Yes. None appears for the parties. Let the matter stand adjourned till May 21, 2025.
This is my appeal. I was thinking, let me do it because otherwise the trial court may not be heard. And this order which I am enjoying today is not really a proper injunction order. So let me do the matter.
Yes, absolutely, Mr. Mithra. You're most welcome.
Well, there's enough to waiting, not you.
Yes.
Both affidavits, the matters being heard before the single judge.
Yes,
I'm
not blaming
That is also one of the urgencies, probably.
And yes, that is
no. There's
yesterday also they didn't appear.
last week, yesterday I was there personally. He was there personally. Matter getting adjourned. Anyway, whatever the reason, irrelevant.
It's a short order, so Mr. Mithra, let us proceed.
May I just tell you, Lordship, what the facts are?
Yes.
Look, there is a development agreement for a property. This is suit for specific performance. The property belongs to a club. Defend numbers 2 and 3.
Yes.
Royal Calcutta Turf Club. 1 and 4 is the erstwhile promoter of the property. Erstwhile developer of the property.
Yes.
So, as per the development agreement, certain sum of money which I am to pay will be used by them for paying off the erstwhile promoter, whose rights have crystallized into an award.
You're a prospective purchaser. You're a prospective purchaser.
Prospective developer.
Oh, you are the developer.
Specific performance of,
yes.
of that agreement.
No, they are the owners.
They are the ones. 2 and 3 are the owners.
2 and 3.
1 and 4 is the developer of the property. While 4 is the erstwhile developer whose rights have crystallized into an award under which they are to get certain sum of money. 40-50 crores. Now, the development agreement, we paid 55 odd crores, which is lying deposit.
Yes.
Now, this 55 odd crores, now there was a condition that this agreement will be further implemented on fulfillment of two conditions. One is that the permission of the Heritage Commission, and number 2 is ULC clearance. Yes, is the urban land ceiling clearance.
Right.
And there is within a certain time span. Correspondingly, there is also a force majeure clause, in terms whereof this, if there's any event which prevents me from getting these permissions, I will have a right to exclude that period. That also, it's a very wide force majeure clause, covering even governmental restrictions.
The time limit for that heritage and urban land clearance is over.
That is over. That got over in the month of February 20.
You had to get the clearances as per the agreement.
Yes. Urban land ceiling is done. Heritage has not happened. There has been extension. One extension granted. Extension has 1 or 2 extensions granted, but thereafter, what happened was, which is our case, the force majeure situation arose. How? The owner of the property, defend numbers 2 and 3, wrote letters to the Heritage Commission saying in writing that Heritage Commission is not functioning.
Pardon?
Is not functioning, and they are not taking any action because of a problem they had faced with the development of the Tripura House property on Baligan Circular. This is followed by a writ petition filed by the owner of the property in the High Court against the Heritage Commission, saying that they are not functioning. And for reasons beyond the control, this is not being processed, the plan. This is, as our case, the force majeure situation, force majeure event, which would exclude this period.
1 and 4 are these subsequent developers. They have gone to them.
No, 1 and 4 are erstwhile developers. Who has to be paid off certain dues. So that's why they've been made parties, so that the money goes to them and their claims are discharged. Now, This happens in the month of December, January. The writ petition is filed. February after February, then this club, which is run by stewards, they say by letter that they will not grant any further extension. But in the month of March, April, there is WhatsApp communication on record to show that there were meetings between the parties and also communication from one of the stewards that we are getting the Heritage Commission cleared, Heritage Commission permission, and once I get the permission, it will be done. In the meeting that was held in the month of May 2024, we find the erstwhile developer involved in the meeting, which made us form the meaningful belief that they were aiding and abetting and tried to procure the breach of contract so that the erstwhile promoter would like to take it over. This being the position, in the month of May, for the first time, these defendant numbers 1 and 2 wants to refund the money to me in the month of May. And in fact, they unilaterally deposited 5 crores out of my 5 crores into my bank account. Immediately, within 2-3 days, we filed this suit for specific performance.
Did you return the money?
5 crores. We immediately offered out of 55 crores, 5 crores, which they returned. Has the 5 crores been returned? 5 crores. No, for 5 crores has not been, but the 50 crores they are holding. We immediately filed the suit. Immediately after getting this 5 crore back, the suit, and we are more than willing to give the money back or deposit. This comparatively small compared to the total value of the.
When did they say no, Mr. Mitra, before the meetings?
They wrote in February, in the month of February.
February 24.
2024.
The writ
Then there
petition
is
was in December, January 23.
23.
Correct.
And March.
Sorry, what happened to the writ petition?
As far as I know, there is a writ petition. Possibly, my junior says, "Ki withdraw kore Kobe.
Withdrawn.
It was withdrawn.
After the suit, after this suit has been filed, they have withdrawn.
No, absolutely not.
When they withdrew?
Wrong.
Before
Not
before
absolutely wrong.
No.
Absolutely, I'll indicate. 50
No.
crores given.
No.
Dates cannot have any absolute.
When was it withdrawn? Before the suit?
I'm telling you, my lord, this ex parte order, my lord, was sought for on June 6, my lord.
We withdraw the question. Please continue.
But because in the writ petition, if at all, has been withdrawn according to us post filing of the suit. After this was shown as the ground for. Now, well, so now, when we filed this suit, the only ground on which now kindly come to the order which was passed by the learned single judge. Refusal, the ground for refusal, kindly come to the second page 376, or the memo of appeal. Yes. Mr. So-and-so, senior counsel, appearing for the plaintiffs, the plaintiffs have already paid about 50 crores to the defendants in terms of the development agreement, rights created under development agreement 14 January 2, the plaintiff is about to be jeopardized and frustrated since pending permission from the competent authority, creation of third-party interest is imminent. In view of urgency as submitted by so-and-so, the interim order, status quo may part. On hearing submission of Mr. So-and-so and perusal of the instant application, along with annexures, it is manifest that the relief is based on the development agreement for construction of multi-storied buildings. There are factual complications involving multi-layered array of facts.
Mr. Mitra, by 6 June 2024 order, it was refused.
Yes.
Ad interim.
Then we came up in appeal. In June itself.
This appeal. No. How can it be? 6 June it was refused. You came up in appeal. That was recorded by the court in this 20th June order. So there was a previous refusal of ad interim.
Oh, bala. After this, there was a returnable date.
Vacation bench you moved.
Yes.
Ad interim refused. You preferred an appeal.
Preferred
Again you moved. for the self-same.
No, but on the returnable date, there was a returnable date of the application. On the returnable date,
You renewed your prayer.
but
You renewed your prayer.
we had asked for adjournment because the appeal was pending. Take out that order. Take out that order. We had asked for adjournment. Take out
If there's a refusal on 6th June, why should the court take a different view on 20th June?
Yes, so we asked for adjournment of the matter because the appeal was pending. Because you kindly
We asked for the adjournment when? You asked for an
On
adjournment,
20th
then
of
that
June.
appeal.
on 20th of June.
You should have moved that appeal instead of this
Well,
fresh prayer for ad interim.
We should have.
Mr. Mitro, you have preferred an appeal. Your ad interim has been refused. At the same stage, at the same level, the
can't be a
principle
fresh
of res
order.
judicata should apply.
Yes.
Both ad interim refused, you again paid for ad interim, although
Yes.
you preferred an appeal against the previous one.
So
Why should the court grant ad interim afresh? I mean, by resigning from its previous position of refusal of ad interim.
So my appeal from the 6th January order remains. 6th June order remains. Appeal from the 6th
That's
June
a different appeal. We are hearing a different appeal.
Well, the 6th June appeal is also here, Mother.
My lord, item
Both are
2
before us.
My lord,
2
item
and
number
3.
2 and 3. Both the appeals.
So I presented the 6th June appeal. I'm not troubling.
6th June order will like to see.
Yes, that is the order, but I'm
Yes,
not
because
troubling
if
my
that
lord with the
stares at your face, then it's difficult to get another fresh
Yes,
order.
the second appeal is really had to be done for the formality.
Yes.
Okay, kindly takes the appeal in appeal number 226. This is the order I'm appealing from.
So you're looking at the 6th June order.
6th June.
Yes, sir.
Kindly come to the second page.
And what is the sort of injunction you asked for?
I asked for really a status quo that no third party rights should be created in the property.
No, what was the prayer in the injunction application?
Injunction application.
देखिए एक बार बाकी application injunction prayer টা দেখো first volume দিলেই হবে আপাতত
Page 40. Page 40 of this volume 1. 43 is of the state petition, page 40 of the state petition. Page.
so basically third party rights
Well,
third party rights and giving effect to
third party.
termination and giving effect to termination
no effect to termination. Or if third party rights are created, well, that is really
that would suffice
that
for
would suffice. That would suffice. Now, Lordship, kindly some of the clauses from the development agreement I would like to show, my lord.
the 6th June order also the learned
That is the order which I have
Single judge,
agreed
yes.
by really. 6th June order.
state that it's
That
manifest
can't
that
be a
the
ground.
relief is based on development agreement for construction factual complications and multi-layered array of that has been repeated probably in the next order this multi-layered thing
Multi-layered. And my junior just now checked up. 14 June the appeal, the petition was withdrawn. 14 June, not before that. So it was. So it is
Not
possible.
served on it.
14th June writ petition was withdrawn
So after the suit was filed.
after suit was filed.
So the submission was.
So you are absolutely right.
I just seen the
Well,
statement.
Don't
my
use absolutely
My
liberal.
instructions are right. Well, this is something I was not there. So the
Anyway, Mr. Mittal,
juniors gave the.
yes. So let us hear you on.
Well, after the appeal was filed. After the appeal. The appeal was moved on 13th of June.
Very.
After service to them.
So there's no writ petition now.
Well, so there's no petition now. So on the date of the suit and date of the
1 and 4 are represented before me.
No.
You're the owners.
2 and 3.
Right.
Now, Lordship kindly comes to the development agreement at page 106.
Yes. Any particular clause which is relevant?
Well, yes.
Any particular?
I will just show the relevant because today they were the identity appeal. After identity,
exactly.
Lordship kindly comes to page 112.
Yes.
Initial approvals. Roman 17.
Right.
Initial approvals shall mean receipt of NOC approval from the Urban Land Sealing Department. That has already been there. In fact, that was there in fact before the agreement.
So this ULC and heritage.
Right.
Yes.
Now, Lordship kindly comes. This will be linked to page 130.
পরে ভলিউমের জন্য রেডি হও
Page 136. Clause 19.2.
19.2 yes
No, yes. In the event the initial approvals are not obtained within a period of 18 months from the effective date, or the owners do not receive the security deposit and annual payments as per the timelines agreement, subject to delays, because the second part has not come, subject to delays, subject to delays attributable to any force majeure event. The owners shall have the right to terminate this agreement. The event of such termination, the owner's developer shall be entitled to the refund of security.
What is force measure
Force
here?
major events is the next page, Lordship. Kindly come to page 111. Page 112 is the force major event. 111 is starts 111. Force major event. I have to briefly go to that's what
So you come under F,
I come under
non-functioning of any existing or new appropriate government authority.
Lordship, kindly. Lordship. Non-functioning of any. And also, my lord, the last one, H, because it's a very wide clause. And now how I am showing force major is a prima facie case of force major can be made out is in the writ petition. Lordship kindly comes to page
In the writ petition,
341. In the writ petition filed by them and the correspondent.
341.
Yes, sir. Possible করতে বল। So kindly comes to the writ petition filed by them, page 332. At 341, paragraphs 31, 32, 31, 32 of the
We'll also take 29 and 30.
29, 30 also. And now, so far as the payments are concerned, Lordship, we have fulfilled our obligation. That is, Lordship will, we have deposited this entire amount, Lordship, page 208. 208. That is, the escrow agreement was made and the money deposited with the escrow. Page 208 is the proof of payment, 55 crores. The serial number 5 in the bank's in the bank's account, and page 183 is the escrow agreement. 183 it starts. At 194. At 194. 4.2. Release to owners. Upon receipt of initial approvals by the developer and receipt of 4.2a, conditional NOC from EPPL, a written notice should be jointly issued by the owners and the developer to the escrow agent, which shall have copy of the aforesaid NOC and intimation of receipt of the aforesaid initial approvals, directing the escrow agent to close the term deposit and transfer the security deposit to the owners and transfer the interest accrued of such term deposit to the developer. The escrow agreement shall be entitled to conclusively rely on the release notice by owners and developers to make payment to the owners without further inquiry. And but there's some negative covenants in the agreement also. That
You
is
made the payment, Mr. Mitru, within 18 months.
we have paid.
There is nothing regarding payment.
No.
Only these clearances.
Only the initial approvals, which has been stuck by the force major. My financial obligation I have discharged. Now, Lordship, so far as this time was extended thereafter, Lordship, the first extension was given. 1 minute, page 300, if I'm not mistaken. Yes, page 300. And reply is page 303. Page 303, Lordship, can take a look.
নেই এটা পরেরটা ভলিউম 3টা দিয়ে দিয়েছো
Page 303 আমার ছিল।
সরি সরি 300 and 303 both are extensions.
303 is the extension.
303,
Our
yes.
request 303 is from Royal Calcutta Turf Club.
Yes.
It is extended up to 11th February 2024. And thereafter, in the intention to renegotiate, that will appear from a few correspondence. I mean, or other words, of course, with the force major, I can say I'm entitled to exclusion. So your refusal to extend is really not right because the force major conditions apply. Now, she kindly comes to page 357. Though they made it without prejudice to our rights, first two paragraphs are riders that we have not agreed to extend. Kindly see the last paragraph.
They have clarified strictly without prejudice and do not accede to your request. We can
However,
discuss
strictly
them at a
without
further.
prejudice to our rights, we can discuss the matter. We can discuss the matter further to evaluate your request. If you do not accede to your request, we shall forthwith refund the advance of 5 crores, and you may also take refund of the escrowed amount.
They withdrew the writ petition on 14th of June 2024.
That's what the order.
2024. And termination took place when?
Termination took place, Lordship. This is in May. Lordship, kindly give me 1 minute. 17th May, page 368.
Which was after this exercise of rethinking.
Rethinking, there's some more correspondence on rethinking. Lordship,
Termination was after this.
after this.
But termination, at the point of time when the termination was effected, the writ petition was still pending. So you may argue that at the point of termination, they had themselves filed a writ petition which was pending, where they pleaded force major, admitted force major.
So that was how my plaint case is made out also. That's how my plaint case is made out. But now, since they're mentioning about the withdrawal is as a
Subsequent.
after they're seeing them. Now the termination is page 368. Is our sorry, madam. It is my mistake. 368 is our letter. It is the termination 371. 370. 371 at 372. Because when we pointed out it was improper for MR to now come and try to sabotage, that is really a procurement of breach. Page 372 is their letter. 16th May 2024. Sent on 17th May 371. And only after we point out that MR is trying to procure breach.
The date is
Date is 17th May because 371 is the email.
yes, 18th May, no, 17th May. This is a trail mail. Very
17th May.
17th.
Second paragraph, in any event and by way of abundant caution, we, in accordance with clause 19.2, do hereby terminate the JDA. Consequently, the power of attorney granted by us in your favor also stands revoked, and in any
Mr.
event,
Mitra, you paid 55 crores, but why do they say we also request you to provide your bank details to enable us to refund the advance of 5 crore?
5 crore because subsequently, I'm not troubling my with all the facts, they wanted additional 5 crore.
No, you had deposited 55 crore. If they terminated the agreement, weren't they to
5
deposit?
crores is a deposit and 55 crores lying with the escrow. 5 crores lying
Oh,
with
it's an
them,
escrow, right.
50 crores lying with the escrow. Right. Initially, we had given entire 55 crores to the escrow at their request, even though the time for withdrawal of the money didn't arise. They requested 5 crores they need.
So now 50 is with them, which they have refunded to you.
5 they have refunded.
Sorry, 5.
5.
And 50 is lying in the escrow state.
Lying with the escrow. Now, apropos this asking us to refund 5 crores.
Yes.
Now, we did not intimate them the bank details.
They
But at
refunded.
page 373, they have written to us, since we did not encash the check or not received the requisite bank details up to the mentioned time, we herewith enclose check number so and so for 5 crore.
Check has not been encashed.
No, not encashed. And then they knew our bank details also at page 375. On 3rd June, or should we see the first two entries, 375. In my bank, they deposited rupees 4 crores.
375 is something.
377 it.
Of the stay petition.
Or 377 possibly in the state petition bank statement. 377 it.
Yes.
377. The 3rd of June,
So
the first.
since you did not encash that check, they put it in your bank account.
Yes. They said they don't know my bank account. Give me your bank account details. I said I will not give
did not.
basically. And then they had the details also.
Which entry, Mr.
The
Mitra?
first two entries. 4 crores
Alright,
and 1
alright.
crore. 03 June 2024 transaction date. Then we filed the suit on 6th of June. Immediately thereafter. So this was the this is the factual scenario. E368 কি আছে? And our case is also that MR defendant numbers 1 and 4 are trying to procure the breach. There was then the meeting which we had in the month of May. MR was also present. Lordship, that Lordship can find that is their correspondence. In fact, they only offered to hold a meeting that was in the month of April. Kindly come to page 360. 365. The subsequent correspondence with Chandrakant Kankaria, 366. 366. This is Chandrakant Kankaria, one of the stewards, met the commissioner accidentally in the middle, had a chat, said matters sorted out. Then next page, TK MR has confirmed for 22nd at 2 p.m. for the face-to-face meeting.
Did he have the authority to act on behalf of the defendant numbers 23?
Then the meeting, here was a steward, and the meeting in fact took place. Lordship will kindly find that meeting in fact took place, which they have admitted at page 372. First panel. On 15th May, there was
Other stewards apart from Chandrakant in that meeting.
Mr. Sarkar was also there.
Apart from him, others.
All the, I mean, this was this is in the official letterhead.
Official.
This is 372. With
Very-
reference, we refer to our letter of 26th February by which we informed you that we are not able to obtain the initial approvals within the extended date of February, and we are not agreeable to grant any further extension. And subsequent discussion, the virtual meeting held on 15th May. In the meeting, we had reiterated that we are not agreeable to grant any further extension. This is the official meeting.
But even after the extensions, you failed to obtain the clearances.
But after because even today they have not got it. So
You have to obtain.
I am to obtain, but because of force major situation, writ petition filed by them. We can't file it, and there's correspondence before that, before the writ petition. Lord, you kindly sees this. I skipped it just now, but then there is correspondence. Kindly see that the letter at page 358. After writ petition is filed, the matter becomes not 358. Where is that letter? We had pointed out that this.
Mr. Mitra, let us get the timelines straight.
Very well.
Now, this you said that before this renegotiation, there was a previous refusal by them.
Yes,
sort of-
refusal is on the
What is that?
303. We will not grant extension beyond that date.
That was stated in the last extension.
That is in February.
That is in 357. This was what we said. We will not grant any further extension. 357. Not grant any further extension. Termination happened in May. 357 on 27th February.
So that says we extended. We extended.
We
That's the
extended
refusal.
till 11th of February by letter. The extended period has also expired, but you have not been able to obtain initial approvals. In this connection, we also refer to discussion on 9th February when you requested for further extension. Kindly note, we are not prepared to extend the time any further. So that was the refusal of extension. 11th of February, or 27th February.
And these negotiations were
Negotiations happened in the month of March, April, and in 15th of May, there was a formal meeting, which is recorded in the defendant's letter at page 372 on 15th of May.
So the issue is still open,
Still open.
according to you.
16th May, they write to us saying that give us your bank account details. We will refund you the 5 crores of the barcode.
Very. So
Now-
you are virtually banking on two things. One is that force majeure clause, their admission in the writ petition regarding force majeure clause, as well as this subsequent renegotiations.
Yes,
And all.
and also, Mala, I did trouble Mala just now, but then there are several correspondence by the Turf Club with the Heritage Commission asking for that you're not functioning, etc. Page 287 onwards, 287, 289, 291, all that is there, ultimately encapsulated in the writ petition.
These are even after the termination.
No, before. These culminated in the writ petition that was filed on 9th of January 24.
Let us see at least one.
Page
287.
287.
287.
The third paragraph is very self-explanatory.
Hmm.
A forced recommendation Heritage Conservation Committee was put up for acceptance by the Mayor and Council 4th August when the entire matter was considered, discussed by the Mayor and Council. The Council in principle found the recommendation Heritage Commission acceptable on the basis of fact. However, it was decided that for the sake of prudence, legal opinion.
At page 288, they say utter shock and surprise came to know due to Tripura House. This was held.
That is the Tripura, and that is the reason given in the writ
Tripura House is unconnected with this.
the Heritage Conservation Committee's quorum was an issue in a writ petition challenging the development in Tripura House by certain adjoining property owners.
What connection does that have with your thing?
The factual connection as it would appear from the writ petition case also, after the single judge of the Calcutta High Court said that the quorum was not there and the Heritage Conservation Committee was not functioning properly and cancelled the heritage permission for Tripura House, they had tried their luck in appeal. The appeal was filed by the state government and also by the developer.
No, the Tripura House being under the aegis of the Heritage Commission, that was cancelled.
Yes, on the Heritage Conservation Committee's
Quorum.
quorum.
Quorum
This is my general knowledge,
Yes.
and the writ petition also bears out this fact.
Very.
So they were at a standstill; they were not giving permission to anybody, and that is also what you will find again thereafter. 3rd May, 24th May. It goes on till the writ petition is filed, and writ petition they have said that in so many words. At page, kindly give me 1 minute. At page, they have said so. Tripura House matter, page 30. Yes, page 341, paragraph 32. Oh, Tripura House matter in the writ petition. So the Heritage Conservation Committee in principle approved.
All right. So very well. Let us hear them, Mr. Mitra. Yes.
My lord, I'm led by Mr. Mukherjee. My lord, may I come back next week, my lord?
In the meantime, if you create a third party interest,
No. He's preserved, protected according to him by an order. That order continues according to him.
which order?
But there's an order of
In the appeal court?
Yes.
Previous appeal?
Yes.
I said that is not adequate. That's why I moved.
It's not adequate.
What is that order?
That is hope and trust.
Nothing's happened in Hope and Trust till the date.
Let
Because
this-
it's been
let-
pending for a year.
Open trust of which
And they
bench?
have certain
Of
adjournments.
the bench presided Justice Mukherjee.
And
But
that
may not be my lord's hope and trust. If it is recorded also that nothing has happened, then not you can record that.
I'll just indicate why this is now happening. There's an Order 7 rule 11 pending with regards to, my lord, the maintainability of the suit.
Commercial Act.
Yes,
the Commercial
commercial,
Courts Act.
non-commercial. The appeal itself would become non-maintainable if it is found that the suit is not maintainable in the regular course. 1. 2, my lord, the appeal has been pending, my lord, since May 2024. Sorry, I'm wrong. Since September 24. 13th May, the appeal was filed.
How can we have? Move
No, I'm sorry, June
June,
2024, the appeal was filed.
13 June.
With regards to the withdrawal of the writ petition,
This
and-
appeal. This
yes,
appeal.
this appeal. It's been adjourned from time to time on the ground that he's going to press his application and my application is pending. Now today,
This has been classified as a non-commercial suit.
this is a non-commercial suit according to him.
Because this
According
came
to
under
him.
clause 7 on the date of the agreement. This was the club. This was not commercial purpose. This was all open ground. This HON'BLE Sarabhai. That's why we had to file it.
So, my lord, from 7th May 24, this is being adjourned.
So you save your breath. Then let us wait for the next.
Yes, please.
Mr. Mitra will keep it. Heard in part. Heard learned senior counsel appearing for the appellants. Pushed up. On the prayer of learned counsel appearing for the defendant stroke respondent numbers 2 and 3, Mr.
2 and 3.
Ghosh. 2 and 3, comma. The matter is adjourned for further hearing till May 21, 2025.
Great.
Thank you. Heard in part বললাম প্রথমে? Oh, না, ও আচ্ছা। পাঠারি থাকে
This is a-
cannot get rid of this matter without
this is
hearing.
a sign of pride. We
The
want to
only
do it.
way out is through.
Yes, my lord. I want to do it before you, lord.
No, no. No, we were speaking about ourselves.
Which
Yeah.
that is even without assigning in future, they will be assigned. So Birla.
Yes, we are opening up. We have decided to go slow in appeals now. Call on next one. You're opposed by Mr. Mitra.
Well, first thing I hear from the other side, Parjari car.
This is a perjury application.
I don't know.
A submission was made before the ballot, single bench that the appeal would be withdrawn. So I was
Well, it's my own personal Parjari
I was asking my junior perjury by whom? By the client or by
council. Well,
seriously, Prashput?
Uh-huh.
What's it?
Well, I will point out what if this I need to explain, Malat. On that day, Malat, the single bench was hearing out the matter. Malat, I am in urgency of some kind of interim protection. Now, suddenly the single judge found that he was, Malat, he could not take up the matter for his personal reasons, Malat.
28th March 2025 order.
Yes, Malat.
What has been decided here?
Yes, Malat. This is only
Not
Malat.
even a judgment under the latest
Malat,
matter.
I do understand, but Malat, I had prayed for an interim order, which was not provided, Malat.
This is not an appealable. This is not a judgment under the latest patent. This is not appealable.
Malat, your
What
lordship,
is this? I mean,
Malat will kindly appreciate.
all your
Malat.
names have been recorded. That's a good thing about it. Your names only, not their name.
Malat, it's neither here nor there, Malat, because Malat,
Count of bias, we can set aside this out. Because your
Well,
names
set
have only
aside,
been
well,
recorded.
it was
All
very-
your names have been recorded. No, defendant number.
Malat, may I just give a short background? Then your lordship will appreciate whether it's applicable or not, Malat. Just let me, Malat.
Give the background.
Malat, very short, in 5 minutes, Malat. Malat, this is with regard to Malat, will of late Nandalal Todi. Malat, the executor is one Neeraj Bajoria, Malat, who is the executor. Malat, Malat, this will was supposed to be probated, Malat. Now it has been made a contentious cause, Malat. My learned friends are on one
You
side.
applied for probate.
I applied. I'm the
Executor.
executor. I'm the executor. Malat, your lordship will kindly appreciate there are two other parties, Malat. One is my Mr. Mitra is Malat appearing for, and Malat another Mr. Oh, Shonak, he is appearing, Malat. Now, Malat, Malat, that is what I'm on, Malat. Malat, support or not so support, Malat, it would be evident from the affidavit, Malat, in support of the caveat. Obviously, Malat, he has also filed an affidavit in support of the caveat challenging my Malat, this will and the execution of the probate. So, Malat, he's also not supporting. Now, what is happening, Malat? Late Nandal Todi had lots of properties, Malat. Now, according to the affidavit of assets which we have filed, Malat, there were certain properties, including one at Beleghata. Now, Malat, the Beleghata property was jointly owned by one Akshay Vinmay Limited. which under a memorandum of settlement between all three parties were to be jointly owned by the three parties. That memorandum divided several properties, but there was a specific annexure which said that this property, 50% of which is owned by Akshay Vinmay, will be owned in proportional shares of 50, 25, 25. Now, this property is being developed. Now, while we were looking into this matter, because we were trying to expedite the matter, we suddenly found that the defendant, respondent number 2, also moved an application for an injunction on all parties in respect of dealing with the property, in respect of another property, which is at Shodhpur.
That injunction was filed in connection with what? This probate?
This, yes, this probate application, not filed by the executor, by one of the challenging caveators. He has filed and he has got an injunction on the same memorandum of settlement. I am not on that.
What interim order did you want?
Yes, I wanted obviously, because today, since it has become a contentious cause, I first made this application that appoints me as the administrator pendentility. Until that time, until the disposal, all properties, there should be a status quo. I will also not deal with them. No one will deal with them.
What happened on 4th April?
That is what I am saying, when I moved the application, I wanted ex parte interim order, Now, what happened, the other side came up and said, I cannot do the matter today, and if required, I'll file my opposition within 3 days.
But this is somewhere in the middle. I mean, this is not the first refusal of an interim order.
No.
This is not the last.
This is the last. This is the last, I'll
4th
point.
April happened in between.
I will just, after that, obviously, just give me 1 minute more. I'm nearly there.
Not a question of minutes.
I'm nearly there, Now, what happens, within 3 days, the opposition is filed. I try and file my reply, also file it. But the problem was the change of determination. There, your lordship will find, therefore I said that, there is someone who's not yet filed their opposition, kindly pass an interim order. He waited, his lordship waited, obviously thinking that he will deal with the matter. But, he refused the interim order on that ground, that let the affidavit be complete. And that was the understanding. And therefore, I pressed for it and then waited for it. Now the situation is, your lordship will kindly appreciate. Today I am without any interim order. I have been able to show, and as a matter of fact, they have filed their affidavit where they have said that this Akshay Vinmay is the joint owner. They are now trying to create another document from which they are saying that Nandalal Todi had given up his rights also in Akshay Vinmay. Now, this itself becomes a disputed question. I understand, it's regard to the title of the property, but I am supported by judges. It says that even till the disposal of the probate application, the disposal or any of these assets of the testator should not be dealt with.
In favor of third party.
Yes, or else it will create third party interest.
That maybe you have a point there, Mr. Rai, but this is somewhere in between, as you say. GA in
GA3,
GA3 initially you paid for an interim order. So the refusal was on the first instance. Deemed refusal was on the first
Deemed
instance.
refusal, yes,
First
on the
instance.
next day also I asked for the interim order because the affidavit
That's
was not
reflected,
complete.
nothing is there. Go
But
back
I
to
have made my statements in the petition, but to that extent, if your lordship now,
There's an exit fixed before the Leonard Singh.
now there's another problem. But the single judge has now released the matter.
Why release? What did you do?
But I did not do anything. The single judge had such good practice when it had appeared in this matter earlier, in respect of Todi's.
We must have one of us at least must have appeared in the matter.
And then, it
Now
becomes
we think
again pillar of the matter, trying to find out 5 or 6.
Please don't remember.
First, when we get a
No,
pillar
all
of the,
similar names are being now assigned to us.
I know,
All names in that
your lordship has
package
been now
are
found.
assigned to this.
The
court.
lordship has been found,
what?
tested, and stamped. That Birla.
Yes, I agree. But
But
here
initially-
we don't have. This is not a judge.
Can I just?
Can you do what? We have not gone into the merits of the matter.
No, I know, I know.
We will
Obviously,
say that.
if it's
Whenever we say needless to say, it means, I mean, that it needs to be said.
may I
Like
get-
it's just like with utmost respect.
with utmost respect, may I make a submission?
No,
Without respect,
without the respect, yes. Please,
I always-
utmost respect always precedes some abuse. In
I don't know,
whatever
my lord,
form.
the abuse, it is abuse, my lord.
Yes,
What
what
I'm asking for, my lord.
process of
Yeah.
court.
Sorry, my lord.
Yes, what do you want?
I only want, my lord, if your lordship is not, obviously not
You cannot
inclined.
request the learned single just to expedite it. No. That is demeaning.
Some precedence, my lord, because, my lord, on kindly sees the sequence of the orders, my lord.
It is
was-
before some judge.
It has not yet been, my lord, assigned, my lord.
Then we have to direct the Chief Justice to assign it quickly.
No, no, my lord,
So
that is not.
yeah, we are looking at something which it's
But can you
beyond
give
our
me the
powers.
liberty to at least, my lord, mention
What?
for
Tell us. What?
liberty to.
How shall we couch that order?
That's what I'm trying to find out. My lord.
Write the order, we'll sign it.
That's not kindly does not take me. I mean, my lord.
Let us just tell us, Mr. Right?
That
How
we'll
shall
have
we
the-
put the request?
We'll have the
Requesting the
liberty.
Chief Justice to assign it quickly.
No.
And after that, the judge to take up the matter and
Assign হয়ে গেছে? Assign হয়ে গেছে বলছি তো।
has been assigned.
কি অবস্থা আমার পিটিশন ও বলছে মানে then my lord, it becomes easier, my lord.
What is it?
Then my lord, the learned
But depending on which bench it has been, the pressure of the bench. all
They
these things.
don't know it has been
some
assigned,
kind of
mentioned before
interim
the
protection,
court.
my lord, some kind of protection. My lord, orders, my lord, I'm a complete.
mention করবে।
No, sorry.
Then my lord kindly gives me some kind of liberty to, my lord, mention and get the matter.
We are giving you protection from perjury, as Mr. Mitra was saying. Perjury for the land single judge. The present appeal has been preferred against an order dated March 28, 2025, passed in a testamentary proceeding. Full stop. The appellant, having filed a probate application, the same turned contentious. Full stop. Vide GA3 of 2025, the appellant sought injunction, both temporary and ad interim. Full stop. Upon hearing learned senior counsel appearing for the appellant, upon hearing learned senior counsel appearing for the parties, we find that the impugned order is somewhere in between, in the sense that GA3 of 2025 had already been moved previously and no ad interim order was granted. Full stop. In the impugned order dated March 28, 2025, the learned single judge merely recorded the filing of affidavits and kept the matter for hearing on April 4, 2025. Full stop. Next para, as such, by the impugned order, as such, the impugned order could not be said to be the first occasion when there was a deemed refusal of the ad interim prayer made in GA3 of 2025. Full stop. Next para. We are informed that the learned single judge who passed the order impugned herein subsequently released the matter,
No.
My lord, determination change.
subsequently
new judge will release.
lost determination in the matter, and as such, the application bearing GA3 of 2025 could not be heard. Full stop. Next para. Learned senior counsel appearing for the appellant presses for an interim order protecting the appellant in terms of the prayers made in GA3 of 2025 before the learned single judge. Full stop. Next para. However, on a careful perusal of the impugned order, we find that no rights of either of the parties has been decided by the said order, nor can the same be said to be a within double inverted judgment within the contemplation of the latest patent, to justify an appeal against the same. Full stop. Hence, the present appeal is not maintainable, in view of the impugned order not qualifying as a judgment where the rights and contentions of the parties, even tangentially, were decided in any manner. Full stop. Next para. Accordingly, APOT 110 of 2025 is dismissed on contest. Any connected application is there?
GA1.
Consequentially, GA1 of 2025 stands disposed of as well. Full stop.
Not gone into the merits, my lord, your lordship.
It is made clear that the merits of the contentions of the parties have not been gone into by this court, as will be evident from our above observations, and it will be open to the suit court to decide all issues independently in accordance with law, without being prejudiced by any of the observations made.
And affidavit service.
প্রথম লাইনে একদম করে দেবেন, affidavit of service filed to be kept on record. First line, before everything.
And Malad will kindly clarify Malad the assigned code, because I'm not sure whether the suit has been assigned. It's only the
No,
application.
we need not clarify that.
No, because
Wherever
the
it
Lordship
is,
said the suit code
It is a different code.
it's a different code.
wherever it is, that is a suit code.
Malad, if it's assigned, generally Malad, the suit doesn't go together, Malad. So that
Suit court একটা কথা ইউজ করেছি, suit court. দেখুন, খুঁজুন, দেখুন, last suit court.
বললো তো
It will be open to the learned single judge taking up the suit. Happy? Suit court এর বদলে, suit court এর বদলে, হ্যাঁ, the learned single judge taking up the suit.
করে তাকিয়ে থাকিস না,
আমার
এটা
একদিন
on the
ছিল।
spot ছিল।
হয়ে গেছে? কোনো পাসওয়ার্ড কিছু ছিল না? হ্যাঁ, তাহলে এবার অ্যাপেল আছে।
ও জল দিয়ে
এই বলছি এটা না আপনাদের original side এমডি সাইড হলে জাজমেন্ট ফরম্যাট আলাদা আছে, অর্ডার ফরম্যাট আলাদা আছে, অ্যাপেল সাইডে মানে ফাইনাল জাজমেন্ট যদি একটা অ্যাপিল হয় সেটা কি জাজমেন্ট ফরম্যাট আলাদা? অ্যাপেল সাইডও আলাদা হয়, তাহলে এটা জাজমেন্ট ফরম্যাটে করবেন, কারণ অ্যাপিলটা বুঝতে পারলেন? মেনশনিং আজকে জিজ্ঞেস করুন।
In the appellate side, my lord, item 47 of my lord's raised. Now, there's serious urgency in the matter, my lord. I wouldn't have normally prayed for upgradation, my lord, but there's
47?
serious. Item 47, my lord. Here, my lord, the injunction that has been impugned, my lord. It's an ex parte injunction, my lord, staying my entire auction process till June 2025. My lord, there's serious urgency in the matter, my lord.
We cannot reach it before, is there any 330, Mr. Rai?
My lord, I am led by Mr. S.N. Mukherjee in this matter, my lord. He's on his ground, my lord, praying for any day up to your lordship's
My lord,
convenience
will
next week,
kindly,
my lord.
because
Today
it's
he's
been running in the list, my lord. I'm not saying anything else, my lord. There's serious urgency in the matter. It's an ex parte injunction
Kindly do not
obtained
take
by
it
the
out of turn,
respondent.
my lord. If it reaches in the
My lord,
ordinary
will
course, we
kindly
will be
appreciate
here
the
to address
urgency
your
of the
lordship.
matter. My lord, a third party outsider has
Mr.
come
Sai,
forward.
there's an extreme
I am
urgency.
not a third party outsider. I am a prospective
third-
bidder in a
He's not even bid. He's
No,
not
we'll
even
hear
filed a bid.
when we
My
hear that, we'll consider
Yes,
that. But if it is not reached before, he is not there. Mr. Mukherjee is not there at all in
my
court.
lord, my instruction
my
is
learned
in
friend
some
is here,
difficulty
my lord.
today, my lord.
My lord, my learned friend is here, my lord. My lord, will kindly
No,
give
I
us some.
If it is not taken up before 330, just mention at 330. Will
deep
or at 4.
oblige, my lord.
4.
We'll do so.
Come back at 4. Sir, you want to mention something?
An application, one of the
Yes, application as a matter of course.
application.
Accordingly, FF4 of 2019 and FF5 of 2019 are allowed, thereby setting aside the impugned judgment and decree dated September 18, 2018, passed by the learned judge, second bench, City Civil Court at Calcutta, entitled suit number 1244 of 2011, whereby the plaintiff appellant's suit was dismissed and the respondent's counterclaim was allowed. Consequentially, we decree the said suit in favor of the plaintiff appellant, declaring that the plaintiff appellant is a bona fide tenant in respect of the demarcated and separated suit property comprised of 4 car parking spaces. A decree of permanent injunction is also granted, restraining the defendant's respondents and their associates from disturbing the peaceful possession and enjoyment of the plaintiff appellant in respect of the said property in any manner whatsoever. Second. The decree passed in the counterclaim of the respondents granting eviction against the appellant is also set aside, no redress to cost. A formal decree be drawn up accordingly. Interim applications accordingly disposed of consequentially.
Deeply obliged. Deeply.
What?
And I am for the respondent.
Yes. Accordingly, FAT 230 of 2021 is dismissed on contest, thereby affirming the judgment and decree dated such and such. There will be no redress to cost. Formal decree be drawn up. Consequentially, can 2 is disposed of in the light of the above.
for the appellant.
Accordingly, FA number 359 of 2025 and FA number 360 of 2025 are allowed on contest, thereby setting aside the orders dated January 22 passed by the Learned Civil Judge Senior Division, such and such, in title suit number 1199 of 2024 and title suit number 1200 respectively, made clear that the above findings are all tentative in nature and shall not be considered to be binding by the Learned Trial Judge while deciding the respective suits. No orders to cost. Cans are also disposed of accordingly.
Grateful, my lord, deeply obliged.
Pray for a stay of operation of the order. I was enjoying an order of injunction. Well, I leave it to your lordship.
Stay of operation of this
That
judgment.
would revive the order of injunction.
আচ্ছা এটা একটা লেটার পাঠ করে দাও after the above judgment is passed comma learned counsel appearing for the respondents seeks praise for a stay of operation of the above judgment full stop. However comma we are of the opinion that in the event such stay is granted comma the injunction order would revive comma thereby having the effect of nullifying the above judgment. Full stop. Accordingly we refuse such prayer for stay.
I'm
Grateful, my lord, deeply obliged.
ও সরি এটা সইটা করে দিন কিন্তু এটা সই করে লাভ নেই এটা আমরা পরে সই করবো আবার এখন লেটার তন্ময় এটা লেটারটা ঢুকিয়ে দিয়ে দেবো yes please.
My lord, I am appearing on behalf of the appellant. Only one word has been typographically missed.
What is that?
First line, my lord. The present appeal has been preferred by the defendant.
Oh yes.
Others, everything is right. 43 paragraphs order, everything is right. Only these words.
Could it be defendants in
Yes.
plural?
Yes, my lord.
Defendants.
Defendants.
Right. Thank you.
I'm grateful.
You are for the appellants.
I am for the appellant.
Learned counsel for the appellants rightly points out that in the judgment dated April 23, 2025, comma, in the very first line, comma, instead of double inverted defendants, double inverted clause, comma, the word double inverted plaintiff was transcribed. Full stop. Accordingly, the judgment dated April 23, 2025 be deemed to stand corrected to the effect that instead of double inverted plaintiff in the very first line thereof, comma, it will be read as double inverted defendants.
I'm grateful.
Thank you. ওটা লাইনটা দিয়ে দিও this order be deemed to be a part of the judgment.
Well, I am for the appellant, your lordship. Lordship, there is a can application of file, my lord. Well, basically application for withdrawal of this appeal, your lordship. It has been filed wrongly, your lordship. I'm praying for a leave, your lordship. To
Wrongly means but
well,
jurisdiction.
it's supposed to file before the CO bench, I mean civil revision, my lord. It's wrongly filed in the appeal. Court, your lordship. And my lord, I'm praying for leave.
What have you challenged here?
My lord, the order dated, lordship, 5th December 2023, your lordship.
Oh, stay application was
Yes,
this one.
yes, your lordship.
Learned counsel appearing for the appellant submits. There's an application for that withdrawal.
Well, we have filed an application, my lord.
Can one.
Can one, your
Very
lordship.
Learned counsel appearing for the appellant stroke petitioner submits that the present appeal has been wrongly preferred instead of a revisional application stroke application under Article 227 of the Constitution of India, comma, since the impugned order is not an appealable one. Full stop. After detection of the same, comma, the present application has been filed for withdrawal of the appeal. Full stop. Next para. Accordingly, can 1 of 2025 is allowed, comma, thereby dismissing FAT number 10 of 2025 as not pressed with liberty to the appellant to prefer an appropriate challenge against the order impugned herein. Full stop. Leave is granted to the learned advocate on record for the appellant to take back the certified copy of the impugned order upon furnishing a photocopy of the same for the records. Full stop. It is made clear that the merits of the matter have not been gone into by this court. No rest to cost.
Grateful, my lord.
What about the removal of defects?
What defect?
Your Lordship, I appear for the appellant. I am led by my senior counsel, Ms. Devjani Sengupta. She is engaged in another court. Kindly
Why is it
grant-
appearing as to be mentioned?
Lordship, we had mentioned in under Order 41, Rule 11. But
Mentioning slipটা কোথায় দেখি? FA file. Oh, you mentioned under order 41, but it is not required to be admitted. Yes. Is there any connected application? কোনো connected? দিতেন তো। Yes, you mentioned it initially under order 41. It's not required to be heard under order 41. First appeals are deemed to be admitted by the registrar. If you
yes,
file an application that will be listed, we'll direct it to go out of the list and we'll record that no order 41 is, no hearing is required.
Your Lordship, if I may,
No,
if
no,
my senior
no,
counsel is
we won't keep it pending. In to be mentioned matter, you cannot pay for time. Not done.
okay.
The present first appeal was initially mentioned for inclusion in the list for hearing under Order 41, Rule 11 of the Code of Civil Procedure. Full stop. However, comma, as per the established practice of our court, comma, the registrar is deemed to, the concerned registrar is deemed to admit the appeal. Full stop. Next para. No separate hearing under Order 41, Rule 11 of the Code of Civil Procedure is, comma, as such, comma, required for a regular first appeal. Full stop. Accordingly, let the matter go out of the list. Full stop. The will direct you to take steps. There is no connected application.
No, Your Lordship, there was some deficit court fees and Taliban was.
You have cured that? No, not yet.
Yes, Your Lordship, the deficit court fees has been paid as per the last order.
Let us just check. There are several other defects. No application for addition of party legal heirs of defendant number 4 have been added. So we'll direct you generally to cure the defects. The learned advocate on record for the appellant shall cure the defects as pointed out in the revised report dated report of the stamp reporter dated November 16, 2024 at the earliest. Carry out the necessary.
Grateful, Your Lordship.
Thank you very much. Next.
In this matter, I am appearing on behalf of the appellant now.
Appellant
So the appellant husband.
is the respondent's application.
No, respondent's application.
Yes. What is the application for?
Not application for maintenance.
Maintenance.
The appeal is of 2008.
This is the longest report of the department.
Yes.
Gas can
Some documents are required to be submitted to the department. We have submitted the same.
gas connection. Some of the exhibits were taken out.
Yes, that is taken. We are as well. Lord Citizen, we have deposited the same.
You have deposited.
Deposited.
At the outset, comma, learned counsel for the respondent submits that the exhibits which had been taken back by the respondent wife have been redeposited. Post of the office shall furnish a revised report in that regard within a fortnight from date. Move the matter.
If this similar thing is correct, direction be given to file paper book.
What is the application for? Appropriate order means early hearing.
No, application for early hearing. No, it is for maintenance.
The application
We are not getting maintenance.
Maintenance pending delay for new.
Let them move their application.
Can I please submit one thing? The appellant husband is.
You take the microphone. Take the mic.
The appellant husband is severely ill. So, my lord, I am will be undergone cardiac bypass on 24th May.
Why didn't he pay this alimony till now, before the cardiac arrest?
My lord, there was no order. There was no order for paying of.
Let them move the application.
No,
No, let them move the application. Their application, they have to move first. Please take your seat.
In the shoot,
Yes,
my lord, in the shoot, my lord, matter was filed by my lord. By the
Why have you captioned it as an application for appropriate order?
Application, my lord, I, my lord, filed it, my lord, for my lord, expeditious hearing as well as my lord for maintenance. For such, my lord, view of the matter.
Do not go together.
Lord, your lordship, my lord,
If they don't pay maintenance, their appeal
your lord has
will be
my lord,
dismissed.
my lord, admit the application as my lord, maintenance, my lord. By order, my lord, order detail, my lord.
You have filed your affidavit of assets.
Yeah, I have filed. They have, my lord, given opposition to the same composite opposition.
What is this affidavit in compliance of our order?
That is, my lord,
That is the affidavit of asset.
affidavit of assets.
বাবু এই সুতো ফুতো খুলে দিন, এই সুতো ফুতো গুলো খুলে দিন, এই সুতো খুলতে খুলতে সারা জীবন কেটে যাবে, এটা আলাদা করে দিন।
The mat suit was filed in 19.
না পারলে কাঁচি দিয়ে কেটে দিন, পরে আবার বের করুন। আপনার সুতো খুলতে হবে?
না, খোলা আছে।
Yes, affidavit of assets and liabilities, this is by whom? Monidipa Paula is your side,
No, my lord.
your side.
I have also filed Ardhendu Nag, the advance record. Filed.
Let us sort out these things first. What is this further affidavit in opposition by you? Another affidavit in opposition? Ardhendu Nag?
Ardhendu Nag, my lord, opposition. Or not
You
for the
could not have filed opposition to your own application.
no opposition.
এটা দিন ওনাকে একবার।
Opposition.
What is this?
The reply, that should be reply, my lord.
Reply is there already with us. Reply is a different document. Must be the opposition to their affidavit of asset.
That is my lord, opposition to the affidavit of assets.
Their affidavit of assets.
Assets,
Correct. Yes, move on.
My lord, the mat suit was filed in 1999, my lord, by the husband with the trial court for dissolution of marriage on cruelty ground. My lord, this suit has been, my lord, dismissed. In the during pendency of the suit, my lord, I was granted, my lord, maintenance by the learned trial court. And
How
before,
much?
my lord, firstly, my lord, I was given, my lord, 3,000.
What was the last amount?
Last amount was, my lord, 4,500, which has been, my lord, modified by the honorable court.
By
It was-
this,
by the honorable court. It was given 6,000 by the learned trial court. The honorable justice, my lord, Tapan Kumar Datta, as lordship then was, his lordship was pleased to, my lord, modify the same and
6,000 was made 4,500 by this.
4,500, my lord. Considering, my lord, the submission of the my lord appellant, my lord.
The last rate was 4,500.
500.
There is no issue of the marriage.
Only, my lord, one son is there. Lord, he is now aged of 28 years.
Correct.
Lord.
So when was the decree passed? The dismissal?
My lord, 23rd of December 2009. Again, the same. This appeal has been referred.
So this is a 2010 appeal.
No, 2010 appeal.
Till now, you did not file any alimony application.
Lord, I have filed, my lord. I was impression that the maintenance, my lord, passed by the learned trial court is the continuation of the suit and appeal is, as the application filed, the lord, as the application filed with the husband, that I will get the maintenance as was fixed by the learned trial court.
But that wrong notion was not dispelled over these 15 years.
I filed execution case with the learned trial court. Lord, I was granted, my lord, lord, payment by the learned court. My lord, they have paid the same, something they have paid the same till 2018.
Till 2018?
18. May 2008.
That is an extra payment.
Lord,
the order was not enforced. Interim
Lord,
alimony pendentility could not.
They have also filed application before the trial court that I have paid inherently, let it be taken back. But this appeal has been dismissed it has been rejected by the learned trial court. They have not preferred any appeal. They have not
preferred revision.
They have not challenged the.
We can draft the revision for you.
They have not challenged the similar. That has been rejected by the learned trial court.
Anyway, let us forget that. You are entitled to alimony at best from the date of this application now.
My lord.
But you have to, very well. That is your explanation why you did not apply in the meantime. So yes, what is their income? What would you do?
Lord, my income at least 3,000 because my lord, I have got my lord 3 lakhs by my mother.
You have got
3 lakhs by my mother, which I have not kept as my lord fixed deposit. And
3 lakhs. 3 lakhs.
3 lakhs. I am getting
What's the monthly interest from that?
2000.
And what about the other 1000?
And 1000 lot Lokhi Bhandar. That is 1000. This is the only income of my lot of my
Lokhi Bhandar is a government scheme.
government scheme. I have stated in lot in my equity assets.
Otherwise, you are unemployed.
But unemployed.
Very good.
But he has alleged that I am a beautician. But there is no beautician. I have no such degree, no such. I have not.
Have they produced anything in support of that?
No, they have not. They have only stated that I am beautician. I am earning by the same. But that is because not even single thing I have earned. I have no such profession. I have not engaged in such profession. But they have taken that plea.
What does the husband do?
Husband is learned advocate of the city civil court. He's also sometimes he's coming to the honorable court also. Lord Patley, he is saying that as the wife Lord went to his chamber and he got he get defamed by that situation, and so in view of this he has left the profession. This is the argument.
He has left the
profession. Being defamed by the wife, he has left the profession. Now he is undergone some medical treatment. That's another thing. But he has paternal property in the Belghoria.
Paternal property we cannot look into it in the alimony pending.
No. I am not.
Assets we cannot look into. Current income we can.
Another assets I have submitted that I have got paternal. My father died. I have got paternal property in Puro Badwan.
Do you have any income from that?
No income. That is the
assets will be considered only at the permanent alimony.
That is the ancestral property. This is the landed property. The undivided property.
We are not interested. Neither in your asset, not in his asset.
I have disclosed.
So let us hear them then.
My lord.
Please take your seat.
Yes.
My lord. Your client is about to undergo a cardiac surgery. When?
On 24th May.
What is your income? Income tax returns you have filed, annexed?
No, my lord. At present, he is totally.
Under Rajneesh versus Neha, you have to file the income tax returns for the last 3 years. What about the last 2 years? Since when did your income stop?
My lord,
what is your age?
I am near about 70 years.
Near about 70 years? No resolution is possible in this matter. What is your age? You must be something.
57.
57.
May I stand correct? My current age is 65 years.
So current age it is reducing. No. Current age 65, previously it was.
No. My current age is 65.
65 is we can still relate.
Yes, my lord.
65 years you are a practicing advocate. You have stopped practice. Why? This is not credible.
In 2012, after passing of the decree, the respondent wife, one of a sudden came to the Bar Association room of Honorable City Civil Court and make a rucksack. Diminish my every.
Rakas.
Diminish my every
dignity.
And dignity.
You left practice. What are you eating? I mean, how are you earning?
I am living under supervision of my other family members.
Not credible. She created a ruckus in your own bar association, and your own bar association people were so antagonistic to you. For that only, a lady comes and makes allegations that you leave practice altogether, not go to any other court, doing nothing, sitting at your home, depending on your relatives. Sorry, not credible.
But my lord, it is totally shattered my career as well as my respect before my colleagues.
Your wife creating a ruckus on a single occasion at your bar association may have an impact on you. Maybe traumatic also. But that will last only for days. Nobody remembers.
My lord, not only.
So since 2012, for 13 years, you are sitting at home only for that.
My lord,
is it credible?
My lord, not only that single incident.
You could have gone to some other court to practice.
The respondent wife has made several false complaints against me before the competent criminal courts, which I am dealing with. So all
but that you need not leave your practice. Nobody leaves practice. People don't leave other husbands in other matrimonial matters. They will sit at home because the ruckus is created. Nobody leaves his profession. Particularly, you are a professional. You can go to any other court also, start your practice, or use your sources. There are many ways you can do your practice. You can go to for registration also. You sit at home for 13 years. Not sorry, not credible. We'll have to resort to reasonable guess for them.
My lord, and there are
What is
some-
their allegation? What is your allegation? His income, monthly income?
Monthly income, my lord.
What have you alleged to be his monthly income?
Actually, my lord, these are law, my lord, professional man, my lord. That cannot
What
be.
is your allegation about his monthly income?
I have not stated that, my lord. I cannot say so. I have demanded 15,000 per month because, my lord, I cannot say so because, my lord, professional man, my lord, that may increase, that may decrease, that may, my lord, stagnant. My lord, my lord, we are also practicing, my lord.
15,000.
I have demanded 50,000.
15,000 is nothing.
15.
My lord,
50.
No, 15.
15,000 is nothing.
Per month.
my lord, one thing also should be
If she
taken-
lived with you because your divorce decree, she's still your wife.
My lord.
So you have to pay for her. If she was with you, you had to pay at least 15,000 per month.
My lord, one thing this
You've gone 50.
honorable court should also consider, from 2019, I am severely ill. In 2019, I have also suffered from a heart attack, and stain was inserted in my heart. So I am,
Stent was inserted in your heart. You had a heart attack. Does not mean that you leave practice or don't have any income for that. No.
my lord, if this honorable court give me.
You had a
liberty,
second
I-
cardiac arrest.
Yes, my lord. And the 15,000 what has been paid before is not only for the wife, it is for the wife and for the child who is at present 32 years.
For the child.
No, not
No,
child.
in the
Let us see
petition
the-
they have averred.
No, kindly page paragraph 9, my lord.
This is not an application for alimony even.
My lord, your lordship, my lord, admitted, my lord, I was pleased to, my lord.
We treated this as
Yeah,
an
my
alimony.
lord, your lordship was pleased, my lord, please, was pleased to admit the same, my lord.
Where have you asked for 15,000?
My lord, paragraph 9, my lord. Yeah, my lord, I am, my lord, your petition submits that the monthly maintenance of rupees 4,500 per month as payable by
Son
the
is to
husband.
get monthly maintenance.
Yes, my lord.
Cost of utility attends age of 27 years.
Till
When did you get this
27
age? 27 years?
My lord, now he is 28 years.
32 years, my
Oh,
lord.
32 years, my lord, sorry, my lord, 32 years.
Sons don't get that advantage.
My lord,
Daughters get that advantage before
Lord.
they marry.
my lord,
Sons don't have that.
for his, my lord, educational
Once
purpose,
you're
he has,
adult,
my lord, he had taken from his
adopted.
maternal uncle, as your lordship pleases, my lord.
Yes, but that is
Your
also
lord,
true
your lordship
because
considered.
see, the practical reality is after attaining 18, very few sons, start earning. So therefore, the mother, it's also part of the mother's expenses to bear the educational expenses of the son.
But my lord, as per my
It's your,
instruction,
yes,
the
not
son
your,
is-
not as your responsibility. You do, he is not your dependent, not
Yes, my
under that category. But it's the expenses of the wife also. It comes within that.
Yes, my lord. And for that reason, in my bona fide, I have paid monthly maintenance, even if
How
there
much?
is 4,500 till what the planet advocate.
But
for
you
the
have
husband-
applied for refund of that amount also.
Yes.
No, my lord, I will not, because that is my bona fide, I have paid.
If you don't seek for that refund, that will be adjusted with whatever we direct you to pay. But you have to pay alimony. 15,000 is nothing.
But my lord, my instruction is that at this moment, the son is well earning.
Not for the son, for the wife herself. Son is earning.
But I have terrible stated, my lord, son is, my lord, purely, my lord, unemployed person.
What is he doing?
He's nothing, he's doing nothing, my lord.
You please take a seat.
My lord.
Yes.
As per my instruction, he is in private job.
Where have you stated what job? Where? Where is he engaged?
There is no documentary evidence. Sir.
Where is your averment even that he is working in this place? You have just sought to defend yourself.
In paragraph number 10, at the last juncture, I said that in page 13 of my opposition, I specifically beg to say that no question of enhancement of monthly maintenance can arise, as because I myself am leading my life at the mercy and care of my younger brother and his wife, whereas the respondent wife earns privately as a beautician.
These are blatant allegations without any basis.
And hair treatment expert, and the son, aged about 32 years, earns a handsome salary who resides with the respondent.
They're just your bold imagination. Say something. From the date of the application, when was the application filed? The series. March 2025. So the arrears will not be much. And whatever you have paid, that will be adjusted with this. You will not press your return application. If you press your return application, get an order there, then you have to pay more. Because otherwise, whatever we direct will be adjusted. 15,000 is nothing.
At this stage, looking into my situation, kindly some consideration be.
টাকা দিচ্ছি
পার্সোনাল পর থেকে অ্যাড হয় না
income sufficient to maintain herself করছে কিনা সেটা দেখতে হবে। বলছি টাইম তো 2009 সাল থেকে বসে আছো, বউ গিয়ে ঝগড়া করলো, প্র্যাকটিস ছেড়ে দেবে? ক্রেডিবল না, ক্রেডিবল। ডিক্রিটা হচ্ছে 2009। The decree was passed in 2009. You had your first heart attack 10 years after. So you're taking advantage of that heart attack. So many people are practicing with heart attack.
Yes, my lord. I'm not taking advantage. I'm just stating that because if at this juncture I have to pay, I have to earn the money, and my professional condition or my
You restart your practice. Nothing doing. We will not grant 15,000, we will grant 10,000. 10,000. এটা কি বলেছে? আবার তো রিসাবমিট করেছে তো। You had exhibited some other documents and you have filed something else.
Not
Old ration cards were
old ration
taken
card
back
has
and
been,
new
has
ration cards have been put in.
taken by the department, then new digital ration card has been given. Digital. Lord,
Those were not exhibited in the code bill. How can we take those?
Lord, what Lord discharge, Lord, change of situation is there, Lord. Ration card which has been Lord deposited in the as
You have to
exhibit.
deposit the exact exhibit you took with you.
Lord, that-
Whenever you take back a document, that is with an undertaking that
Yes,
you have
Lord,
to do that.
Lord, certificate
Why
copy.
did you exhibit in the
Lord,
first
certificate copy was there. Certificate copy has been given. Certificate copy is on record also. Certificate copy, Lord, of the same. And Lord, these have been taken by the Lord department, and Lord, digital ration card has been given.
নতুন ডিজিটাল
Digital ration card has been given. Digital.
এগুলো তো এক্সিবিট হয় না।
That is the.
You have got certified copy of the original document?
Email, yes, I have deposited. I have submitted the same in the High Court.
প্রথম যেটা সেন্টেন্স তুমি দিলে ওটা প্রথম প্যারাগ্রাফটা, এই এক্সিবিট যেটা বললাম এটা কেটে দাও, এটা কেটে দাও। You are granting 10,000. At the outset, learned counsel for the respondent wife submits that the exhibits which were taken back by the respondent wife were deposited with the appropriate authorities, and as such, certified copies thereof, as well as newly issued digital ration cards have been ration cards, comma, which have been issued in place of the previous ration cards, comma, which had been marked as exhibits, comma, have been furnished. So, however, comma, since the new digital ration cards were not part of the trial court records, comma, nor exhibited in proper manner in the code below, comma, those cannot be construed to be the exhibits in the suit. Full stop. The office is directed to furnish a further report as to whether the certified copies of all the withdrawn exhibits have been filed by the respondent. Full stop. Such report shall be furnished by June 13, 2025. তারপর the application bearing can 2 of 2025 is taken up for hearing. First up, although the application has been couched as an appropriate order, comma, upon hearing learned counsel for the respondent stroke wife stroke petitioner, comma, we find that such caption has been given under a misapprehension. Full of next para, the present appeal arises from the dismissal of a divorce suit filed by the appellant husband in the year 2009. Full stop. Next para, the respondent wife, comma, apparently, comma, was under the misapprehension that the under the mistaken notion that the alimony pendentility granted by the trial court during pendency of the suit shall continue during the pendency of the appeal as well, on the presumption that appeal is a continuation of the suit. Push up. Next para. Even the appellant husband initially deposited arrears. Push up. An execution case was levied on the self-same premise in respect of non-payment of the alimony pendentility, even for a period after filing of the appeal. Push up. The husband also cleared off some of the dues in such context, comma, proceeding on the premise initially that the order of alimony pendentility passed in the suit was continuing. Push up. Next para. However, comma, subsequently the appellant husband grew wiser and filed an application for refund of the amount paid for the period after the passing of the impugned decree. Push up. Next para. Thus, comma, in effect, comma, we treat the present application to be one for alimony pendentility. Full stop. Next para. Learned counsel for the appellant husband, comma, during hearing, comma, submits on instruction. You will not press that refund application.
Yes, ma'am.
That the application filed by the appellant husband for refund of the excess amount paid in respect of alimony pendentility shall not be pressed by the appellant
It
husband.
was rejected.
It was rejected.
In 2019. Not
তাহলে shall not be pressed ওখান থেকে কেটে দিয়ে was already rejected
by the learned trial court.
full stop. Be that as next para, be that as it may, comma, we independently take up the present application for alimony pendentility, and whatever amount is directed to be paid by us shall be adjusted with the amount already paid by the appellant husband.
Lord, my lord,
Full stop. Next para.
please excuse.
The appellant wife, the respondent wife, claims that she is unemployed. Full stop. In the application, comma, she has claimed alimony at the rate of rupees 15,000 per month for herself and her major son in lieu of education expenses for the said son. Full stop. It is denied by the respondent wife that she is earning anything, comma, either as a beautician, comma, as alleged by the husband, comma, or otherwise. Full stop. Also, comma, it is denied that the son of the parties is employed anywhere or is earning salary. Full stop. Next para. Learned counsel appearing for the respondent appellant husband submits that the appellant husband is suffering from severe cardiac ailments and is due to undergo a cardiac operation on May 24, 2025. Full stop. Previously, comma, in the year 2019 as well, comma, the appellant husband suffered a heart attack for which a stent had to be implanted in his body. Full stop. Next para. It is contended that in the year 2012, comma, RUCKUS, RUCKUS, was created by the respondent wife in the Bar Association of the appellant husband, comma, in the City Civil Court at Calcutta, where the husband used to practice law, comma, due to which severe trauma and ignominy was caused to the husband. Full stop. Consequentially, comma, in order to avoid ridicule, comma, the appellant husband allegedly left practice thereafter and is now dependent on the alms, ALMS, of given by his relatives. Full stop. Next para. However, we do not find the said allegation of the appellant husband credible. Full stop. Next para. A person having a law degree and having practiced for quite some time uh, would not, under normal circumstances and prudence, leave his practice altogether simply because his wife created a scene at his workplace and or filed several complaints against the said husband. Full stop. The husband, being a qualified advocate, having had a number of years of practice behind him, cannot be believed to have left his law practice altogether merely due to such stray incident. Full stop. As such, we cannot but opt for resorting to reasonable guesswork as is legitimate in such circumstances, where one of the parties suppresses his stroke her income. Full stop. Even going by moderate standards, we are of the opinion that an amount of rupees 10,000 per month ought to be payable as alimony pendentility to the respondent wife to meet her bare requirements. Full stop. The wife admittedly earns rupees 2,000 from a fixed deposit from interest in respect of a fixed deposit which she has, as well as earns rupees 1,000 per month under a state government scheme. Full stop. Next para. However, the amount of rupees 3,000 per month is extremely meager, and as such, we hold that the wife does not earn sufficient to maintain herself. Full stop. Next para. In view of the above, can 2 of 2025 is allowed on contest, thereby directing the appellant husband to pay alimony pendentility to the respondent wife at the rate of rupees 10,000 per month. Uh, Full stop. The current alimony at the above rate shall be paid by the 15th day of each current month, starting from the month of June 2025, and thereafter by the 15th of each succeeding month for the said month. Full stop. Next para. The arrears of alimony counted from the date of filing of the present application, that is from March 2025 till May 2025, shall be paid by two equal monthly installments, the first of which shall be paid by June 30, 2025, and the second by June 31, 2025. Full stop. Next para. It is made clear that whatever amount has been paid by the respondent husband uh, to the uh, uh, appellant husband to the respondent wife for the period after passing of the impugned decree of the trial court shall be adjusted with the said arrears. Have you paid more than 30,000?
Yes, my lord.
Full stop.
Yes, in lot 4,33,000, 4,32,000. Yeah.
We'll adjust
We
it.
him lot filed return back the same.
Tell it last night. She'll not have anything then if you adjust it.
My
Whatever you have paid, you have paid.
You have
And
put
your
it up.
application was rejected. We were under the impression that you were not paying. Last night, this much.
Good.
No rest to cost.
Good.
Are the paper book directions and all are there?
Lord,
Previously, informal paper book direction was there, but presently I am praying for direction of formal paper book.
Why?
Because, my lord, as I have stated, the physical condition may be hardened, so I am praying for a formal paper book direction.
Well, what does that have to do with the physical condition? The same people will prepare it. Whoever prepares the informal paper books, they also prepare the formal paper.
My lord, my
You just have to pay them.
Yes.
No qualification of that one. We'll come back after 5. This matter is over.
grateful, Lord.
I'm opposing.
My lord, I am for the appeal.
Yes, Mr. Prasad, what is the matter?
My lord, application for condonation of delay. My lord, they have used an opposition. My lord, I am filing my reply. I have copy.
Opposition you have filed, Mr.
Yes, not on the last
On the
occasion,
last
Lord, on the last date, Lord, it was. Yeah.
Opposition টা কি দিন না? Opposition টা একবার দেখুন তো। বলা আছে। Yes, got it. Mr. Mukherjee, please take a seat here. Yes, Mr. President. What is the period of delay?
My lord, it was notified by the stamp reporter that 1358 days.
1358.
58 days. But my lord, I am before my lord, I am delving into the explanation. My lord, I just want to point out the argument that I want to advance. First, my lord, this delay of 1358, my lord, could be erroneous reporting. And my lord, whatever delay that was arisen, my lord, I have explained. My lord,
According to you, what is the delay?
my lord, according to me, my lord, the delay should be, my lord, 18 days. 18 days. Because, my lord, I am giving the background why I am.
COVID period or?
No, no, no. My lord,
Prior to COVID.
prior to COVID, my lord, my lord, the preliminary decree was passed on 30th of July 2012. Now, my lord, when the preliminary decree was passed, immediately thereafter, my lord, we have filed an appeal challenging the preliminary decree.
Within time.
Well, there is a section 5 and there was a section 5 and
Condoned.
yes, condoned. Now, my lord, what happened in that appeal, this honorable court had directed that you proceed with the preparation of the final decree, but you shall not give any effect. And the parties will be restrained from my lord, changing the nature and character of the concerned property. Now, my lord, this was the interim order and it was passed on 20th of July, 20th of June 2013. Now, my lord, what happened thereafter? The trial court had proceeded with the preparation of the final decree. The final decree was passed by two different order, 24th of June 2013 and 28th of July 2013.
Despite the order of this court?
Yeah, it was the direction was that you go with the preparation, but you shall not give any effect to the final decree. This was the direction, interim direction. I will place the order that was passed. My lord, if my lord will consider
Yes.
my delay application, that is Can 3 2025. My lord, it is appearing at page 70. It was the interim order considering my section 5 and the injunction. And this was the appeal challenging the preliminary decree.
Oh, there was no restriction to passing the decree. Let
Yes.
the process be complete.
Process
An apprehension was expressed that court might give effect to the final decree.
My lord,
Then this appeal was disposed. The
my
next
lord,
day.
yes, my
Yes,
lord,
that was dismissed.
kindly consider, my lord, the appeal is
Very well. So decree was drawn up on. Why do you give 2 dates? How can there be 2 dates?
my lord, the initial day was the commissioner report was taken on record.
That is not the date of the decree.
At the second day was the my lord, the court had finally prepared the 28th July 2013.
Very well. Final decree. Yes.
Now, my lord, as the my lord had already produced the interim order, my lord, there was a direction that you proceed with, but you cannot give
Not
effect.
given effect to subsequently the appeal was also disposed of.
And my lord, thereafter in the year 2017, 22nd of March 2017, The appeal challenging the preliminary decree was dismissed.
Huh.
Now, my lord, I filed this appeal challenging the final decree on 7th of July 2017.
Twentieth of
22nd of March 2017, the Malota
appeal disposed.
appeal was disposed, and
You
I
filed?
filed this appeal challenging the final decree on 7th of July 2017.
You count the limitation from the date of disposal of the appeal.
Malota,
Because till then no effect to was given.
because ultimately, Malot, it as the
Limitation runs. No effect to is in the nature of a stay.
Malota,
Decree will not be given effect to means in effect the operation of the decree is stayed, even if that
But
was so.
Malot,
That does not mean for the purpose of limitation, the limitation did not run.
Malota, subject to correction, but Malota, as my preliminary challenge to the preliminary decree was also pending. Until unless, Malot, that
So what?
Malot, it was not disposed of, Malot, how the final decree, because the final decree
Absolutely.
will
Or
agree
appeal
with
does
the,
not, pending of appeal does not operate as stay. Order 4105.
and
And
Malot,
here there was a specific order whereby the court was permitted to
permitted,
to complete the process. That was the language used. To
but
complete let the process be complete.
process
The
be,
previous sentences, your advocate said you apprehended that the court below might give effect to the final degree.
yes,
Might give effect to the final degree. Mark the language.
yes,
Let the process, court says, let the process be complete. However, the actual allotment, if made, must not be given effect to.
yes.
So actual allotment can only if made. So it goes up to the stage of actual allotment being made. But even if made, not effect to.
Yeah,
That
Malot,
means the decree is in existence. Or I mean,
subject to correction, Malot, it is in totality, Malot, the final decree will not be given effective. Malot will consider.
final degree will not be given effect to
Yes.
means presupposes that there is a final degree which can be given effect to.
Malot,
Not given effect to for the purpose of limitation, how can that be relevant? Final degree is passed.
yes,
If
Malot,
X is not to be given effect to, that means it
Yes.
presupposes X exists.
Malot, that is
Final
going
degree
on.
was
That
there.
is going on.
Limitation Act, there is no such provision. No.
Malot,
That is the only explanation.
Malot, explanation that it was under impression that as it was not, direction was there not to give effect.
Very, very fatal in
Malot,
impression.
this was the first one, and Malot, finally, Malot, this as Malot, this was pointed out when this appeal was Malot, this appeal was taken up, that you take back the initial section 5, Malot, explaining 8 days delay and file afresh. Malot, accordingly, that section 5 was finally filed before your lordship on 17th of April 2025.
Section 5 application filing date is unimportant.
Yes.
Date of filing of the appeal is important.
Malot, 7th of July 2017, the appeal was filed, and if that be so, Malot, 1358 days delay is the actual delay as per the stamp reporters.
7th of July
2017.
2017.
And Malot, the explanation to that effect.
So final degree you said is 20th of July 2013 or
13. Prior to that, it was already Malot done. But
appeal file, yes, right.
This appeal challenging the final decree, Malot, was filed on 7th of July 2017. After Malot dismissal of the appeal to the
No, Mr. Prasad, we are dismissing your application.
Malot, this is the only Malot, and Malot, if Malot will consider the merit of the case.
Cannot. Now we cannot.
Malot, this.
Go and convince Justice Trivedi.
Malot, because subject to correction, Malot.
Merit in certain cases, yes. In marginal cases, Mr. Prasad, we do. We don't say that, but we do. Here, 1358 days, no. And this explanation.
Malot,
it's a very intelligent way of putting it, but it's entirely advocate's brainchild.
Malot, that what is the cause, Malot, I have explained. Malot, I have nothing more to add. This is the Malot impression.
It goes to your credit, Mr. Prasad, that you could have this to add. No.
Malot, and what I am humbly praying, Malot, that the final decree,
Hmm.
because I am also insisting your lordship to take a look to the final decree also. Malot, that the final decree, because I am also insisting your lordship to take a look to the final decree also. Malot, and because there are several malot irregularity. The commissioner who had been appointed malot to cause the partition, but he is not a survey knowing commissioner. There is no such malot reflection that
You
he
take
knows
that
that.
written objection.
Yes, malot, I have given, but it was ultimately turned out by the trial court. I have cross-examined the commissioner
Really
also.
preferred an appeal, Mr. Prasad. Even if you have, look into that, that cannot be a ground for, that cannot be the primary ground for condonation of delay.
No, no.
In your case, if you look into that, that will be the only ground of condonation of delay. We cannot do that. We could never do that, even previously.
Yes.
That could be one of the considerations.
Yes, malot.
And in
I
50-50
can-
cases, in even suppose closer cases, we could consider that. That is one of the ground. But here, that will be the only ground. There is no other. The other ground is not acceptable. Mr. Mukherjee, I have heard you. Yes. The present application for condonation of delay has been filed in respect of an appeal preferred on July 7, 2017 against a final decree of partition dated July 20, 2013. Push up next para. Learned counsel appearing for the appellant stroke petitioner submits that against the preliminary decree passed in the partition suit, comma, from which the present appeal arises, comma, dated July 30, 2012, comma, a first appeal was preferred bearing FAT number 29 of 2013. First up, in connection with the said first appeal against the preliminary decree, comma, with a order dated June 20, 2013, comma, a coordinate bench had inter alia recorded the apprehension of the appellants that the trial court might give effect to the final decree. Full stop. In such context, comma, it was observed that let the process be complete, comma, however, comma, the actual allotment, comma, if made, comma, must not be given effect to, comma, without express leave being obtained from the said court. Full stop. Next para. Learned counsel appearing for the petitioner submits that as such, comma, in view of the said order dated June 20, 2013, comma, the final decree of partition, comma, although passed in the interregnum, comma, did not have any effect in law. Full stop. The said position changed with the disposal of the appeal by an order dated by a judgment dated March 22, 2017. Full stop. Upon such disposal, comma, the present appeal has been preferred on July 7, 2017. Full stop. Calculating the period taken for obtaining the certified copy and other ancillary periods, comma, the limitation period, the limitation, the delay, comma, in the present case, comma, is submitted to be about 18 days. Full stop. Next para. Learned senior counsel appearing for the respondents controverts such submissions and contends that merely because a coordinate bench had directed the effect of the final decree not to be given does not mean that the decree was the decree did not have an existence. Full stop. As such, comma, it is argued that the limitation period began to run from the date of passing of the final decree on July 20, 2013. Full stop. Upon a careful consideration of the submissions of parties, comma, we find that the arguments made by the appellant stroke petitioners are not tenable. Full stop. Next para. The very fact that video order dated June 20, 2013 passed in FAT 29 of 2013, comma, the coordinate bench observed that no effect would be given to the final decree presupposes that the court permitted a final decree to be passed. Full stop. The said observation of the coordinate bench merely operated, comma, at best, comma, as a stay of operation of the said decree. Full stop. Next para. However, comma, such an order does not translate into the decree, comma, which has already been validly passed, comma, freezing in time. Full stop. Next para. There is no provision within the four corners of the Limitation Act contemplating that in such situation, comma, the limitation period will stop running. full stop, next para, thus, comma, the position of law uh, sought to be portrayed by the appellants are not tenable from any perspective. Full stop, next para, as such, comma, the grounds given in the present application for condonation of delay cannot be accepted. Full stop. Accordingly, Can 3 of 2025 is dismissed on contest without, however, any order as to cost. Full stop. Consequentially, FAT 363 of 2017 is dismissed as time barred. Dismissed as time barred.
Yeah.
Great. Thanks. এটা ফর্মাল ডিগ্রি হবে না। এই মেঘনাথ এটা জাজমেন্ট ফর্মে করবেন কিন্তু ফর্মাল ডিগ্রি হবে না।
হয়তো ক্যান পেন্ডিং ছিল সেটা ক্যান টু
All cans.
আচ্ছা, can such, thank you. Can such and such are disposed of consequentially.
Thank you.
Grateful.
Lordship, item number 11, I have been requested by the appellant's advocate, Lordship, to prefer an adjournment. For 2 days.
On the prayer of the appellant, let the matter stand adjourned till May 19, 2025, Monday. Mr. Roy, your name, somebody's name has to be given because a prayer, your name given. Yes.
Yeah.
Well, my lord, is my appeal. Lordship was hearing this matter last week, my lord,
Yes.
with respect to that transposition point that the company, my lord, being the appellant number 1,
Yes, yes.
had gone into CIRP. But before I commence, my lord, I think I'll have to make, my lord, apologize to the court. In fact, my lord, unconditionally tender my apology. There was one small wrong submission that I had made, my lord. This might be, my lord, bordering on suppression, so I'll have to bring it to your lordship's notice. 2019, my lord, the appeal was preferred. On behalf of all the appellants, the submission that I'd made on the last occasion was that the company had not gone into CIRP or not in winding up. Lord, we came across, my lord, day before yesterday, an order on the server passed by Justice Showman Shen. But in that, my lord, possibly the interpretation could be that sometime in the year 2019, prior to the appeal being preferred, my lord, the winding up had been restored. Whatever the effect of that, my lord, would be, I will argue that later. My lord, that has gone down in paragraph 12 of your lordship's order on the last date. Lord, I'd probably, my lord, be failing in my duty if I don't point it out to the court today.
Paragraph 12, we have said at the juncture when the suit as well as the appeal was filed, 2 and 3 were directors of the company.
Well, I could not have been a director if the company was in winding up. Because then
But you're still in winding up.
Well, that
Winding up court gave an opportunity to pay up in certain time.
yes, that
But
was
the winding up petition was pending.
Yes.
no
it was
winding up petition was pending right from the beginning, right from 2012. That is not even the bone of contention. The point is that in 2012, when the company had gone into winding up in the company court, then there were several opportunities that were afforded to me in order to pay up so that the company goes out of winding up. In
But
fact,
when this application was filed and this particular appeal was filed, you are still directors.
I was when the suit was filed, I was still the director. Lordship kindly looks at one order, my lord. When the suit was filed,
Can I have a copy?
no, not yet.
Lord, I'm for the RP. May I also, my lord, have a copy of the
I'll give it to Mr. Lakhmani. I have one copy.
Give a copy because they have to come prepared on this also.
Yes, my lord, I'll hand up. I don't have
notice and he's
I don't have an available copy. I'll give my copy to Mr.
Mr. Naik, you circulate copies, we'll take it up before next Wednesday, can't take. You have to advance arguments on this then.
It's 9th of September 2016.
This is a
So this is, my lord, prior to the filing of the appeal. Post the filing of the suit, but prior to filing of the appeal. What I would have prayed for was that the appellant number 1, eventually, my lord, if I'm able to satisfy that there was no malafide on my part at all.
No, not malafide, but
because this order, my lord, in my defense, this order, my lord, I could not find right at the beginning. But I'm led by Mr. Shen, my lord, in no matter.
yes, Mr. Shen, let them have a look at this order.
9th September.
9th September, and let them come back because you have to argue on that.
But yes, my lord, we missed this matter on the last occasion before your lordship, my lord. Subject to correction, my lord. Even in that case,
yes,
that part of your lordship's order will remain because appellant number 2 and appellant number 3 have sued in an independent capacity as guarantor, which your lordship has held. So that therefore the plaint can be segregated as having been filed by appellant number 2 and appellant number 3.
That logic remains.
That will remain. My respectful submission, my lord. Difference only will be that, my lord, now because of the CIRP, appellant number 1 would have been represented by RP. Now appellant number 1 will be represented by the official liquidator, if that is so, because if it had already been wound up before.
No, but presently the company is undergoing CIRP.
Undergoing CIRP.
And
Yes.
I'm the RP.
Resolution purpose, yes.
So I'll be representing the company.
RP is the person who will represent.
Yes, but I have
You directed notice to the RP for
Yes,
that.
your lordship, your lordship.
Mr. Lakmani, what is your stand otherwise on this? I mean, would you like to contest the appeal along with them?
My
Or
lord, may I tell your lordship, my lord, there are some elements here.
yes.
Firstly, my lord, the appeal, even if the appeal succeeds, the suit ultimately will not be pursued by me. It will be pursued by the resolution applicant who will take over the company. Right now, a plan for approval has been filed and that plan is pending voting, my lord. Voting is on. Any day the plan might be approved and I may cease to be the RP. So this is a call really, my lord, that the RA may take eventually whether to pursue the suit or not. But my lord, as of now, my lord, I am in charge.
No, there's a resolution plan in
A plan has been received.
on the pipeline.
A plan, no, my lord, a plan has been received under the code,
If that is
insolvency
approved,
code.
if that is approved, the company remains the same.
There are 3 levels of scrutiny. My lord, first level
Yes,
of scrutiny
yes.
is the resolution professional. I have passed the plan. Then it's placed before the committee of creditors who vote on the plan.
Lastly, the
That voting is
appropriate-
ongoing.
Yes.
Once, my lord, it is voted upon, then, my lord, the tribunal will have to approve.
Even if it is approved, the company remains the same.
Company remains the same.
Management will change.
Management will change, my lord, but the management
So then
cannot.
it reverts back to the same position. The company
My lord,
remains
but then the new management, my
may
lord,
take a different decision.
will take whatever decision they have to. Ideally, this decision ought to be reflected
Even
in
then,
the.
in the suit also, then transposition has to take place because they don't relinquish their cause of action as guarantors.
My lord, all I'm saying is that these are, my lord, things which have happened in the past. This matter was first before the High Court.
So today, what is your stand? I mean, what is your
My lord, I
instruction?
need to inspect records. My applications, my lord, for non-compliance of handing over of records is pending both against the official liquidator because the matter was before the High Court, as well as, my lord, against my friends, the guarantors. So, my lord, I'm yet to even, my lord,
You take,
access.
need some time to take
I
a
will-
decision on that also, transposition.
Yes, my lord. Today, my lord, I can't really comment on that. But, my lord, if your lordship gives me some time, my lord.
This application was for what? What relief? Did you grant any relief?
This is an application for Section 5 and my lord,
Oh,
the
Section
stay
5.
application, my lord.
And I, my lord, have to be very careful here because if I side with the bank, I'll be blamed by the guarantors, and if
Either
I side
way,
with
you
the
are-
guarantors, I'll be blamed by the banks.
Yes.
So either way, my lord, I'll be sandwiched. So I have to, my lord, take into account a lot of aspects and then take a decision here.
The company cannot say that they will not pursue a damage claim. Even whoever comes in control of the company, that will speak.
So, Mr. Shen, they may take a decision that this is a waste of their money. I mean, pursuing a litigation.
No,
That the
because it
litigation departments of companies often take decisions that
No,
we
no,
won't
that-
pursue.
but
They may enter into a
here,
compromise,
my
try
lord,
to
it
enter
is a
into a
case
compromise.
of, my lord, it is a case of where the secured creditor could not take proper steps in respect of the hypothecated asset.
True. At the end of the day, Mr. Shen, this is a decision which the company can
Of
take.
course.
They may say we won't spend in litigation.
This advantage difference will be, well, this is not a case of general damage. This
Whatever
is
damage. Whatever they may
a,
relinquish
they
their
will
suit. They
gain
may,
by reason of, well, lord, their debt being
but
discharged.
they'll also have to go on paying litigation costs for that. They may think
Well,
that will be
opportunity
prohibitive.
cost, well, it depends on opportunity. How far you will gain if you can
Depends
prove.
on how many appearances Mr. Lakmani has and all these things.
The cause of action was like that, the money money will be received, the goods were stolen of the company, and if that happens.
That is in the suit.
They have to
That
be
is,
resolved.
they have to take a call first whether they proceed
My
with
lord,
the.
practically, I'll tell your lordship what is happening. My lord, the COC will decide whether the plan of the resolution applicant will go
It's
through.
risky for the resolution profession to take a decision even now.
Yes.
My lord, it is. My lord, it is. I just need, my lord, some time to, my lord, scrutinize my documents and make a stance because I want to be thorough, my lord.
We'll keep it the first Wednesday after vacation.
Very well, my lord. Your lordship may consider
After
it.
vacation, we'll keep it the first
But
Wednesday.
transposition can take place. They have no.
No, if they take a decision that they will proceed with the appeal. Otherwise, if they have to file a fresh appeal, Mr. Shen, that will be time burden now.
Yes, that is true.
So they may not, if they want to proceed with this challenge, I mean, they may be on the same footing as you and they may.
Yes.
May I let a copy of the order which has been handed over to your lordship
yes,
be made available to us?
Or give the details they can have.
It
And the condonation of delay application may be served.
In our order itself, you have got a copy.
Condonation of delay.
We are keeping this pending then till Wednesday, the first Wednesday.
The condonation of delay application may also be served, Lordship. They have not given that. No, then
Very well, whatever. Learned Senior Counsel appearing for the appellants hands over a server copy of an order dated September 9, 2016, passed in CA number 428 of 2016 with CP 42 of 2012, from where it transpires that the learned single judge recorded that the official liquidator submitted that the company had defaulted in making payment of installments in terms of a previous order, by reason whereof the order of winding up passed by the learned single judge has revived. Full stop. The learned single judge ultimately observed that in the meantime, the property had been taken possession of by the State Bank of India in exercise of its powers under Section 13(4) of the Surface Act 2002, and it was submitted that the property had not been put to sale. The learned single judge further found that under such circumstances, an appropriate notice be served upon the State Bank of India, Stressed Assets Management Branch, Roman 2, Jivandip Building, with an intimation that the matter would come up for consideration on the returnable date, that is September 23, 2016. And in the event the said secured creditor was not represented, appropriate orders with regard to the preservation of the property shall be passed. Next pair, it is submitted that due to a communication gap, the said position could not be apprised to the court on the last occasion when the matter was heard. Next para, a copy thereof is handed over to the learned advocate appearing for the respondents and the resolution professional who is represented in court today upon notice. Next para, learned counsel for the resolution professional submits that his client is required to go through the relevant documents, which will take some time, before taking a call even on the issue of whether the resolution professional shall, on behalf of the company, decide to proceed with the present appeal as an appellant. Next para, hence, in order to enable the resolution professional to apprise himself stroke herself appropriately, let the matter stand adjourned till June 11, 2025, when it will be listed next under the same heading.
Himself, my lord.
Himself, herself, stroke herself. Thank you.
Affidavit of service.
Affidavit of service file to be kept on. We said himself, herself, because I did not want to stop the flow. Otherwise,
This gentleman seems to be a little masculine, so I'm grateful.
Yes. Land acquisition.
No, I beg to be excused, at the initial, because of slight mistake, we had to approach your lordships once again. But all these 8 appeals were disposed of by common judgment, and all the pending applications were stands disposed of, and liberty was granted to the respondents to withdraw the deposited amount. Now, one mistake we forgot to point out, your lordship, out of all those applications, one substitution application was there. That was required to be disposed of. That's why I come up with an application for addition of party, for adding the party in this appeal as in place of deceased respondent. Only in one appeal. I pointed to further.
Which appeal?
That is appeal number, 618. I have also annexed the application for substitution along with this application.
What is the CAN number of that?
Today's CAN number is 9.
Earlier CAN 7.
Earlier CAN was
CAN 7 was. CAN 7 was not formally allowed.
Stand disposed of. All applications disposed of without passing any substitution order. That's why I have come up with this fresh application. Only an order of substitution.
That substitution application was filed within time.
Yeah, no, that was filed by us after a delay of with section 5 application. We have filed under Order 22 Rule 9.
No, that was in their appeal you had filed.
Their appeal we have filed without intimating.
So you cannot oppose that.
Yes, we have filed.
In fact, in the land acquisition case, my lord, there is no limitation in his for substitution.
No, it lies. Certainly it lies.
The present application, being CAN 9 of 2025, has been filed by the respondent in FAT 618 of 2019, which was disposed of along with several other connected appeals by judgment dated May 1, 2025. Push-up learned counsel appearing in support of the application submits that due to bona fide inadvertence, it was not pointed out to the court that Can 7 of 2024, filed in connection with FAT 618 of 2019, was an application for substitution of the heirs and legal representatives of
This is respondent Ranjit Kumar Mukherjee. Only one respondent.
Of the deceased respondent Ranjit Kumar Mukherjee.
Ranjit Kumar Mukherjee.
Ranjit Kumar Mukherjee. Full stop. Next para. It is submit. We upon hearing learned counsel, we find that although it was recorded in the judgment dated May 1, 2025, that all connected applications, including Can 7 of 2024, were disposed of, no formal order allowing the same and directing the substitution of the heirs of the deceased respondent was passed. Push up next para. We accordingly construe the part of the judgment dated May 1, 2025 to dated May 1, 2025, whereby Can 7 of 2024 was directed to be disposed of to be an order allowing the said application and directing the substitution of the heirs and legal representatives of the deceased respondent Ranjit Kumar Mukherjee upon setting aside abatement on condonation of delay. Full stop. Accordingly, since the said application was already disposed of, the same is deemed to stand allowed as on that date, that is on May 1, 2025. Full stop. The office shall carry out the consequential corrections to the memorandum of appeal, incorporating the names of the heirs and legal representatives of late Ranjit Kumar Mukherjee in the place and stead of the said deceased in FAT number 618 of 2019 in terms of the cause title of Can 7 of 2024 filed in respect of the said application. Full stop. The necessary consequential corrections shall also be effected in respect of the decree passed. Is a formal decree passed?
No, your lordship, decree is yet to be passed. Drawn up. Order is there.
The necessary consequential correction na kore, the necessary alterations shall also be reflected in the decree drawn up in respect of FAT 618 of 2019 pursuant to the judgment dated May 1, 2025. No rest of course.
Application Can 9. They have filed application for additional parties is also the parties.
Can 9 is
Can 9 dispose of ki bollam na?
No.
Acha. Can 9 of 2025 is disposed of accordingly in the light of the above orders. Disposed of already constituted. Retrospective put our date. Yes, Mr. Raut. Yes, this is an application for
The last
injunction application is the
So the last occasion, Lordship had asked for the plaint of the suit filed by the plaintiff, the appellant, my lord.
Yes.
This is the
appeal is against what?
Against the
Refusal
order.
of injunction.
refusal of injunction.
Ad interim.
No.
No,
Temporary.
temporary.
Well, your lordship perhaps remember 3 co-tenants are there.
Yes.
Well, they jointly entered into an agreement with the erstwhile owner.
That he will collect the rent from the other occupiers.
Not only that, I was given the co-tenants were given liberty to erect a multi-story building.
You have erected that.
Yes. During the subsistence of the tenancy.
He has not erected.
Let him.
But subject to correction, he has not constructed. His deceased.
So your turn will
My-
come.
my
Sir.
predecessor-
Take your seat.
My predecessor constructed during the subsistence of that tenancy.
Take your seat, Miss Ahmed.
We came to learn my landlord's client, the respondent number 1 and 2 before lordship. They purchased the property in a clandestine manner
From whom? The owner.
from erstwhile owner, my landlords. And immediately after purchasing property, started collecting rents directly from all the subtenants.
You said they're bound by that agreement entered into between you and your land.
My lord, exactly.
That was a part of your tenancy agreement.
Yes, my lord. And not only that, your lordship will find from the tenancy agreement, Annexure A, dated 18 June 1982. There was a particular specific clause that if in future the landlords intend to sell their property, the first the preference should be given to my client, to the co-tenants.
But did you ask for a specific performance of that?
Yeah, behind my back, clandestine manner.
Till date, have you asked for any specific performance? You did not.
But that was not done, my lord. Immediately now, thereafter, what happened, my lord? Out of 3 co-tenants, 2 co-tenants, according to them, he sent a letter in the year 2018, intimating my client, the appellant before lordship, that we have already surrendered our tenants. Well, this is the entire scenario.
So page 40 is that clause.
My lord.
Second party authorizes the imports, first party to collect and realize rents from tenants.
Yes. And according to my land, the respondent number 3 and 4, the other 2 co-tenants, we have already surrendered our tenants.
To them?
Yes. Well, first of all, the surrender must be coupled with delivery of position. No position was given. Their subtenants are still there. Well, up to 2018, we collected rent from them. Thereafter, they all of a sudden started stopped making payment to
So
rent.
your predecessor.
I'm only.
Your predecessor was the original tenant. He was the
yes.
successor.
Yes, no.
Those 2 points were taken by Mr.
My lord, that predecessor died, leaving his widow and younger brother. Subsequently, widow died. Younger brother before lordship.
You are the heir, but a point was taken by Mr. Ahmed,
My lord,
remember correctly on the last occasion,
yes.
that it will survive on the surviving co-tenants or joint tenants, whatever. Joint tenant was it specifically.
Yes.
And not on the heirs of the deceased co-tenant, joint tenant. That was one point you had taken, Mr.
Yes,
Ahmed. So you have to meet that point. What is your answer?
Well, first of all, under the Mohammedan law, the brother, full blood brother, is the heir of the other co-tenant.
Show us from any book.
My lord.
Brother is the sole surviving closest heir.
Only sole surviving. That co-tenant Noim Malik died leaving no issue. Widow died subsequently, and he's the only surviving the full blood brother. Your lordship will find from I beg to excuse my lord. Today, I could not collect the second copy of the book. This is the only copy I am handing up. My copy I could not trace out. I purchased that small yesterday. New book. I am handing up. Your lordship, the Sunni law inheritance. Your lordship,
This is by whom? Mullah, এখন নামই মোল্লা তাহির মামুন মোল্লা বাদ দিয়ে সবাই লিখে
three classes of heirs are there. Sharers.
Apart from you, there is nobody else of the.
No.
In any event, you have to come. And the second point taken by him that it will join in respect to joint tenants. On the death of one of the tenants, it survives on the surviving heirs.
My lord, I'm
surviving joint tenants.
My lord, I'm ready to give answer to yours. Admittedly, my predecessor died in the year 1991 during the operation of the 1956 Act. If that be so, recent decision, your lordship knows, my lord, the 2024 Supreme Court.
2G does not apply.
My lord?
2G does not apply.
Because if it is found the tenant dies during the operation of the old act, prior to 10th July 2001.
Yeah, that order till it is recalled
Yes.
by the Supreme
Well,
Court.
here in this case, my predecessor died 1991.
During
Well,
56
the
Act.
56 Act. Well, then you will also finally take trouble to go
Yes.
through the definition of 2H of the 56 Act. Definition of tenant, section 2H.
56 Act নেই আপনার কাছে 1956 premises আছে একবার আনা হয়েছিল
Well, these books are now available after. No, somehow I have collected. Your Lordship, only definition will suffice. Your Lordship, I have. 2H. Squarely covered my case.
We are afraid to handle these books because the pages may come off in our hands. Yes, 2H.
I'm reading it. Tenant means any person by whom or on whose account or behalf the rent of any premises is or but for a special contract would be payable and includes any person continuing in possession after the termination of his term. This is not relevant for us. Or in the event of such person's death, such of his heirs as were ordinarily residing with him at the time of his death, what shall not include any person against whom degree has been passed. Well, I am the younger brother, full blood brother.
So even if it's a joint tenancy, the position does not change. Good.
And well, in support of my contention, well, I am referring a judgment. Well, reported in. Well, in a Karnani properties, I am not citing your Lordship.
No, so cite it formally.
Well, then your Lordship citing reported in AIR Online 2024 Supreme Court, page 271. Sorry, 771. AIR Online 2024.
You'll also find it in SCC.
My lord.
You'll also
Yes,
find it
for
in
me,
SCC.
yes.
You can give the name to Mr. Amit so that you can find it.
Name Rajesh Mitra alias Rajesh Kumar Mitro.
Find out by Rajesh Mitro. Otherwise, Karnani properties, there are several reported judgments.
Karnani.
Rajesh Mitro will be less number. At 2024. Justice Sudhanshu Dhulia's judgment.
Yes.
Have you got an extra copy for Mr. Ahmed?
Yes.
Give it to Mr. Ahmed also. Yes, he must be knowing
Yes,
it.
yes,
All of us know. But cite it formally to us.
On yes.
We have to refer to it.
Paragraph 22, 23.
Yes.
I know this. And well, the second one was reported in very old judgment, well, Indian law reports. 1939 Indian law reports. Calcutta 254. Well, in this judgment, there was no paragraphs. Well, I will draw attention of my lords from my lord the my lord, page 258, second paragraph onwards.
Page 250?
Second paragraph onwards. In India, as you also got that. Page 258, my lord, in second paragraph. Third paragraph, I think.
Yes.
In India, tenancies from year to year, or from month to month, are leasehold interest. Section 116 of the Transfer Property Act places leases from year to year and from month to month on the same footing. these tenancies under the Transfer Property Act are transferable, and I see no reason why they should not be heritable. No, so far this case is concerned, a suit for eviction was filed. The landed municipal decreed the suit. On the ground, the tenancy, upon holding the tenancy is heritable one. But since 2 or 3 years has been left out, suit is not maintainable. I initially suit decreed, well, first appellate court reversed the judgment. Thereafter, second appeal. In second appeal, it has been held. So it is the tenancy is heritable one, and all the legal errors are required to be brought on record for the purpose of filing.
Your present appeal has been arises out of your suit. You sought for declaration that you are entitled to that.
Declaration and challenging the self-trial, surrender.
Challenging surrender and
Declaration
asking
that
for
is
injunction that they cannot
not to disturb my position.
and your collection of.
Correct.
Very good.
So, in my humble submission, since the present appellant before his lordship is the sole surviving heir of one of the co-tenants, Naim Molli. He has inherited the tenant, he has every right to protect his tenancy by filing the instant suit. And on the last occasion, I drew my lord's kind attention. The rent bill, joint rent bill, in the name of 3 names, and one of the co-tenants were entrusted to collect the rent. Your lordship, kindly have a look at page 42 of my application for injunction. It's 42.
43 years.
Yes.
Yes.
And that about your lordship, kindly have a look at the first agreement entered into by the erstwhile landlord and the 3 co-tenants. Your lordship, kindly come to page 29, Annex B. What is the intention of the landlords and the tenants? And in that agreement, the clause 16 was there. And in clause 16, it was agreed upon by and between the parties that in case of sale, the first preference will be given to my client. But during the
Clause 16, which page?
My lord, page 29, Annex B. No, Annex A. Your lordship, kindly come to Annex A.
29. Where is clause 16?
No, your lordship, just a minute. No, Annex A, your lordship, first of all, Annex A, page 22. Annex A, page 22. The first agreement entered into by the erstwhile owner and the 3 co-tenants.
Page 26.
Page 22, I am drawing my lord's attention.
26 is that agreement, clause 16.
Yes. And it was categorically mentioned that which terms or expressions
But you have not taken advantage of that. You have not filed a suit for enforcement of that clause.
That has not been filed. But so far, right now we are concerned with my right.
And you have not challenged the sale in the suit. You have challenged the surrender of tenancy and their collection of the rent.
Well, so far sale is concerned, yes, not challenge. But so far the surrender is concerned, that is under challenge.
You say they could not have surrendered without you.
No, but since the tenancy is a composite unit, single unit.
Right.
Out of 3 co-tenants, 2 cannot. 2 cannot.
Well, let us hear Mr. Ahmed. Yes, Mr.
The plaint, my lord, I had asked for the plaint on the last occasion. Yes, the plaint, my lord. What is the case, my lord? The appellant, my lord. The court below. Shall I read out the plaint?
Yes.
My lord. The suit for declaration and injunction. It originally
In A, they have claimed to be joint tenants. And that the joint tenancy is still in existence, not been
Joint
terminated?
tenants, well, they have claimed their tenancy right.
Yes.
The case of the plaintiff is that there were 3 tenants.
And right
joint
to
tenants,
rent,
Mohammed
and
Shoaib.
they have sought for a declaration challenging that surrender of tenancy rights.
Surrender.
Yes.
Now the case was that, my lord, 3 joint tenants, my lord, name of the joint tenants were Mohammed Shoaib, Mohammed Zakaria, and Mohammed Naeem Malik, who happens to be
Right.
the brother of the appellant. Now, during the substances of this tenancy, my lord, Mohammed Naeem Malik died, my lord. Now, my case is, my lord, since you have asked, you have sought for a declaration that you have become a joint tenant along with the rest of the 2 tenants, Mohammed Shoaib and Mohammed Zakaria, after the death of your brother. So he has sought declaration as a joint tenant. Because this is the case which he has made out.
Yes.
Paragraph 4, my lord, if your lordship goes to paragraph 4 of the plain, my lord, that
Yes.
subsequently in terms of the said agreement, Mohammed Shoaib, Mohammed Zakaria, Mohammed Naeem Malik jointly constructed a G+4 storage building in a portion of the said premises by demolishing the existing structure thereon at their own investment, and accordingly said Mohammed Shoaib, Mohammed Zakaria, and Mohammed Naeem Ali became the joint tenants in respect of the said G+4 storage building, as well as remaining vacant portion of the said premises by making payment of monthly rents as agreed in the said agreement, who are hereinafter referred to as the joint tenants. That after the construction of the said building, Mohammed Shoaib, Mohammed Zakaria, and Mohammed Naeem Malik jointly inducted several tenants under them as per the terms of the said agreement. The landlord also issued letter of atonement to such tenants, asking them to pay monthly rents to the said joint tenants, and since inception, they jointly collecting rents from such tenants by issuing rent receipt till the month of July 2018. That in terms of clause 14 of the said agreement, as well as an agreement amongst the joint tenants. Well, this is an agreement amongst the joint tenant, where the superior landlord was not the party, my lord. Amongst the joint tenants dated by 1984, Mohammed Shoaib was made in charge of collecting monthly rents from the tenants, and accordingly, he had been collecting monthly rents from the tenants of the said building regularly by issuing proper rent receipts on behalf of the said joint tenants. It is pertinent to mention herein that in the meantime, one of the joint tenant, namely Mohammed Naeem Malik, died intestate on 5/2/1991, who was issueless, leaving behind his widow Amina Begum and brother Mohammed Tazammul Hussain, who is the appellant herein, who were dependent upon him. Well, kindly uh, mark this line, my lord, because I'll be coming on this, my lord. Who were dependent upon him and who brought him up and had been residing with him in single mess till the time of his death as only legal heirs to inherit him, and accordingly they jointly inherited the tenancy right in respect of the said premises in place and instead of deceased Muhammad Naeem Malik, and became the joint tenants of the said premises along with Muhammad Shoaib and Muhammad Zakaria. So his case is that after the death of his brother, he has stepped into the shoes of his deceased brother, and he has become the joint tenants of the along with Muhammad Shoaib and Zakaria. The subsequently said Amina Begum, the widow of Muhammad Naeem Malik, since deceased, died intestate on this. It's a blank, my lord, and as such, Muhammad Tajamul Hussain and the plaintiff herein became the joint tenant along with Muhammad Shoaib and Muhammad Zakaria in respect of the said premises. And as per the terms of the said agreement, said Muhammad Zakaria had been collecting monthly rent from the tenants of the joint building premises by issuing proper rent receipts on behalf of the joint tenants. So all along his case has been that he has become the joint tenant after the death of his. Now, my lord, in a tenancy of a joint tenancy, my lord. The Supreme Court, my lord, there has been several judgments where the concept of joint tenancy and tenants in common has been discussed, my lord. My lord, the Supreme Court, my lord, the Apex Court has been vocal about it, that in case of a joint tenancy, once a tenant dies, one of the joint tenant dies, the survivorship will automatically will go into the rest of the surviving tenants, my lord. My lord, I'm quoting one, my lord, Supreme Court, my lord, 2018 Volume 6,
Have you got
SCC,
copies?
well, SCC 708, my lord. where the concept of joint tenancy and tenant.
Mr. Raut and Mr. Amit, both of you, we are asking both of you a question because we are virtually hearing the appeal itself.
Malad.
Whatever, whichever way this, because formally this is appearing as an injunction application.
Malad.
Whichever way we go, whether we grant injunction or we refuse injunction, that will tantamount to disposal of the appeal.
Malad.
So if you grant, give consent, both of you, we constitute this to be a hearing of the
Malad,
appeal.
I'm ready.
Mr.
Subject to approval of.
Otherwise, this, suppose we grant injunction, then for all practical purpose, you are saddled with this appeal.
Malad.
And vice versa for
Malad.
Very well. We'll just record that somewhere. Please continue. Yes.
So in this judgment, my lord, the Honorable Apex Court, my lord, discussed the differences between joint tenancy and tenants in common, my lord.
You can just place the relevant paragraphs.
Page 14, paragraph 14 is, my lord, relevant, my lord. Discussion, paragraph 14, my lord. The issue at hand is what would be the status of the succeeding legal representatives after the death of the statutory tenant. In this regard, it would be worthy to discuss the two capacities, which is tenancy in common and joint tenancy, and the rights that one holds in these two different capacities. Fundamentally, the concept of joint tenancy and tenancy in common are different and distinct in form and substance. The ingredients regarding the co-tenancy and joint tenancy are different. Joint tenants have unity of title, unity of commencement of title, unity of interest, unity of equal shares in the joint estate, unity of possession and right of survivorship. This is my case, my lord. Tenancy is common is a different concept, my lord. I'm not going to this, my lord, because my case in hand is, my lord, with regard to joint tenancy, which he has claimed to be a joint tenant after the death of one of the joint tenant, my lord. But I'm also, there's one judgment, my lord, another, my lord. Well, this is, my lord, the 78 CWN, my lord, page 19, my lord. Very similar, my lord, question of tenants in common and joint tenancy were discussed, my lord. And it was held when a sole tenant dies, his heirs inherit the tenancy as tenants common in the sense of the death of his interest will not pass by survivorship to the other tenants.
Which paragraph are you reading?
My lord, I shall, my lord, read out the relevant paragraph where the, my lord, has been discussed, my lord.
Yes. Oh, you are reading from the head note.
Well, I'll come back to the internal part, my lord.
Right. We'll continue from here after the recess.
Oh, my lord. My lord.
এগুলো থাক এখানে, এটাই continue. Yes, Mr. Ahmed, please.
I placed a judgment, my lord, CWN, 78 CWN, my lord.
Yes, yes.
But I'll read out the relevant paragraph, my lord. But I'm extremely sorry, my lord. It's hazy, my lord. Paragraph 11, hazy, my lord. But still, I'll read out page. I mean,
Solid.
yes. But it is clear from the above statement of law that as present at between the heirs themselves, they are tenants in common, but joint tenants in the sense that on the death of one, his interests will not by survivorship to the ownership, but would devolve on the heirs under the law. In case of joint tenants, on the death of one, his interest of the tenancy will pass to the other joint tenants by survivorship.
Right.
But I'm reading out the paragraph 12 also, my lord. But because this judgment was based on a judgment of Kanji Manji's case, and my lord, which was discussed in this judgment, my lord. But I'll not read out the whole
Please not
paragraph.
read
my lord.
out,
But I'll read out from the last, my lord, from this in Kanji Manji's case, my lord, has a lordship.
Yes, Kanji Manji.
Before the Supreme Court, the joint tenancy was created in favor of two persons, namely Kanji Manji and Rupji Jeoraj. These are two persons. Those two persons were joint tenants in the true sense of the term, namely, on the death of one of the tenancy would pass to the other by survivorship. What happened in that case is that the notice to quit was served on both Kanji Manji and Rupji Jairaj. The suit for ejectment was filed against both Rupji Jairaj and Kanji Manji, but later the plaint was amended by striking out the name of Rupji Jairaj, who died much earlier. It was contended before the Supreme Court that a notice to quit was invalid, it has been served only upon only one of the lessees, Kanji Manji, and not upon the heirs and legal representatives of Rupji Jairaj, and the suit was bad for non-joinder of the heirs and legal representatives of the Rupji Jairaj who were necessary parties. The Supreme Court held as follows. The argument about notice need not detain us long. By the deed of assignment dated February 28, 1947, the tenants took the premises as joint tenants. The exact words of the assignment were that the assigners do and each of them doth ever assign and assure with the assignees as joint tenants. The deed of assignment was approved and accepted by the trustees of the Port of Bombay, and Rupji Jairaj and the appellant must be regarded as joint tenants. The trial court therefore rightly held them to be so. Once it is held that the tenancy was joint, a notice to one of the joint tenants was sufficient, a suit for the same reason was also good. It is evident from the aforesaid observation of the Supreme Court that on the death of Rupji Jairaj, the tenancy passed on to Kanji Manji by survivorship. Otherwise, the suit would not have been held to be maintainable.
Yes.
1 of the case, my lord, it's not a judgment, it's not a site, I mean, it's not from any, my lord, I have downloaded it from a, my lord, website, Indian Kanun, my lord, whether, that is why I'm not placing
But
it.
this is sufficient.
My lord, I'm
On
not
this
placing it.
proposition, at least this.
My lord.
And regarding brother not being an heir, you
My
also
lord,
said something.
now, coming back to the
other point.
my lord, 56 Act, my lord.
Yes.
Very specific, section 2H, my lord.
Yes.
My lord, your lordship had, my lord, if your lordship, my lord, I have a book, my lord, it's very old.
No, the equally old.
We have.
Your lordship had.
Our books are equally old, so don't worry. Yes.
Statute itself is old.
It's probably as old as the act.
As old as the act.
Yes, Mr. Ahmed, what is your
tenant, my lord? Definition of the
right.
tenant, my lord. My lord, tenant means any person by whom or whose account on behalf the rent of any premises is, or but for a special contract would be payable and includes any person continuing in possession after the termination of the tenancy. This will not come here, my lord. Or in the event of such person's death, such of his heirs as were ordinarily residing with him at the time of his death. The language is, my lord, such of his heirs as were ordinarily residing with him at the time of his death, my lord. My lord, the defendant, the appellant, my lord, claims to be the brother who was dependent upon the deceased brother, my lord. It will come, if I read out the plaint, my lord. It is in paragraph 8 of the plaint, my lord, which I had earlier, my lord, pointed out, my lord. It is pertinent to mention him that in the meantime, one of the joint tenant, namely Muhammad Naeem Malik, died interstate on 5/2/1991, who was issueless, leaving behind his widow Amina Begum and brother Muhammad Tajammal Hussain, who were dependent upon him and who brought him up and had been residing with him in single mess till the time of his death as his legal heirs to inherit him, and accordingly they jointly inherit the tenancy right, my lord. Well, coming back to the, my lord, the statement made by the appellant, my lord, he was dependent in the year 1991. He was dependent upon his brother, my lord. My lord, kindly see the affidavit, my lord. From the affidavit portion, your lordship will find the age of the appellant, my lord, 72. If we go back to 1991, in that period, his age was something around 45 years. And he is a legal practitioner, my lord. His affidavit portion says by occupation legal practitioner. So whether this can be believed that at the age of 45, being a legal practitioner, you were dependent on your brother, that has to be looked into, my lord.
But to age does not say dependent.
The new act says, but the new act says
New act
1980.
here
Because
that is
because
applicable
it
because
was
of
because of the 1997 Act, because 97 Act has incorporated few
not applicable
few
in view of,
criteria, my lord, which was that one
not
of the death,
applicable in view of Rajesh Mitra's case because
my lord.
so this does
So
not
they had
contemplate dependent.
while drafting the
They were
plaint,
overzealous.
my lord, that has been done.
But in any event, you say that, I mean, ordinary residing or not, it does not come in. Joint tenancy is there.
because of the age, my lord. But it's unbelievable, my lord.
No, that is on dependence.
Dependence and
He was an heir.
he as per the
To
Mohammedan
age
law, my
says
lord.
heir. To age says heir.
To age
Brother,
says,
apart from the mother, nobody.
my lord, the language is, my lord. The language is, my lord, such of his heirs
who are residing with him at the time of
at
his
the
death.
time of death.
So they
The wife
plead
was
that.
residing.
They plead that. They plead that.
That pleading is there, my lord. But whether that pleading is believable or not, I leave it to your
Why
lordship.
not
My lord.
believable?
My lord,
One's brother may reside with him. What is the harm in that? Or
residing, my lord, whether residing at the suit property or whether residing at another property. That's a different query.
why is it not credible that the
But
brother was residing with him?
My lord,
they have pleaded in para 8 that the brother was residing. He was residing.
he
with
was
his
residing, my
brother.
lord. But that I have. I mean, I don't. The credibility of this statement is
the injunction stage. At least, why is it incredible? I mean,
that
a brother can reside. Many people reside with their brother.
The language is, my lord, at the time of his death, he was residing. But residing where? Whether he was residing in the suit premises or whether he was residing in some other place at the date of
the
place of his
tenant
death.
was obviously residing at the suit premises. He says
No, he does. But the fact is that he does not reside there, my lord.
That
even
will
the
be decided
tenant
at a
never,
later
even the tenant never resided. Even the tenant was not residing in the suit premises. My lord.
Have you in your written objection did you point this out to the injunction?
Well, I have only challenged the, my lord, written statement. I have challenged his claim, my lord.
No, injunction application. This is we are here. The injunction application was decided by him. You did not file a written objection.
I filed it.
In that, did you point out that
This
they resided
this
elsewhere?
specific
is not
avertment is not there, my lord.
Anyway, very well. So very well. Let us hear him on reply. Yes, Mr. Raut, judgment.
On reply, my lord.
Joint tenancy.
No.
Everywhere in your plenty have claimed joint tenancy.
Yes, my lord. In reply to that, your lordship kindly have a look to my lord, the agreement entered into by and between other co-tenants in the year 2012.
Why should you look at those agreements? Your pleading is there in the plaint. Joint tenancy.
Not only that, my lord, the heir of the one of the co-tenant, Naeem Malik, his widow and younger brother, was accepted to be the co-tenant with the other two co-tenants.
Your plaint pleading says they were joint tenants everywhere. You seek a declaration of joint tenancy.
Yes, madam.
Then why shouldn't the principles of joint tenancy as opposed to tenancy in common prevail?
Not tenancy in common.
It's your plaint case on the, and the injunction has to be on the basis of your plaint case, not beyond that.
Yes, that's to so far the initial tenancy, your lordship, it is a purely joint tenancy because the tenancy created from the very beginning in the name of three.
If it is a joint tenancy, then these judgments should prevail.
Which judgment?
The judgment is just not cited by your learned friend. A joint tenancy does not survive on the heirs. It survives back to the other joint tenants. It's a unity. There is unity of possession and survivorship.
That even your lordship kindly consider the conduct of the parties. Conduct of my client and the widow of the other co-tenant accepted. They enter into agreement.
Where is that contract?
Your lordship kindly page 37. Agreement dated 11 May 2012. After the death of one of the co-tenants, his widow and younger brother was accepted to be co-tenant along with them. Your lordship kindly come to page 37.
Accepted by the landlord.
Landlord, other co-tenants. Other co-tenants. There is an agreement entered in after the death of the one of the co-tenants.
Here also you describe yourselves as joint tenants.
My lord. Well, even after the death of Naim Malik, one of the co-tenants, his widow and my younger brother were accepted.
You know what I mean? You.
My lord. Accepted. And accordingly they acted. Paid rent, collected from the subtenants. There is no dispute about it. No dispute about it. Even the erstwhile, one of the owner, they never challenged. They never raised their objection. So far, one of the agreement of 2012 is concerned. It was very much within the knowledge of the erstwhile owner. So, in my humble submission, so far the principle enunciated in that 98 CW, that is not at all. Because here the facts is altogether different. Everything, both the co-heirs, the heirs of the deceased tenant was accepted. It is known to everybody. So at this stage, they cannot, after all, they are strangers. They have purchased the property during the subsistence of my tenancy. Creation of tenancy, never, no dispute, nothing of this sort. Nobody disputed. The agreement was accepted by all.
Where have you pleaded about that agreement?
Well, I have agreement.
Or that you were accepted as joint tenants? Yes, para 10. Plaint.
Everything was a settled position. And at this stage, we are at the stage of interlocutory application, injunction application. The complicated question should not be taken into consideration at this stage. There should not be any mini trial. Everything will be decided on trial. Whether I was residing with my brother or not, what is my status, and who used to pay rent, who used to collect and everything. On trial, it will be decided.
Good. We are closing arguments on this. On consent of parties, both the appeal and the application are taken up for hearing together. Heard learned counsel, hearing is concluded and judgment is reserved. We'll pass judgment very soon, as soon as.
Good.
Next week, not before next week. Thank you. Very good argument, Mr. Ahmed.
No.
Yes, Mr. Raut.
May I take back my...
Yes, you definitely may.
নতুন নিয়েছেন
Courts have the habit of... Yes.
Appellant petitioner, my lord. An application.
Why are you so morose, Mr. Ghosh? What happened?
My lord, application for a stay of the final degree proceedings has been filed. Copies have been directed to serve upon the respondents. We have served. They entered appearance. So in the meantime, my lord, lower court have been directly called forward. We put the special method cost to bring the LCR and paper preparation has already been done. In the meantime, on 29th August 2025, they put the final degree into executions.
Actually, you have not put in Tolobana and all regarding 2 to 16, 18, 22.
But the
That's the office
Tolobana
report.
okay.
1 and 17 are represented to council. Caveat.
At the special representation
There's an
cost,
office
there is a delay. We have deposited. It was conducted on 17th April 2025 order.
17th April?
17th April 2025.
Just check.
In terms of the earlier order,
17th April
2025.
of this year too.
24.
Okay, 17th April.
17.
Order active.
2025.
সামনের order, পিছনের order. No, that was condonation of the special.
Yes. It was delay was condoned in putting the special measure cost. 17th April 2025 order.
Special messenger cost was condoned.
Yes.
Not the Tolobana. Tolobana you have not put in at all.
Well, we have served the applications to speech.
The appeal, Tolobana. Notice of appeal, notice of hearing of the appeal. What is this application for?
Application for stay of the execution, final degree proceedings.
You have challenged what? Oh, partition suit.
Partition.
But
appeal has been on 4th April 2024, and there is an order of direction of to bring the lower court records and the papers and paper.
You are enjoying an interim order.
There is no interim order.
Why did you file an application so late?
Application filed
had filed previously. You did not move it earlier?
No, why not?
In 2024, when those orders were passed,
No,
those were passed in. So it was not granted to you, deemed refusal.
But, that application was not placed. Now they started the execution proceedings. Keeping
at that point of time, there was no execution case.
No, right now. Well, kindly see this. 5 of 2025.
What? You have soft copies on all?
Yes.
All have received?
Yes. All.
Affidavit of service filed to be kept on record. Full although Can 1 of 2023 was filed in the year 2023 for stay of operation of the impugned decree, the same was not moved earlier. However, learned counsel appearing for the appellant submits, by handing over a certified copy of the tabular statement filed in connection with an execution case, that during pendency of the appeal, execution has been levied in connection with the impugned decree, thereby creating an urgency to move the matter. Next para. From the affidavit of service filed today, which is kept on record, we find that due service has been effected on the respondents. Next para. Since the appeal involves both questions of fact and law, we hold that a prima facie case for hearing of the appeal on merits has been made out. Accordingly, Can 1 of 2023 is allowed, thereby granting stay of all further proceedings in title execution case number 05 of 2025, pending before the learned civil judge, senior division, 3rd court at Paschim Medinipur is the district.
Paschim Medinipur. The court is 3rd court. 3rd court senior division.
Yes, 3rd court senior division at Paschim Medinipur, district Paschim Medinipur till disposal of the appeal. The appellant shall put in the Tolobana in respect of respondent numbers 2 to 16 and 18 to 22 within a week from date.
And
special messenger cost and paperwork directions were there. So Talabana, please put in immediately within a week, but do it by tomorrow.
Understood.
Thank
A certificate copy may be kept to the record.
Yes, you have said that certified copy handed over in court. একটা line add করে দিও, the certified copy of the tabular statement file to be kept on you.
Yes, I'll be able to.
Thank you.
আগে কারণ আগে কারণ তাদেরকে যে আর্গুমেন্টস ছিল ক্লিয়ার হয়েছে পড়া যায় এদিকে
Item number 16, I am for the respondent. This is my application. Can
For the applicant, I'm praying for 1 week accommodation to file an affidavit.
What is the application for?
Malas, the application is malas formal and innocuous pair. Malas, your lordship has directed stay upon payment of malas occupational charges. Malas, they have not paid any occupational charges. So malas, we filed this application to permit us to proceed with the execution case. That is the only prayer.
Can 4?
Can 4.
What is our order? You have annexed that?
Yes, my lord. Primarily, my lord, your lordship. Kindly come to page 10. This is the first order of your lordship. That your lordship has granted stay upon occupational charge to be determined. And thereafter, page 13 is the order by which your lordship has fixed the occupational
In
charge.
default of the payments, the stay order granted above shall stand automatically vacated.
Yes, my lord. Page.
Where have you alleged that they are not paying? In the which paragraph?
Yes, my lord.
They did not make any payment?
No, my lords.
Not a single payment?
Not a single payment.
You have not paid?
My lord, as per the instruction of the advocate on record.
No affidavit. We will just vacate this stay. Sorry, prayer refused. Have you instruction whether this you have made any payment?
I have no further instructions, my lord.
Who is the advocate on record? Where is he? You are the advocate on
No,
record?
no, my lord, no, my lord. As per the instruction of her, I'm praying for accommodation for 1 week. Kindly, my lord.
Who is your advocate on record? Who is the advocate?
Miss Joy Maite. Joy Maite.
Where is she?
She's sick. She's suffering from.
Can 4 of 2025 has been filed for appropriate orders. Full stop learned counsel for the plaintiff stroke respondent submits that by an order dated February 11, 2025, passed in the appeal, comma, stay in respect of operation of the impugned eviction decree and connected execution case, comma, if any, was granted till disposal of the appeal, subject to the appellant paying to the respondent occupation charges to the tune of rupees 20,000 per month. Full stop. However, comma, it is submitted that no such payment, comma, either current or arrears has been paid. Full stop. It is pointed out that in paragraph number 17 of the said order, comma, it was recorded that in default of the above payments, comma, current or arrears, comma, the stay order granted therein above shall stand automatically vacated without further reference to the court. Full stop. Next para. At the juncture when the application is moved, comma, an adjournment is sought on behalf of the appellant, comma, seeking leave to file an affidavit in opposition to the application. Full stop. However, comma, on query of court, comma, the learned advocate seeking adjournment fails to apprise the court as to whether any payment has been made in terms of the order dated February 11, 2025. Full stop. However, comma, since the appellant seeks an opportunity to file an affidavit in opposition, comma, we direct the appellant stroke opposite party to file affidavit in opposition, file his affidavit in opposition to the application within May 20, 2025.
Grateful, my lord.
Reply, if any, shall be filed by within 2 days. File it by May 22, 2020. Oh no, we don't have. Acha na, very well. Opposition time ta May 20 na kore filed within May 23, 2025. Full stop. Reply, if any, shall be filed within June 13, 2025. Full stop. The application shall next be listed on June 16, 2025. push up. However, comma, in view of the appellant having failed to produce any iota of papers to indicate that any payment in terms of the order dated February 11, 2025 has been made, comma, the respondent stroke decree holder shall be at liberty to proceed with the connected execution case during pendency of the application.
Grateful marks.
But I'm for the appellate.
Yes, Mr. Mukherjee.
That on the first day, your lordship has recorded an order that the suit has been decreed. I have been restrained from disturbing the common partition wall and adjoining common passage. Adjoining passage. Lord, I am not on that. Lord, what is there the difficulty? One part of the adjoining Lord wall, partition wall, is just affixed to the structure standing over there. So if I want to Lord construct anything within the bounded area which has been allotted in my favor as per partition deed, because initially the parties are claiming their respective right, Lord, flowing from a partition deed executed between the parties.
Just remind us, Mr. Mukherjee, this is their partition suit.
It is their suit for declaration and permanent injunction.
Declaration to the effect
Declaration to the effect that I don't have any right to disturb the common partition wall as per the partition deed executed between the parties, adjoining passage.
And from making construction.
And from making construction,
4 feet passage.
encroaching upon 4 feet without leaving 4 feet passage.
So on the last occasion, you said something regarding you will make construction.
I will make my construction
there.
for the purpose of delineation and demarcation. Lord, your lordship knows nowadays, Lord, the corporation is also a party to the suit. Corporation will not give me any sanction building plan, or even I will not be Lord allowed to apply until and unless a demarcation will be there in respect of the boundary line. So I cannot demarcate it without touching the boundary wall. So that's why my apprehension is that the court has already restrained me. I will also do not want to do that without the leave of the court. Today I filed the appeal. I have prayed for an appropriate order in the guise of appropriate order, appointment of a special officer from your lordship's court, wherein my learned friend Milord has joined an issue that instead of a special officer, it should have been Milord a structural stability engineer who will assess what is the Milord stability of that Milord the adjoining partition wall, and thereafter I may be allowed to demolish Milord only those portion which is affects to my Milord building.
Without
disturbing their stability of the building or Milord the partition wall. Immediately thereafter, I will reconstruct it, and Milord, I will whatsoever I make construction, I will leave Milord 4 feet Milord as per the statutory mandate. Kindly now takes up Milord my prayer once. I shall take your lordship to their opposition also. If your lordship takes up Milord the can 1. Page 6, Milord.
So if you comply with that, then the entire appeal can be disposed of. Yes. If they agree to that. Yes.
And they have Milord already filed the last occasion and affidavit in opposition to this. Milord, if your lordship
Their objection is that structural engineer should be.
Milord, that is Milord.
Yes, Mr. Ravikaji, what do you say?
So first of all, what my learned friend just submitted, that there is no demarcation in the partition deed.
You are Ms. Mukherjee Roy Chaudhary?
Mrs.
Mrs. Mukherjee Roy Chaudhary.
I carry my father's name also and my.
We have to choose one. We cannot continue calling you Mrs.
Lordship will
Mrs.
choose.
Mukherjee Roy Chaudhary.
Lordship will choose.
Anyway, yes.
Lordship, in the partition deed, when the mother premises number 30.
No, they say they'll comply with the decree. Basically, what they say is they have to comply with the decree.
My learned friend just submitted that there is no partition and the boundary has not been demarcated. It is not correct. When Lot Ko and Kho had been said has been mentioned as per the partition deed, the boundary has also been mentioned. And that is what the Lordship here, my learned friend has annexed to that in the CAN application, and it goes and the plan will also show that. So it has been rather in the development agreement, what they have stated that the schedule, it is comprising my property. where it heated my client to file the suit. I have the development agreement also, and where it gives the mother premises number, not my premises number.
But Mr. Mukherjee, if you agree to that, then what is the scope of challenging the appeal?
No, my lord, what I say.
That is the decree precisely, that
Today-
you are restrained from making
today, my lord,
construction
my
on
previous-
scheduled property by leaving mandatory 4 feet space from the
Yes,
boundary.
but I cannot touch, my lord, I cannot touch the boundary wall.
Yes.
Boundary, yes. My lord, that is the difficulty. My lord, the boundary wall is just affixed to the, my lord, it's a, your lordship knows the old, my lord, North Calcutta buildings. My lord, adjoining, it's a single building which
Your
is standing,
present structure touches the boundary.
touches the boundary
Their
wall.
present structure also.
Yes.
Lordship, I filed a photographs. The portion
That is not disputed by my learned friend also.
Let us see the photographs.
Lordship, my learned friend has annexed some at page number 82, which I believe is a black and
Should
white.
look
one.
at his photographs or your photographs? Choose.
So my photograph.
We are there, page 32.
Page number 32.
Yes.
32, Lordship. This portion
That is
is
the
mine.
boundary wall. We can't find the boundary wall.
This one is the partition wall. This Thakur Dalan portion is the boundary wall. This one, red color.
One portion already demolished.
This is from my
This
side.
is-
After the courtyard is the boundary wall. That is from my portion, 30B, Fakir
That,
Chakraborty Lane.
that structure with the arch, that is itself the boundary wall.
It is the boundary wall. It is a two-storied building. It is a two-storied structure, and it has been mentioned in
Is
the.
there any photograph from their side?
Yes, Lordship. Lordship, 32.
82 is the present situation of my application.
32. This from their side. Beneath the lower one.
Hmm.
That is, and this window is mine. And it has been stated, mentioned in the partition deed.
The balcony belongs to them. Pink. Left hand photograph.
Left is the common passage.
No, page 32.
Page 30.
That pink balcony belongs to you or him?
Me.
This is from your side. then.
U-shaped structure. My portion is a U-shaped one.
Where is their portion? The right
That
side?
that is behind the green color.
The other side of that.
Other side of that.
Very well. Let us see from their side.
From my side, not page 82.
82 is from your side.
Yes.
And 32 lower.
That is the structure. That is the boundary wall. The other side of the boundary wall.
Yes. Other side of
So
the
your
boundary wall.
structure is not touching it. Where is your structure touching it?
Lordship, I believe this portion, this portion.
Which page is that?
At page number 33 of my application, of my opposition.
Yes, that portion.
Your Lordship will find a window,
Hmm.
and there is a wall just at perpendicular to the boundary wall. I believe that portion they have not demolished. They have demolished the entire portion. That had caused a huge damage to my portion also. Because the Kori Boroga and all are in one length with the main structure.
You can appoint a structural engineer
Yes,
to
my lord. From kindly do that, my lord.
And
Later
it will be-
independent report comes because I do not want. I have a right to enjoy my portion of the property. I
No
want
one
to
has
make.
hindered
Yes,
that.
yes. That's why, my lord. I do not want to, my lord. Also,
So you can appoint a structural engineer from the
from
panel,
your lordship's
panel of engineers of our.
Yes.
Boy is swearing this affidavit, 24 years old, and he's saying that what happened.
24-year-old is no longer a boy.
Lordship 24
From
for
our
me,
perspective, maybe a boy.
for me, Lordship 24-year-old
And-
boy man is coming up and saying that in the year 1972 no repair work has been carried on, and that is true to my knowledge.
72.
But
It's
the
very
developer- the
old
developer-
sentiment, my lord. The old building, my lord. They are not ready and willing, my lord,
And
to allow us.
how is it
But
related?
that's
Nothing. The developer has got the power of attorney. He had never come to the court, nor deposed, nor has affirmed this affidavit. Only showing that two ladies are suffering from.
Kaji, why don't you
terminal-
ascertain from our panel? I mean,
Lord, from your lordship's, Lord.
there's a common panel with the registrar. You'll find it. You,
Then
both of you agree to a particular engineer.
Lordship, it is a 20 feet.
You agree to an engineer from our panel. You'll
Yes,
find
yes.
it with the office of the with the registrar's office.
Lord, your lordship can make it that portion blank, my lord. We shall both of us, my lord, inform your lordship what is, my lord, the agreed, my lord, the name of the.
When will you inform us? Today itself, then.
আমি
tell.
জানি না।
If you don't file, we'll put in a name. We'll find out.
Lordship.
So how long will it take to complete the construction? We don't have any idea.
My lord, first a limited
Inspection
report we filed before your lordship. Thereafter, your lordship's direct, my lord, to undergo this, my lord, entire exercise under his supervision.
And in presence of both the parties.
Definitely.
The present appeal has been filed against a decree whereby, comma, inter alia, comma, the appellants have been restrained by permanent injunction from making any construction on the B schedule property of the suit, comma, which is admittedly owned by the appellants, comma, by leaving mandatory 4 feet space from the common boundary wall between the said B schedule property and the adjacent A schedule property, comma, the latter belonging to the plaintiff stroke respondents.
No, Lordship. B schedule A schedule is my learned friends. The 30A is A schedule and 30B my property is B schedule.
A is theirs.
A is theirs.
A is
B আর এটা উল্টে দাও। Bটা আর এটা উল্টে দাও। Next paragraph. Learned counsel appearing for the appellants submits that the appellants are agreeable to appointment of a structural engineer as special officer to supervise the construction made by the appellants in order to avoid any unnecessary complications and stroke or allegations of violation of the said decree. Full stop. In principle, comma, the respondents also agree to a structural engineer being appointed to ensure the safety and security of the existing structure on the respondent's side of the property. Push up next para. As such, comma, we hereby appoint blank, comma, an engineer from the panel of engineers of this court as special officer to hold an inspection at the suit premises for the purpose of assessing the possibility of the appellants making construction in terms of the impugned decree, comma, by leaving 4 feet space from the common boundary wall between the B and A schedule properties, comma, without, comma, in any manner, comma, adversely affecting or disturbing the structural stability of the existing building standing on the yours is B,
Mine is
on the B schedule property. Push up next para. Both parties shall cooperate with the said special officer. Push up. The special officer cooperate with the special officer in that regard and furnish copies of the relevant documents in order to enable the special officer to hold such inspection in presence of both the parties and or their authorized representatives. Push up next para. Such inspection shall be held upon prior notice to the learned advocates for both the parties, comma, within May 30, 2020, May 31, 2025. During the vacation also.
Yes. You know, only one thing, Lord. My apprehension, Lord, my prayer is with regard to the other part, this is a vacant land. Lord, the feasibility of allowing me to make construction, your Lordship has specified, let them, Lord, let the engineer
Without
do
disturbing
that.
their structure.
Yes, let the engineer do that. But Lord, page 6, my prayer is the southeastern part of the boundary wall, that is, Lord, adjoining to both the buildings.
Yes.
So that I wants to.
You will assess the possibility of you making construction on your portion without disturbing the structure.
As per the prayer of the application itself. Not application prayer is only with regard to that portion. Otherwise, other portion, Lord, without disturbing my learned friend's property, I can do that. But kindly see once, Lord, for my satisfaction, Lord, page 6 of the Can 1. This I want, Lord, under the supervision of a special officer. Because once I touch that, they will say I am violating the court's order.
So, Mr. Mukherjee, he will inspect the entire thing and see whether the other portions.
This also. Lord, this is the crux.
This is obviously included.
Kindly, Lord, otherwise the special officer can say the court has directed how you can make construction without disturbing. But once, Lord, I have to touch the schedule. That's why I undertake. I have to touch it, but I will reconstruct. Whether that is feasible or not, That the special officer will say.
31 to 25.
So that my objection is in my affidavit opposition in page number 20. That's what I've stated regarding that.
That's why structural engineer. That's
To engage a registered structural engineer of the Kolkata Municipal Corporation to inspect in presence of both the parties and furnish report as to whether the alleged demolition intended to be carried out by the appellants shall affect the structural stability of the common partition wall as well as my property on the northeast portion of my property, which is attached with the adjacent partition wall.
Yes.
Because
But
the
that
Korikoroga and the beams is what was a one structure, 30.
Their pair is that scheduled only reason for prefer. This is
No,
a
Lord, Your
prayer.
Lordship, kindly ignore those
Only
portions.
reason for preferring and all this.
No, Lord, kindly.
But what is your prayer?
But in the Honorable Court, in
How will
respect
you
of the
couch the
Schedule
order?
D boundary wall and some old structure of southeastern corner of the Schedule A property, which belongs to the petitioner, are attached with the common portion of the wall being D schedule property. And while carrying out such demolition of the old dilapidated structure, even some portion of that common partition wall
So
being
we can
D schedule,
couch it as if including the portion of the appellant's property touching the
D schedule common boundary wall.
that will do.
Yes.
যেখানটা বলেছি structural stability of the portion occupied B schedule বললাম including the portion of the no, that would not mean anything. You already have an existing structure. You have to make a the new building has to be by leaving 4 feet common space from the common boundary wall. We are in our direction is more comprehensive. We have said the special officer will ascertain the possibility of making construction by leaving 4 feet space from the boundary wall without disturbing the structural stability of their portion of the property. That includes everything, whatever is there.
But Lord, I have to demolish the A schedule remaining structure.
That is what he will.
Which is facing.
That is what you will see. That is the only. Actually, he has to inspect that only. But he will inspect the entire thing. He has to see whether the possibility of making your construction without disturbing the structural stability of their portion. So at the time of inspection, you point out that also. And we can incorporate probably that making the new construction on your portion upon demolition of the existing construction. যেখানে making new construction which commissioner যেটা দেখবেন আর কি special officer making new construction on the scheduled property upon demolition of the existing structure touching the descheduled boundary wall.
I'm extremely good.
The matter shall next be listed on June 16, 2020, June 10, 2025, when the special officer shall file a report in writing as to the outcome of such inspection upon circulation of advance copies of the same to the learned advocates on record for both the parties. Remuneration has to be paid. The remuneration, what we don't know the rates. We will keep that also blank. The remuneration of the special officer is hereby fixed at rupees such and such. You have to bear the expenses.
Yes.
Comma to be borne by the appellants. Push of such remuneration shall be paid on the date of the inspection.
Right. Whether not my advocate on record, not both the side will inquire or your lordships not regarding the name from your lordship.
Please inquire also. If you can, please just mention before rising.
Very well. Right.
It will be easier for us. Otherwise, we will have to take some time. We cannot sign this order today.
Yes, sir.
And if you can, you can tell the whoever person is there in the office that we have inquired, and about the fee structure also you can just have an inquiry.
Very well.
Both of you can ascertain, you can agree on a name. That will be easier for us.
Very well. Great.
Thank you. Do it before we rise.
Yes, yes.
Right.
Yes.
Or I beg to appear on the appellant petition of mine.
Yes.
My application for injunction, my lord. My mother executed deed in my
You're
favor.
appearing before this court after a long time, sir. Yes.
My lord, a will was authored by my mother in my favor. I made an application for grant of the said probate of the said will. I suffered before the learned court bill. Against that, I am before your lordship. After that, I suffered before the learned court below.
It was rendered contentious.
Yes, yes.
Suit was dismissed.
Suit was dismissed.
Will execution was disbelieved or what?
All of the learned court below dismissed my application for probate primarily on two grounds.
Yes.
First ground is that there was a deed, there was a will by my mother previously. Why my mother has executed the second will, no reason has been given. Although the will was a registered will.
That was constituted to be a suspicious circumstance.
Suspicious circumstance.
So what do you want now? Injunction?
Injunction is that since I have suffered, the opposite parties are trying to make third party interest in respect of the properties in question. Against that, I am before you, lordship.
The present appeal has this is for the first time.
Yes, this is for the first time.
The present appeal has been preferred against the dismissal of a contentious probate suit filed by the appellant, full stop. Since questions of both facts and law are involved, comma, we find that a prima facie case for grant of injunction has been made out, full stop. Moreover, comma, unless an injunction in the nature as prayed in the application is granted, comma, the appellant will be at the risk of suffering irreparable injury and the appeal might be rendered infructuous. Accordingly, the respondents and or their men and agents are restrained by an order of injunction from transferring, alienating, encumbering, and or creating any third-party interest in respect of the suit property and or changing the nature and character thereof, as well as from parting with possession of any portion of the property which is the subject matter of the disputed will till disposal of the application. The appellant shall serve copies of the application on the respondents, indicating that this application will be listed next on June 11, 2025, when an affidavit of service to that effect shall be filed by the appellant.
I'm grateful to him.
Yes. हाँ, बोलो. Opposition you have filed?
Yes, we are already filed.
Can 3 you have directed already to appear? Can 3 to appellation appear? It yes. হ্যাঁ বলুন
My lord,
অ্যাপিলটা কিসের বিরুদ্ধে
defaulter, nuisance, damages and illegal construction bath and privy.
সবকটা গ্রাউন্ডে আপনার এগেইনস্টে উচ্ছেদ
আমাদের
হয়েছে
এগেনস্টে, হ্যাঁ।
আচ্ছা তো এখন কি এটা স্টে অ্যাপ্লিকেশন
হ্যাঁ, একটা যেটা অর্ডার হয়ে গেছিল ইজেকমেন্ট, ওটা স্টে আছে। এবার আমি
অকুপেশন চার্জ
অকুপেশন চার্জ নয় মাই লর্ড, কারণ ওনারা কোনো জায়গায় অকুপেশন চার্জেসের ব্যাপারে কোনো কথা বলেননি। হঠাৎ করে অকুপেশন চার্জেসের ব্যাপারে এখন ওনারা তুলে ধরেছেন যে অকুপেশন চার্জেসের ব্যাপারে অ্যাকচুয়ালি যা যা এলিগেশন ছিল পুরো টোটাল প্লেন থেকে শুরু করে
অকুপেশন চার্জ হচ্ছে যে প্রভিশনে আমরা অ্যাপিল স্টে দিই অ্যাপিলের কানেকশনে, যে আইনের যে ধারায় তাতে বলা আছে যে যে কোনো কন্ডিশন কোর্ট ইম্পোজ করতে পারে যখন স্টে দিচ্ছে। যখন যেহেতু ওরা একটা ডিগ্রি পেয়ে আছে, আপনি অ্যাপিল করেছেন, এখনো জেতেননি অ্যাপিলে, অ্যাপিলটা আপনি জিততেও পারেন, হারতেও পারেন। যতদিন অ্যাপিল পেন্ডিং আছে ওরা তো ডিগ্রিটা এনজয় করছে, আমরা স্টে দিয়ে সেটাকে আটকে দিচ্ছি। তার জন্য অকুপেশন চার্জ হিসেবে আমরা কন্ডিশন হিসেবে দিতে পারি। অনেকগুলো জাজমেন্ট আছে সুপ্রিম কোর্টের, অকুপেশন চার্জ আমরা অ্যাসেস করব আপনারা যে কাগজপত্র দেবেন তার উপর। অকুপেশন চার্জ কন্ডিশন অফ স্টে হিসেবে এভিকশন সুটে মাস্ট।
মাই লর্ড,
আগে চাওয়ার চাইর ব্যাপার না।
হ্যাঁ আচ্ছা মাই লর্ড, আমরা তো রেন্ট কন্টিনিউ দিয়ে যাচ্ছি, কোনোদিনই আমরা ডিফল্ট করিনি।
ডিফল্টের কোনো ব্যাপার না, এটা হচ্ছে এখন অকুপেশন চার্জের নিয়ম হচ্ছে যে এখন আজকে দাঁড়িয়ে ওরা ওই প্রপার্টিটা যদি ভাড়া দিতেন ওই জায়গাটায়, তাহলে ওনারা কত টাকা পেতে পারতেন সেইটা, সেই কোয়ান্টামটা ফিক্স হয় অকুপেশন চার্জ হিসেবে। আপনার স্টের কন্ডিশন হিসেবে। সেইটা আমাদের দেখতে হবে আজকে দাঁড়িয়ে মার্কেট রেন্ট ওখানে কত, ওই প্রেমাইসটা কত বড়, কি ডেসক্রিপশনটা কি, যে প্রপার্টিটা নিয়ে মামলা সেটা ডেসক্রিপশন কি, একটা ঘর না দুটো ঘর, কি আপনাকে জিজ্ঞেস করছি।
একটা ঘর,
একটা
একটা
ঘর কোন
ঘর,
ফ্লোরে,
ফার্স্ট ফ্লোরে।
কোন এলাকায়?
এটা বিবেকানন্দ রোড, সরকার লেন, ওইখানটাতে।
ওটা তো কমার্শিয়ালি এক্সপ্লয়েট করা যায় ওই এরিয়াতে, তাহলে তো
মাই
ভালোই
লর্ড,
অকুপেশন চার্জ।
মাই লর্ড, একটা এগ্রিমেন্ট আছে, এগ্রিমেন্টটা আপনি কাইন্ডলি 19 নাম্বার পেজটা একটু দেখুন, তাহলে আপনি বুঝতে
আপনার
পারবেন।
রিপ্লাইয়ে
না, ভলিউম পেজে যে 19 নাম্বার, ওখানে একটু দেখুন, ভলিউম 1, 19 নাম্বার পেজ।
ইয়েস, হ্যাঁ বলুন।
মাই লর্ড, থার্ড পেজে একটা দেখুন,
এটা কি
ওখানে।
আপনাদের এগ্রিমেন্টটা?
হ্যাঁ, এটা আমাদের আমাদের এগ্রিমেন্টটা, মানে এগ্রিমেন্টটা কিভাবে হয়েছিল সেই এগ্রিমেন্টটাই আমি একটু জাস্ট কোর্টের সামনে তুলে ধরছি। যে এখানে আছে লাইসেন্স বেসিস ফর হার রেসিডেন্সিয়াল পারপাস টিল হার ন্যাচারাল লাইফ টাইম। পরের লাইনেও দেখুন মাই লর্ড, যে ডিউরিং হার লাইফ টাইম ফর হার রেসিডেন্সিয়াল পারপাস অনলি। তারপরে 20 নাম্বার পেজেও ফর হার রেসিডেন্সিয়াল পারপাস অনলি অ্যান্ড ডিউরিং হার ন্যাচারাল লাইফ টাইম।
আপনাদের রেসিডেন্সিয়াল পারপাসে দেওয়া হয়েছে সেটা,
হ্যাঁ, আমাদের।
সেটা সেটা কথা নয়। কথাটা হচ্ছে আজকে যদি ওরা স্টেটা না থাকে তাহলে ওরা উচ্ছেদের ডিগ্রি পেয়ে আপনাদের উচ্ছেদ করে দেবেন, ওরা তখন প্রপার্টিটা পেয়ে যাবেন। তখন যখন ওরা প্রপার্টিটা দেবেন ওখানে অন্য কাউকে ভাড়া দেবেন, তখন তো নেসেসারিলি রেসিডেন্সিয়াল পারপাসের জন্য নাও দিতে পারেন, তখন ওরা কমার্শিয়াল পারপাসের জন্য দিতে পারেন। ওই এলাকাটা বিবেকানন্দ রোডের যে এলাকাটা, গিরিশ পার্ক এলাকাটা আপনি বলছেন, ওখানে প্রচুর দোকান আছে, ওটা কমার্শিয়ালি এক্সপ্লয়েটেবল। আমাদের টেস্ট হচ্ছে আপনার অকুপেশন চার্জ ফিক্স করার জন্য। আজকে যদি স্টেটা না দিতাম আমরা, এভিকশন ডিক্রিটা যদি আপনাদের এভিক্ট করে দিতে পারতেন ওরা, তাহলে ওনারা ওইটা অন্যদের ভাড়া দিয়ে কত পেতে পারতেন। সেই অন্যদের ভাড়া দিয়ে কত পেতে পারতেনটা শুধু রেসিডেন্সিয়ালি ফিক্স নয়, কমার্শিয়ালি ওরা দিতে পারেন। কাজে আপনাদের কি পারপাসে দিয়েছেন বা আপনার কত ভাড়া ছিল এটা একদম ইনমেটেরিয়াল।
আবার এখানে 21 নম্বর পেজটাই দেখুন মাই লর্ড, ওনারা বলেছেন দ্যাট দ্য লাইসেন্সি ফিস শ্যাল বি ইনক্রিজ 10% আফটার এভরি 5 ইয়ার্স।
তার সঙ্গে কোনো সম্পর্ক নেই। মুশকিলটা কোথায় জানেন, আপনারা নিজেরা মামলা করেন। আপনার এরম অবস্থা নয় যে আপনি লিগাল এড সার্ভিসের থ্রু দিয়ে আসছেন, কারণ আপনাকে আমরা প্রথম দিনই অপশন দিয়েছিলাম। আপনারা এবার যদি মামলা করেন তাহলে আপনাকে আইনটা জানতে হবে, তাহলে কোর্টের 1 ঘন্টা নষ্ট হবে আপনাকে আইনটা বোঝাতে। এটা খুব প্রবলেম আমাদের পক্ষে। আমি আপনাকে ফ্র্যাঙ্কলি বলছি, আপনার নিজের মামলা করার সাহস ডেফিনেটলি আমরা প্রশংসা করছি, কিন্তু সাহস থাকলেই হয় না, কোর্টের টাইমেরও একটা দাম আছে, কারণ অন্যরা বসে আছে তাদের মামলা, লয়াররা বসে আছেন তো আলাদা কথা, অন্য লিটিগ্যান্টরা ওয়েট করছে। আপনাকে যদি আমাকে প্রতি পদক্ষেপে আইন বোঝাতে হয় ম্যাডাম, তাহলে আমার পক্ষে এভাবে কিন্তু বিচার করা সম্ভব নয় আমাদের পক্ষে। প্রতিটা আইন আপনাকে বোঝাতে হচ্ছে, আপনি বেসিক আইন যে জানেন না, আপনি কেন কোনো উকিলের পরামর্শ নিচ্ছেন না? এটা বেসিক, এগুলো এগুলো দিয়ে আমরা এখন আপনাকে আইন শেখাতে, আমরা তো লয়ের ক্লাস করছি না এখানে। এটা তো আপনাকে বুঝতে হবে। আপনার যদি দুস্থ অবস্থার জন্য আপনি করতেন,
হ্যাঁ
আমরা
মাই
কিছু
লর্ড,
বলতাম।
ওটাও তো আছেই মাই লর্ড, আমি তো একটা কন্ট্রাকচুয়াল সার্ভিস করি, আমার অ্যাক্সিডেন্টের জন্য আমি মাইনেও পাচ্ছি না।
আপনার যদি সেটা হয়, আমরা লিগাল এড দিয়ে ভালো অ্যাডভোকেট আপনাকে দিচ্ছি, আপনি নিন, তাতে কোনো অসুবিধা নেই।
আচ্ছা, আসলে
সেটা
মাই
আমরা
লর্ড।
ব্যবস্থা করে দিতে পারবো, স্টেট লিগাল সার্ভিসকে আমরা ডিরেকশন দিতে পারি আপনাকে অ্যাডভোকেট।
আচ্ছা আচ্ছা
কিন্তু আপনি যদি
আচ্ছা
নিজে মামলা করেন, আপনাকে ম্যাডাম আইনটা জানতে হবে।
আচ্ছা।
অনেক জাজমেন্ট আছে সুপ্রিম কোর্টে যেগুলো আপনি জানেন না। এখন আপনাকে, আপনি প্রতি পদক্ষেপে আপনার নিজের এগ্রিমেন্টের উপর রিলাই করছেন। বুঝতে পারছি, একজন লেম্যান হিসেবে আপনি সেটা করতে পারেন, কিন্তু এটা তো কোর্টে মামলা হচ্ছে। আমরা তো আপনাকে প্রতি পদক্ষেপে আইন বোঝাতে পারবো না। আর আপনাকে যেভাবে ক্ল্যারিটি নিয়ে বুঝিয়েছি আমি, এর বেশি কেউ বোঝাতে পারবেন বলে মনে হয় না। আপনাকে তো পরিষ্কার বলে দিলাম, আপনার এগ্রিমেন্টে রেসিডেন্সিয়াল, আপনার এগ্রিমেন্টে কত ভাড়া, 10%, এটা ইমমেটেরিয়াল এখানে। এখন আপনি হেরে গেছেন, ওরা এভিকশন ডিক্রি পেতে এন্টাইটল, সেটা আমরা স্টে করছি। আমরা স্টে করছি, তার বদলে ওদের কম্পেনসেট করতে হয়, এটা হচ্ছে আইন। কম্পেনসেশনটা কিভাবে নিরিখে, কোন নিরিখে বিচার হয়? আজকে দাঁড়িয়ে যদি এভিকশনটা ওরা পেয়ে যেত, স্টেটা না থাকতো, তাহলে কত টাকা ওরা আর্ন করতে পারতো ওই প্রপার্টিটা থেকে। এই যে আর্ন করতে পারতো, সেটা ওরা কমার্শিয়ালি দিতে পারতো। সেই জন্য ওইখানে বেস্ট কি প্রাইস পেতে পারে, মার্কেট রেন্ট কি চলছে, সেটা আমাদের টেস্ট, একমাত্র টেস্ট। আপনার এগ্রিমেন্টের সঙ্গে কোনো সম্পর্ক নেই। যদি আপনি অন্য এগ্রিমেন্ট দেখাতে পারেন যে রিসেন্টলি ওই পাশের ঘরে কারেন্টলি কোনো ভাড়া দিয়েছে কম টাকায়, সেগুলো রেলেভেন্ট হবে,
হ্যাঁ, সেগুলো আছে,
সেগুলো দেখান।
সেগুলো
আপনার
আছে।
এগ্রিমেন্ট ভুলে যান, সেটা আপনার অপোজিশনে আপনি কোথায় দেখিয়েছেন, আপনার রিপ্লাই আপনি কোথায় দেখিয়েছেন, সেইগুলো আমাদের দেখান। যে আজকে দাঁড়িয়ে রিসেন্টলি কোনো ভাড়া দিয়েছে কেউ কম
হ্যাঁ,
পয়সা,
612 টাকায়
সেইগুলো
কেউ
দেখান।
ভাড়া দিয়েছে।
সেইটা হচ্ছে
হ্যাঁ,
অনলি টেস্ট। আজকে রিপ্লাইটা যেটা ফাইল করলো সেটা কি এটা? অর্ডার ফর 27 রিপ্লাই। ক্যান 2 এর রিপ্লাই ফাইল করেছেন তো আজকে।
ক্যান 2 তো প্রথমে
ক্যান
ছিল,
2 তে স্টে।
হ্যাঁ তারপরে ক্যান 3 তে আমাদের যেহেতু ডকুমেন্ট গুলো লোয়ার কোর্টে জমা পড়েনি, অল
ক্যান
কোর্ট
3 টা তো আমরা ডাইরেক্ট করেছি অ্যাপিলের সঙ্গে শুনানি হওয়ার জন্য, মূল অ্যাপিলের সঙ্গে। সেটা তো আগের দিন আপনার সামনে আপনার প্রেজেন্সেই হলো। ক্যান 3 এর এখন শুনানি হচ্ছে না, সেটা অ্যাপিলের সঙ্গে শুনানি হবে। এখন ক্যান 2 এর শুনানি হচ্ছে, ওটা স্টে। তা আপনি ক্যান 2 এর অপোজিশনে লিখেছেন কেন অ্যান অ্যাপ্লিকেশন আন্ডার অর্ডার ফর 27? এটা তো স্টে।
অপোজিশন মানে এফিডেভিট ইন অপোজিশনটা দিয়েছেন, তার রিপ্লাই
এফিডেভিট
আমি
ইন
দিয়েছি।
অপোজিশনে কোথাও ওরা লেখেননি অর্ডার ফর 27। ওটা ক্যান 2 বলেছেন, তার এফিডেভিট ইন অপোজিশন বলেছেন। আপনি আপনার ক্যান 2 তে তো এন্টায়ারলি মিসলিড হয়ে যাচ্ছে আমরা। ক্যান 2 অফ 2025 বলে তার নিচে লিখেছেন অ্যাপ্লিকেশন আন্ডার অর্ডার ফর 27।
তার নিচের লাইনে লেখা রয়েছে এফিডেভিট ইন অপোজিশনের রিপ্লাই।
কোথায় আপনাকে ডকুমেন্টটা দেখান?
ওই তো স্যার নিচের লাইনটাতেই, মানে ওইটারই
ঠিক আছে, ওটা
নিচের line।
বুঝেছি। কোন কোন এগ্রিমেন্ট আছে, কোথায় অ্যানেক্স করেছেন যে কারেন্টলি ওখানে কম ভাড়া দেওয়া আছে?
এখানটা আছে, এই অর্ডারের মধ্যেই আছে। 612 টাকা গোপাল দাস যে সাক্ষী দিয়েছে তার মধ্যেই আছে, আমি দেখাচ্ছি।
612 টাকা সাক্ষী দিয়েছে মানে?
মানে উইটনেস, লোয়ার কোর্টে যে উইটনেস যিনি দিয়েছেন গোপাল দাস বা সুজিত নাথ, তাদের ভাড়াগুলো এখানে তোলা রয়েছে অর্ডারের মধ্যে, যেটা ডিক্রি হয়েছে 8/10/2000।
কোন সালে ভাড়া দিয়েছেন তারা?
তারা এখনো ভাড়া দিচ্ছে এখন,
কোন সালে তাদের এগ্রিমেন্টটা দেওয়া হয়েছিল টেনেন্সিটা?
5 বছর,
কোন সালে তাদের এগ্রিমেন্ট করা হয়েছিল?
5 ইয়ার্স এগো হবে।
কোন সালে?
আজকে থেকে 5 বছর আগে।
গুনুন কোন সাল, গুনে বলুন।
18 সালে।
আজ থেকে 5 বছর আগে 18 হয়?
18, 19, 20, 21, 22, 23, 24।
কোথায় এগ্রিমেন্টের কপি? আপনার এফিডেভিটে তো কিছুই অ্যানেক্স করেননি আপনি।
না, আমি এগ্রিমেন্ট অ্যানেক্স করেছি মাই লর্ড।
না, আপনার রিপ্লাই এখানে রয়েছে, কোনো এগ্রিমেন্ট নেই।
আমার এগ্রিমেন্ট ভলিউম 1 এ
তা আপনার এগ্রিমেন্ট এখনকার ওখানে ওই জায়গাটায় অন্য কাউকে ভাড়া দেওয়া হয়েছে কম টাকায়, সেটা দেখাতে হবে। এখন তো আমরা 2025 সালের মে মাসে রয়েছি। এই বছরে বা অ্যাটলিস্ট কয়েক মাস আগে কোথাও ভাড়া দেওয়া হয়েছে, অন্য কেউ ভাড়া দিয়েছেন ওই বিল্ডিং এ অথবা তার আশপাশের বিল্ডিং এ, সেটা দেখান।
গোপাল দাস 612 টাকা ভাড়া দিয়েছে।
কি গোপাল দাস 612 টাকা একই কথা বলেছেন, কোথায় আছে সেটা? নিজে মামলা করলে আন্ডিও অ্যাডভান্টেজ নেওয়া যায়, এই ধারণাটাই ভেঙে দেওয়া যায়।
লিখেছি আমি গোপাল দাস।
সরি, আপনি কিছুই অ্যানেক্স করেননি আপনার ডকুমেন্ট। আমরা ওদের ডকুমেন্ট থেকে দেখতে পাচ্ছি ওখানে ওখানে ভাড়ার একটা ওরা দিয়েছেন, ওরা একটা অ্যাসেসমেন্ট দিয়েছেন। আমরা সেটা ভিত্তিতেই আমরা অকুপেশন চার্জ ঠিক করছি। একটা রিপোর্ট দিয়েছেন ওরা ইয়ের চার্টার্ড ইঞ্জিনিয়ারে।
হ্যাঁ, ওই রিপোর্টটাতে সবটাতেই বলেছেন আওয়ার ক্লায়েন্ট বলেছেন, আওয়ার ক্লায়েন্ট বলেছেন, এইভাবে
হ্যাঁ, ওদের ক্লায়েন্ট, ওরাই তো
হ্যাঁ,
অ্যাপয়েন্ট করেছে, সেই জন্য ওদের ক্লায়েন্ট।
হ্যাঁ ওনাদের
কিন্তু তার
client
বেসিসটা
বলেছেন
রয়েছে যে ওখানকার লোকাল ভ্যালুয়েশন।
এখানে 40 ছিল। 40
মাই লর্ড, আমাকে তাহলে কি একটা নেক্সট ডেট দেওয়া হবে যাতে
কিন্তু
লিগ্যাল
আপনার স্টে
এডের সাথে
অ্যাপ্লিকেশনটা আমরা স্টে অর্ডারটা ভেকেট করে দেবো।
স্টে অর্ডার
আপনি স্টে এনজয় করে যাবেন আর দিনের পর দিন এভাবে টাইম নেবেন, এটা দেবো না।
না মাই লর্ড, আমার
সরি।
স্টে এটা করে দিলে, কারণ একটাই রুম, আমার মা আর আমি দুজনেই থাকি, ঘর পুরো ভ্যাকেট হয়ে গেলে আমরা যাব কোথায় মাই লর্ড? আমি তাহলে একটা লিগ্যাল হেডের জন্য একটা শর্ট টাইম বা একটা কিছু করে দিন, লিগ্যাল হেডের অ্যাডভোকেটের আমি সাহায্য নিচ্ছি।
ঠিক আছে।
আমাকে তুলে দেওয়ার জন্য এইভাবে মারছে দেখুন।
হয় আপনি আর্গুই করুন, না আপনার মেয়ে আর্গুই করবে। ঠিক আছে, স্টে আমরা ভেকেট করছি না, আপনি কত তাড়াতাড়ি সেটা করতে।
একটা কথা বলছি মাই লর্ড, একটা ঘর নিয়ে দুটো কেস করেছেন ওনারা, যে ড্রয়িংটা দিয়েছেন দেখুন 1634 আর 23 মানে 1634টা
আমরা
স্টে
মূল
আছে।
অ্যাপিলটা তো পেন্ডিং আছে, মূল অ্যাপিলে সবকিছু দেখবো, কিন্তু এখন আপনার অকুপেশন চার্জ করার জন্য তো আমরা আমাদের ইমিডিয়েটলি স্টেটার জন্য আমরা দেখছি।
হ্যাঁ মাই লর্ড, আর একটা ঘর নিয়ে দুটো করেছে, আবার 9/6 আরেকটা ওরকমই অর্ডার আছে, যাতে পুলিশ হেল্প করে আমাদের ঘর থেকে বের করে দেবে।
আমরা তো সেটা স্টে করে রেখেছি।
না, আবার আরেকটা
অন্য মামলা।
হ্যাঁ আরেকটা, দুটো মামলা,
My lord has appeal is pending. My lord has refused to grant any stay.
that my lord has dismissed this statement.
সেটাতে স্টে আমরা ডিসমিস করেছি সেই জন্য সেটাতে হয়ে যাবে।
না মাই লর্ড, ওটা আছে, ওটা এখনো 66 টাইটেল এক্সিকিউশন 66 অফ
আপনি কত তাড়াতাড়ি
2024।
অ্যাপয়েন্ট করতে পারবেন আপনার?
আমাকে একটা টাইম দিন, আমি করে নিচ্ছি, কিন্তু আমার ওই
আমাদের এক
6।
সপ্তাহ বাদে ছুটি পড়ছে, গরমের ছুটি।
আচ্ছা, তাহলে গরমের ছুটির পরেই আমি উকিল আমি লিগাল এটের সাথে আজকে গিয়ে একবার কথা বলে নেবোক্ষণ।
আমরা আমাদের অর্ডারের মধ্যে ঢুকিয়ে দিচ্ছি যে আপনাকে লিগ্যাল স্টেট লিগ্যাল সার্ভিসেস অথরিটিকে,
ঠিক
হাইকোর্ট লিগ্যাল সার্ভিসেস অথরিটির অফিস আছে, খোঁজ নিয়ে
ঠিক
আপনি
আছে,
যাবেন।
ঠিক আছে
আমাদের
মাই
অর্ডারে
লর্ড।
আমরা ঢুকিয়ে
হ্যাঁ মাই লর্ড, ওই 9/6 আর একটা যে অর্ডার আছে
9/6 হয়ে গেছে ওটা।
মাই লর্ড, ওটা যদি হয়ে যায় মাই লর্ড, তাহলে ওটাতেও আমরা
ওটা
উচ্ছেদ হয়ে
এই
যাব।
মামলার প্রতিপাদ্য বিষয় নয়।
এখানেই আছে, আমার স্টে পিটিশনেই লেখা রয়েছে মাই লর্ড। এবং
এই মামলার প্রতিপাদ্য বিষয় নয় ওটা।
কিন্তু
এই অ্যাপিলটা 9/6 বিরুদ্ধে আপনি করেননি, এই অ্যাপিলটা করেছেন অন্য একটা প্রেমিসেসের বিরুদ্ধে।
কিন্তু আমার ওখানে
আমি এটাতে আমরা ওটা দেখতেই পারি না।
স্টে
আমরা
পিটিশন
এখানে বসে আপনাদের বিরুদ্ধে যা যা মামলা আছে পরস্পরের মধ্যে সব নাম,
এই যে এখানে
হয় আপনি
ছবিতে
বলুন না
দেখুন।
আমি বলি, আপনি শেষ করে নিন তারপর আমি
আসলে
বলি।
মাই লর্ড, একটাতেই উচ্ছেদ হয়ে গেলে তো পুরোটাই উচ্ছেদ হয়ে যাব, ওই জন্যই তো ভয় লাগে।
করার
এই
নেই,
যে
যদি আপনার স্টে
একটাই
রিফিউজ করে
ঘর,
থাকি উচ্ছেদ হয়ে যাবেন।
এই যে একটাই আমাদের ঘর, সেই
বুঝলাম।
ঘরটাকেই দুটো করে পার্ট করে করেছেন ওনারা। যে
The petitioner appearing in person and through her daughter is unable to assist the court properly, despite repeated opportunities being given. Full stop, next para. It is understandable, since the ladies before us are not legal professionals and we completely sympathize with them. Full stop. However, it is not possible for this court to carry on hearing the matter without the appellants having minimum acumen of law, which would unnecessarily waste litigants' time. Full stop. Thus, since the petitioner's daughter submits that they are in some financial constraints in appointing advocates, we direct the Calcutta High Court Legal Services Authorities, as and when approached by the appellant and Stoker or her daughter, to immediately provide competent legal assistance for the purpose of conducting the appeal on behalf of the appellant. Full stop. The High Court Legal Services Authorities shall act on the basis of the communication of this order, coupled with a server copy of this order for the purpose of compliance. Full stop. On the prayer of the petitioner, appearing in person and through her daughter, we adjourn the application till আমরা জুনের
9/6 এই যে এই ঘরটাতে ওনারা
জুনের
নিয়ে
16
নেবেন।
তারিখে আমরা এটা রাখছি মামলাটা।
জুনের 16 তারিখ, তাহলে মাই লর্ড
June
9/6 এই ঘরটা
16, 2025, when it will be listed under the same heading. Parameter.
কুড়ি একুশ বাইশ কুড়িটাই আমাদের 20-21-22
For some of the respondents, Mr. Mukherjee.
How the respondent?
Yes, Your Lordship. Mr. Mukherjee.
I beg to appear, my lord, on behalf of one of the appellants.
Yes, Mr.
I'm praying, my lord, kindly take up these matters next week. I'm
Next
trying
week.
to have a settlement.
May I, my lord, only make one small submission? My lord, your lordship had asked us to explore the possibility of settlement. Now, my lord, proposals have been exchanged. We have, my lord, given a counter proposal to the proposal that came from Mr. Mukherjee's client. Well, they have not responded to it. My lord, if
I'm
your lordship
trying
direct-
to find out a response.
trying
Will
to
you
find
take up
out-
next week?
Very well, I leave it to your lordship. My lord, I can't say anything over Mr. Mukherjee.
On the prayer of
এই,
the
তুমি আমার সঙ্গে কথা বলো না।
I will now.
on the prayer of learned senior counsel appearing for the appellant, let the matter stand adjourned till on the prayer of learned senior counsel for the appellant in FAT 170 of 2025, the matter is adjourned till next when Mr. Mukherjee, next Wednesday,
Which Wednesday, anything, any day you can.
Tuesday, then any difference? Very well. Adjourned till May 20, 2025, when it will be listed under the same heading. Number 20th May, Mr. Mukherjee. Yes.
Grateful lordship. এই
Thank
শাহ,
you.
আমার সঙ্গে কথা বলো না রেলবনে।
I will talk to Mr. Mukherjee.
Next Tuesday,
21, 21 and 22
22,
same order.
21, 22.
Yes.
Same. Very
Three matters.
very 20 to 22 তাহলে তাহলে 21 and 22 or 20 to 22
20 to 22.
20 to 22 very good matters
Three matters.
plural yeah yes
Fee loss, appearing of the dependent appellant loss.
Yes.
That I'm for the response. Suit for eviction. Suit was decree ex parte.
What is the delay?
Delay loss I can too.
What is the delay?
Illness. Delay.
What is the delay illness?
Period of delay loss is 184 days.
What illness?
Lost acute gynecology and demeritation of the bones.
Where is the certificate?
Yes, annexed certificate. Can one.
You have been looking after the case on behalf of both the appellants.
Two appellants. One is 78 years old.
You have been looking after the case for both the
Yes.
appellants.
Yes.
Yes. What do you say? We find from the annexures to the application for condonation of delay that the averments made in the application, comma, to the effect that the delay in filing the appeal was occasioned due to the serious ailments, comma, including acute gynecological problems and bone deformities being suffered by the appellant number 2, comma, who has been conducting the case on behalf of both the appellants all along, comma, we are satisfied that such averments have been substantiated. Accordingly, sufficient cause has been shown by the appellants for occasioning the delay in preferring the appeal. Hence, can 1 of 2025 is allowed, comma, thereby condoning the delay in preferring FAT 184 of 2025, the appeal be deemed to stand registered and admitted. What are the other applications?
Can 2 is the stay application.
Appeal arising out of?
Eviction suit. At the time of, I do not know the execution case, but subsequently I came to know the execution was filed. His number was 112 of 2024.
What is the numbering, total number? Ejectment execution?
Title execution number.
This is city court?
Yes, city court.
This is not numbered as ejectment execution? Title execution?
Title execution.
Title execution number? 112 of?
112 of 2024.
24?
24.
Which court? Which bench?
Bench lordship.
Or should you just
it is now registered.
So before the city civil court will do. Yes, what do you say to this?
Normally, when you are
occupation charge has to be. So you have to file affidavit disclosing what is.
Yes, my lord, that is what I have.
We'll direct you to do that and we'll grant a limited.
Yes, naturally.
The present appeal has been preferred against a judgment and decree of eviction. Full stop. Since questions of fact as well as law are involved, comma, we are of the opinion that a prima facie case for grant of stay has been made out. Full stop. However, comma, it will be open to the respondents to argue on the quantum of occupation charges which should be imposed as a condition of such grant of stay. Full stop. Next para. Accordingly, all further proceedings in title execution case number 112 of 2024 pending in the city civil court at Calcutta, comma, filed in respect of the judgment and decree impugned in the present appeal, comma, shall remain stayed till disposal of the application. Full stop. The respondents shall file their affidavit in opposition within June 13, 2025, thereby disclosing relevant material for assessing the occupation charges. Full stop. Reply, if any, thereto shall be filed within a week thereafter. Within June 20, 2025, the application shall next be listed for hearing on June 23, 2025.
I'm grateful,
The
Madam.
affidavit of service filed today be kept on. The application যেখানে বললাম ওটা can 2 of 2025 shall be listed for hearing.
But item number 24, my lord, I appear on behalf of the defendant appellant, my lord. A suit for declaration of title and injunction was filed on behalf of the plaintiff number 1. Claiming that the land in question has been transferred in favor of the defendant 2, it has been obtained on the basis of fraud, and the subsequent transfer in favor of on behalf of my
You are
client.
related, Mr. Ghosh. The clients are related, plaintiff and the defendants.
No, they are not related, my lord. They have transferred the property in my name, my lord. They filed the suit.
Sale deed.
Sale deed. Suit for declaration. My lord, we took a specific point, my lord. This suit is barred under section 31 because this type of suit has to be avoided by filing an application under section 31 for cancellation of the deed.
Oh, they sought a decree of declaration that it is not binding.
Binding.
But he was an executive. He was the
executant of the deed. And my lord, the learned judge has said that since this is a void document, it is not this is not necessary.
Fraud has been found in their favor.
Fraud has been found in my favor. And now, my lord, your lordship knows the Supreme Court judgment, my lord, when the person is executant of a deed, he has to avoid the sale under section 31.
So you are seeking injunction now?
Injunction not to transfer alien because they are trying to transfer alien, my lord.
This is appealing for the first time?
First time, my lord.
The present appeal arises out of judgment and decree whereby the suit filed by the plaintiff stroke respondent number 1
yes
inter alia for declaration that a sale deed purportedly executed by the plaintiff in favor of the defendants is void and not binding on the plaintiff, comma, being tainted by fraud. Learned counsel appearing for the appellant's contents that the suit was palpably barred by law since under section 31 of the Specific Relief Act 1963, comma, in a case where the executant himself or herself challenges the veracity of a document, comma, which if allowed to stand, comma, would adversely affect the interests of the plaintiff, comma, the appropriate suit is a suit for cancellation of the document upon payment of appropriate court fees and not a suit merely seeking a declaration that the said document is not binding. Full stop. The appeal ought to be heard on the above question and the other grounds taken in the memorandum of appeal. Full stop. Thus, we find a strong prima facie case for injunction having been made out. Full stop. From the averments in the injunction application, we also find that the balance of convenience and inconvenience is in favor of grant of injunction, comma, more so since in the event the suit property is dealt with before hearing the appeal, comma, the appellants may suffer irreparable injury. Accordingly, the respondent number 1, only one. The plaintiff stroke respondent number 1 shall remain, plaintiff stroke respondent number 1 and or his men and agents shall remain restrained from changing the nature and character of the suit property as well as from transferring, selling, alienating and or encumbering the suit property in favor of third parties in any manner till disposal of the application. You have also asked for possession.
Possession, my lord.
Possession we are not because it's doubtful.
Doubtful.
Till disposal of the application. First of the appellant shall serve a copy of the application on the plaintiff stroke respondent number 1 indicating that the application shall next be listed on June 10, 2025 when an affidavit of service to that effect shall be filed by the appellant. Full stop. Service on the pro forma respondents is dispensed with for the present.
I am grateful.
Thank you.
Matter 25, I'm for the appellant. I'm paying not to the only.
Why?
Firstly, Mr. Torman Mukherjee was lastly, your lordship. He is in the midst of argument court number 6. That is the whole problem.
You're granting adjourn. On the prayer of the appellants, them at least adjourn for the day.
Much obliged.
Thank you. Yes.
But it was this matter was heard
yes,
last occasion. Your lordship was minded, my lord, not to admit the appeal because, my lord, it was a appeal from an order of remand arising out of a partition decree. So, my lord, the first appellate court was of the opinion that it should go back to the trial court, not for a rehearing, my lord, and they will also be, my lord, permitted, my lord, to amend their plaint, and, my lord, the matter will be heard afresh.
The suit was dismissed. Their suit was dismissed.
Lordship.
For non-joinder, just please give me-
Non-joinder and, my lord, as well as, my lord, there are 3 points.
Section
Exception to the
34, hit by section 34.
Your suit was for the
Suit for partition.
Oh, because the covered of person was not free.
Yes,
that is not required, Your Lordship, in a suit for when he has not been able to
If
prove
Mr.
ouster.
Mukherjee can keep a straight face throughout his arguments on this in support of his client without laughing, without smiling, then we'll grant him the pay.
Difficult. I surrender. Other point was, Lord, that the plaintiff claimed to have purchased 99 decimal by demarcation and therefore there is no scope of partition. That was another point. 3 points.
One was non-joinder of whom?
One was, not the non-joinder of the common vendor of due to not the subsequent transfers. The other was not the in the absence of prayer for a recovery of possession, Lord, the suit is hid by proviso to section 34.
Yes.
And third was, Lord, because, Lord, they purchased, Lord, a demarcated portion of 99 decimal, so there was no scope of a partition. So these are the 3 reasons for which,
But
Lord,
this is between the owners of the demarcated portion.
Lordship. So, Lord, this was the reason for which, Lord, page 6, 7, and 8 of the trial court, Lord, and thereafter it went up in appeal. The appeal court at page 8 and 9, Lord, that was not the appeal court's, Lord, the version. It remanded.
Remanded, granting them an opportunity.
Lord, also to file and amend, Lord, amended copy of the plaint.
By joining the adding the parties.
No,
or seeking recovery of person.
No, Lord. Kindly have a look at, Lord,
Yes,
the page 8 and 9 of the appeal court. Lord,
yes.
That is about the middle portion. It is a specific case of the respondent that they are in possession of the entire land and the same is established in the local inspection. The absence of recovery of possession or depositing of the court fee for the purpose force the court below in dismissing the suit. In this reference, not such and such. Heard the argument advanced by both sides and the admitted part remained that Induwala Ghosh is the owner of such and such. But then not the entire title, derivation and everything has been discussed. Then, Lord, the first appellate court, the court below admitting the existence of both the deeds of the parties but failed to ascertain the fact of co-shareship. The suit land as sold is a defined and demarcated portion. There is no need to include the co-sharers of the land exceeding 1.51 acres of land. The defendant by a later deed obtained the left portion of the land as it is available. The judgment such and such is not maintainable here as the court ought to offer the plaintiff to establish their possession. The court ought to offer the plaintiff to establish their possession. The court may not try to make out a third-party case by traveling beyond a schedule. It is the duty of the court below to give proper scope to the parties, if necessary by way of amendment or survey of cause schedule or the prayer of the party with an eye of proper adjudication of justice. Accordingly, the judgment is set aside and it is equally not the trial court and the appeal court are equally
Right. It's a competition sort of thing. We can
file the cross appeal.
No, we, order 41 rule 33 will employ order 41 rule 33 of the code of civil. 33, not 22.
So,
can pass a further degree or other degree or modify the degree or do whatever.
No, what I'm submitting, Your Lordship, the trial court, everything he held in my favor. That I have 99 decimal, my deed was prior, and he had only 52. He can't purchase more than what is left.
Yes.
But the court held, Your Lordship, the trial court after holding the court also disallowed his ouster. He claimed ouster and adverse possession. That was disallowed by the trial court. No appeal preferred. And Your Lordship will see
what the trial court, on what ground the trial court? The first ground was that it was defective because necessary party, that is the common vendor, was not completed. Number one.
The common vendor is a necessary party according to you also.
No,
Why do you
because
say that?
it's a suit for partition, your lordship. This person who are having shares at the present moment, previously who had the ownership is not required. The present share co-owners are implemented in a partition suit. Present
By you obtained title by virtue of deeds executed by some of the co-sharers, original co-sharers.
Plot number 1207 is 8.42 acres.
8.42,
Of
yes.
which, my lord, co-schedule is 1 acre 51 decimal.
That is
And co-1 is out of that particular plot 99 decimal. The question
It's a
is,
demarcated portion.
yes, this is a demarcated.
All the co-owners sold.
No.
No.
Your lordship, what happened? One Induwala Ghosh was the owner of
8.42.
She, by a deed of gift, the market portion she gifted to her nephew, Amulya Ratan Mahapatro.
That is co.
The co-schedule. And
so demarcated portion was gifted by the original owner.
yes,
Amulya Ratan
got
sold
it
this
by-
property to you.
No,
to
he sold to me.
Saroj Kumar Rai. in
No,
1960.
he sold to me 99 decimal of that
Yes.
1.5.
That 99 decimal was not demarcated.
No, it was the boundaries were given, length and breadth was not given.
Very well. Then not partitioned.
Not partition. Because
you want-
he was left with 52 decimals.
Your subject property is the entire property of your vendor. 1 acre, that cost schedule property.
99 decimals. Because that is my share in 1.51 acre.
In 1.51 acre,
99 decimal.
99 decimal was not partitioned out, not
But
carved
yes,
out.
because length and breadth was not. The
The
area.
length and breadth was not there, then it could only confer title regarding a share of the portion of the
Yes, yes.
So
that is
therefore, you are seeking partition now.
partition.
If you seek partition, how can you confine yourself to 0.99 decimal?
Because that is my share.
99 was culled out from 1 acre, 1.51 without a partition.
No, I have stated, cost schedule, I have stated that 1.51 acres.
Cost schedule property is an intact property.
Yes.
It's a demarcated property. No doubt on that.
Yes.
Cost schedule is 1.51.
Yes, yes,
Out of that, 99 decimals were sold to you.
yes.
This 99 decimals, is that demarcated and cut out from the 1.51?
No.
Then
because
you have to
a
seek
boundary
partition.
was given. Boundary was given. So your lordship will kindly visualize this. It's 1.51 acres, 99. 3 sides boundary is okay, but one side he was having some property. So land of the vendor was
So
written.
you said demarcated 99 decimal was given to you.
Yes, but not by length and breadth. That was the difficulty arose.
Not by length and breadth means?
Means what is the length from
It's
north to
stated on the
south?
northern part 99 decimal.
Yes,
Then-
northern part.
Then how can it be defined?
Yes, that is.
Then you have to seek partition of the entire cost schedule property.
Yes, I'm 1.51. I'm seeking partition of that.
That was the first question we asked you, Mr. Srivastava.
Cost
Whether you are
schedule-
seeking partition for cost schedule property 1.51.
Yes.
You started with no.
No.
You have to seek cost schedule entire partition.
Yes.
So
Cost schedule
you
is
say your vendors need not be implicated. Common vendor.
common vendors, because at the present moment the owners.
Amulya Ratan has given cost schedule to some people.
Yes, to 99 decimal to me and the balance to him.
To Mr. Mukherjee's client.
Same person.
So you are the only necessary parties.
No, the plaintiff and the defendants are the necessary because they are at present the
You means
co-owner.
plaintiff and the defendants are the necessary parties.
Yes.
You are the necessary parties. You means you and him.
Yes. But the court said no.
Plaintiffs and defendants are generally the necessary parties in a suit, Mr. Srivastava.
And the court held that Amulya Ratan is to be implemented as a party. But your lordship in the
Amulya Ratan has sold his.
he sold everything.
Very good.
Now he is dead also, because that is on evidence. The defendant has stated he is dead.
In any event, Amulya Ratan need not be proved. So
and-
you say that this that non-joinder is a non-issue.
Yes.
Non-joinder should not have been
In a partition suit.
recovery of possession, section 34. So is not applicable.
In partition suit, it's not.
And what about this third point, demarcated portion, which Mr. Mukherjee is saying?
But that is not portion was sold to me. It was stated the boundaries were given. That on north it is this land.
Yes, no,
south-
no. What is the point on which it has been remanded? If the suit land is sold, is that divide?
Only the point, Lord, that is at page 9. It is the duty of the court below to give proper scope to the parties, if necessary, by way of amendment.
That is okay.
And
But
survey
before
of co-scheduled property.
Before that, it has been held the court bill admitting the existence, he failed to ascertain the fact of co-sharership. The suit land as sold is a defined and demarcated portion.
That is
There
that
no-
99 decimal, because they purchased, my lord, 99 decimal with a butted and bounded. The learned judge said that, trial judge said that it is almost partition.
So now it's an open remand. Now
Open
what?
remand. The trial court's order is set aside. It is open remand. It will be tried, my lord, after, my lord, taking of evidence, if they choose to file, my lord, an amended plain.
Amended plain for what purpose? That's not clear.
But that is why you have amendment, survey of the cause schedule on the prayer of the party with the idea of proper adjudication of justice.
What is this remand? We should set aside this order, the judgment of remand also. And we should replace it by our own order.
Yes.
Mr. Mukherjee, just satisfy us on this. Non-jointed cannot be held to be.
Lord, I tell you, Lordship, Lord, the entire property was, my lord, 8.42 acres. Lord, if we go by a partition of a plot is not the only one unit, Lord, that is, Lord, we can find out. Until unless, Lord, it is demarcated by a bata. Now, Lord, when, Lord, a co-sharers of, Lord, a particular, Lord, a larger plot seeks a partition, Lord, they are seeking partition in respect of 1.51 acres. So, Lord, the balance amount out of 8.42 acres, Lord, those owners are not arranged as a party, although they will be affected by, Lord, a partition.
8.42, Mr. Mukherjee was initially owned by a single lady.
Lord, I am, Lord, the plot number. I am going by 1207 plot
Yes.
number. Out of that larger plot, Lord, that belonged to Indubala.
Indubala was the sole owner of that.
Indubala, out of that 8 point, yes.
0.99, sorry, 1 acre, 1.51 acre, that was demarcated and sold to all of you.
No, Lord, that was not demarcated. It was gifted to Amulya Ratan, sister's son, in the year 1967.
Achha, 1.51 was a part of
8 point, Lord.
Obviously, it was a part of 8.
Yes. But here is only one plot involved. I mean the plot number.
No, even that gift did not sell did not transfer a demarcated portion.
No.
We have to see the gift deed schedule.
Yes. Indubala থেকে অমূল্য রতন। Then, Lord, Lord, in the meantime, Lord, let my learned friend, Lord, take it out. Then, Lord, Amulya Ratan, out of that, Lord, 1.51, Lord, he sold, Lord, 99 decimal to my learned friend in the northern part.
Without exactly
So,
defining.
Lord, there is another, Lord, the deed which requires, Lord, an interpretation.
No, have you taken a defense that it was demarcated and no partitions utilized? You cannot say that.
I did not. Because, Lord, there is another twist to the tale, because it was also my case that I also purchased another portion of, Lord, the larger property by preemption.
Very good.
That was in
You
respect of
cannot take that
1.31.
Preemption on the ground of co-sharership.
Yes. Yes.
Then you cannot take that one.
Yes.
So 1.51 acre has to be partitioned, Mr. Mukherjee. It's a common property. The question is whether the other co-sharers of 1.51 of that plot are required to be added.
Necessary parties or not.
So the court must have been not the common vendors, but the co-sharers of the vendor. Even if
Court
that
is
be so-
concerned about the vendors, but my contention is, Lord, that if the owners
All
of the
co-sharers.
yes,
All
otherwise
co-sharers
they
of
will
the
be
plot.
affected by the decree.
So that will presently ascertain by looking into this
The deed
gift
that
deed
whether,
schedule,
Lord, it gives a specific,
whether
Lord,
there is a
amount.
scope of doubt even. So that is on non-joiner. Prayer for recovery of coercion, no case. And this, what about this demarcated portion? That is related to the first point, probably.
Lordship.
Because 1.51, if that was demarcated in the first place, then nobody else is required to be added. So we can modify this order and clarify also.
map না থাকলে জীবনে তুই ভাষা দিয়ে ওটা demarcation হবে।
Then it's not demarcated.
8.42 is a very large tract, out of which 1.51 is a fraction of it.
Gift deed schedule is here.
Gift deed is similar.
Whatever schedule or whatever is annexed here, or you have got a copy? No
we have
schedule
got-
also.
No, it does have a schedule. Lord, finding out from that, Lord, is a handwritten, Lord, the certified copy. But all that we are trying to find out whether there is a map annexed to this deed or not, so that, Lord, we can find out whether it is a demarcated.
Then it has been remanded. It has to be ascertained by the trial judge as to whether this was a demarcated, by virtue of this gift deed, a demarcated portion was given to you. Consequential to that, the trial court will also decide whether somebody else is required to be implicated. Because if it is not a demarcated portion, then other co-sharers of the plot better copy.
Yes.
If it is not demarcated, other co-sharers of the plot have to be implicated. We can direct the trial court to give you an opportunity to do that. Implicate the co-owners if it is found that it was not demarcated.
If it is found.
First issue which will be decided by the trial court is whether by virtue of this gift deed in respect of co-scheduled property 1.51 acre, a demarcated portion was gifted to Amulya Ratan. First issue.
Yes.
If it is decided in the positive that it was a demarcated portion, then automatically, consequentially, trial court will also decide the issue of non-joinder. If it is demarcated, nobody else is required to be joined. If it is not demarcated, other co-sharers of the plot, as Mr. Mukherjee said, they have to be joined. If that is the finding of the trial court, we will get an opportunity. The trial court will give you a time-bound opportunity to implement those
Because
parts.
the trial court did not advert to that.
We'll clarify this in our order. That's why you are putting it.
Also clarify that in a partition suit, no declaration is required.
No, recovery portion, yes.
Recovery of possession is not required because he has pleaded ouster, which he has failed to prove. Once that is done, he has failed to prove.
Since an open remand, it has been sent on open remand, we are not reopening that. Ouster, we are not going to. We are saying that in a partition suit, recovery portion is not. Section 34 bar does not apply.
Yes.
Section 34 has to be on the frame of the suit.
Yes.
Justice Bose's order is there, or judgment
The
is
date of filing
on the plaint. Yes, on the plaint. Very well.
And we have filed a cross objection, Your Lordship.
We will dispose of lock, stock, cross, barrel, everything.
Pillow file করেছেন? না, আপনি cross
Cross objection. Cross objection on what? We will confuse ourselves. Leave it. Mr. Mukherjee and Mr. Srivastava, please take your seats. Just correct us if we go wrong on the facts or something. We'll be.
But
We'll
if
make
your lordship requests dates, I can give only the dates of the.
We'll not go
deeds.
into so much detail
Very-
deliberately
very-
because that will bind the courts.
Lordship.
Yes.
Lordship.
The present appeal has been preferred against a judgment and order of remand. Full stop. The genesis of the litigation is a partition suit filed by the plaintiff stroke respondent number 1. Full stop. The learned trial judge dismissed the suit on several grounds. Full stop. The salient grounds were colon দিয়ে নিচে Roman 1, non-joinder of the common vendors of the plaintiffs, Roman 2, bar under the proviso to section 34 of the specific relief act due to no prayer for recovery of possession having been made, Roman 3.
And declaration, Your Lordship, the court
Oh,
trial.
declaration also?
Yes.
How can it be a section 30? Achha. Recovery of possession as well as declaration of title. Declaration of title. Roman 3 হচ্ছে as to whether the co-scheduled property, comma, out of which the co-1 schedule gifted property of the plaintiff was culled out, comma, was a demarcated property. Full stop. Next para. Learned senior counsel appearing for the appellant contends that the appellate, Mr. Mukherjee, we forgot your original contention. So we have to place something in your mouth.
Not yes, not I was challenging the order, not this order of not the open remand by saying that the appeal court not could have adverted to not
Itself.
with not the materials available before it.
Could have itself adjudicated.
Yes.
Learned senior counsel appearing for the appellant contends that the appellate court itself could, under order 41 rule 24 of the Code of Civil Procedure, decided all issues involved in the litigation in the appeal itself, since all the relevant materials and evidence were already on record. Full stop. Next para. In support of the cross objection, learned counsel appearing for the plaintiff respondent number 1 argues that in a partition suit, the prayers for declaration of title and recovery of possession need not be separately sought. Full stop. That apart, it is argued that a demarcated portion was gifted by Indubala, the original owner of the property, being plot number 1207, comprised of 8.42 acres, to Amulya Ratan, comprised of the co-scheduled property. Full stop. Next para. Upon hearing learned counsel for the parties, we find that there was confusion galore in the minds of the learned trial judge. Full stop. Next para. It is evident, now it is right law that in a suit for partition, the prayer for declaration of title stroke shares of the parties is implicit, and as such, no separate relief of declaration of title is required to be sought. Full stop. In any event, the bar incorporated in the proviso to section 34 of the Specific Relief Act does not contemplate a suit of the present nature. Full stop. Insofar as recovery of possession is concerned, in a partition suit, there are two stages. Full stop. First, by a preliminary decree, the trial court is required to declare the respective shares of the parties, and at the second level, a partition commissioner is appointed and submits a report by allotting different portions of the property as per the shares of the parties. Full stop. Upon the partition commissioner's report being accepted and a final decree being passed, the earmarked and demarcated portions of each of the parties are allocated. Full stop. As such, no further recovery of possession is required to be paid. Full stop. Next para. Moreover, it is well settled that a suit has to be adjudicated vis-a-vis the bar under section 34, proviso of the Specific Relief Act, in the form in which it is framed. Full stop. As framed, the present suit is one for partition, and as such, no further relief of declaration of title or recovery of possession could have been or ought to have been paid. Full stop. Hence, the learned trial judge erred in law in holding so, and the learned appellate judge, to that extent, was justified in setting aside the impugned judgment and degree of the trial court and sending the matter on remand. Full stop. Next para. The other two issues involved in the suit, two primary issues involved in the suit are interconnected. Full stop. Next para. It is required to be ascertained as to whether Indubala, who was the exclusive owner of plot number 1207, comprised of 8.42 acres, gifted a demarcated portion of the said property to the extent of 1 acre 51 decimals, comprised of the co-scheduled property to Amulya Ratan. Full stop. The trial court, while adjudicating the matter on remand, has, accordingly, to decide on the materials available on record as to whether a demarcated portion of plot number 1207 was gifted to Amulya Ratan. Full stop. The next issue is connected therewith, comma, insofar as whether the suit was bad for non-joinder of the other co-sharers of plot number 1207 is concerned. Full stop. In the event the learned trial judge, comma, upon consideration of evidence and rehearing the parties, comma, arrives at a conclusion that by virtue of the gift deed in favor of Amulya Ratan, comma, the original owner Indubala donated a demarcated portion of plot number 1207 in respect of the cost schedule property, comma, the obvious answer to the next issue would be that the suit is not bad for non-joinder of necessary parties, comma, since there would arise no question of the rest of the plot number 1207 apart from cost schedule property being joint and there being other co-owners. Full stop. Next para. On the contrary, comma, in the event the learned trial judge arrives at the finding upon consideration of the materials that by virtue of the gift deed executed by Indubala to Amulya Ratan, comma, the cost schedule property which was so gifted was not a demarcated portion of plot number 1207, comma, in such event, comma, the other co-owners in respect of 8.42 acres of plot number 1207 would be necessary parties to the suit. Full stop. Hence, comma, we modify the impugned judgment of the first appellate court to the following effect: colon, 1, the learned trial judge shall, comma, on the materials already on records, but upon giving fresh opportunity of hearing to the parties, comma, re-adjudicate as to whether the subject matter of the gift deed by Indubala to Amulya Ratan, comma, comprised of the cost schedule property of 1 acre 51 decimals was comma, a demarcated and well-defined property was gifted to Amulya Ratan. Full stop. 2, in the event, consequentially, comma, the learned trial judge shall also decide whether the suit is bad for non-joinder of necessary parties, that is, the other co-owners in respect of plot number 1207. Full stop. Next para. In the event the trial court comes to the finding that by the gift deed of Indubala to Amulya Ratan, comma, a demarcated portion in the cost schedule property was gifted to Amulya Ratan, comma, the issue as to non-joinder would be answered in the negative. Full stop. However, comma, in the event a contrary finding is arrived at by the learned trial judge to the effect that the property gifted to Amulya Ratan comprised of the cost schedule property was not specifically demarcated, comma, the learned trial judge shall give an opportunity, a time-bound opportunity to the plaintiffs, stroke respondent number 1, to implead the other co-sharers, stroke co-owners of the 8.42 acres comprised of plot number 1207. Full stop. Next para. Insofar as the finding of the learned trial judge as to the suit being bad for the plaintiff having not incorporated the reliefs of declaration of title and recovery of possession, comma, we affirm the finding of the learned trial judge and observe that such finding of the learned trial judge was clearly erroneous in law and cannot be sustained, and such finding is hereby set aside. Full stop. Next para. The learned trial judge shall rehear the matter in the light of the above observations and dispose of the suit after remand as expeditiously as possible, comma, preferably within the what will be a reasonable period, 8 months.
Maybe a year.
1 year.
Because
Kindly fix it.
because
Date
I
for
do not know,
appearance of
Lord,
the
whether
party.
there will be amendment of the plaint or the written statement.
Yes,
I do
yes.
not
If
know.
you are permitted to add new parties, then it will take 1 year.
We do
1
not-
year. Preferably within 1 year from the date of communication of this judgment to the trial court. আচ্ছা যেখানটাই কোলন ড্যাশ দিয়ে পয়েন্ট গুলো শুরু করলাম না এই লাস্ট যে 1 2 3 4 করে বললাম যে আমি তো 1 2 3 4 বলে বললাম 1 এ যান 1 এর আগে যান 1 এর আগে লাস্ট
লিবার্টি নিতে হবে অ্যামেন্ডমেন্ট আপনি নিলে আমার
না লাস্টে তো 1 2 3 4 করে বললাম না
এটা পেড করতে
একটা কি আছে বলুন
একটা পেড করে দিয়ে দাও।
হ্যাঁ ওইখানে বলছি তার আগে সেন্টেন্স কি আছে একের আগে কোলনের আগে কি বলেছি কোলনের সেন্টেন্সটাই বলছি কি বলেছি না হেন্স উই hence FMA number such and such is disposed of by modifying the impugned judgment and order of the learned first appellate court.
TOT, your lordship. TOT.
We will say that. We'll say that. Being judgment and order, being the judgment and order dated April 4, 2023, passed by the learned additional district judge, fast track court Roman 1, Paschim Medinipur, district Paschim Medinipur, in title appeal number 23 of 2011 to the following effect. বলে তারপর judge. Last line সবকিছু হয়ে যাওয়ার পর COT, what is the COT number, Mr. Srivastava?
77 of 2025. Yeah, your lordship.
Is it in our list today?
No, it's not. Kindly take it on the list.
Acha, COT such and such, COT 77 of 2025 is treated to be on the days list and disposed of in the light of the above observations. No rest to cost. Any application is pending. Can 1 was pending. Apart from can 1, any other application is pending?
No, Lord. No.
Can 1 of 2024 stands disposed of accordingly as well.
Amendment.
We are keeping a copy of this one.
Yes, on the record.
COT
Your
that will.
lordship, may I submit? Give me liberty to, if required, we'll ask for amendment.
But both the parties then, Lord, if it is required.
I mean,
Now, Lord, why we say this? Because, Lord, after, Lord, the factual finding by the learned trial judge, Lord, we do not know where it comes. If it is necessary, Lord, there might be a, Lord, a requirement of, Lord, amendment of the pleadings by both the parties.
Addition of party, your lordship has given me liberty. But
COT যেখানে dispose of বলে লাস্ট যেখানে 4টা বললাম লাস্ট যে পয়েন্ট হলো তারপর একটা পয়েন্ট করে দিন if required the learned trial judge shall grant both stroke either of the parties opportunity to amend their respective pleadings in the suit.
Great.
kindly fix a date for appearance of the party.
No.
Demanded
We don't know the roster of the court, Mr. Srivastava. We have said 1 year from the date of communication, communicate this judgment.
No, but the date is this week, 16th of.
This week it cannot be done. Don't think so. If you can communicate, you can, because this will be on the server latest by tomorrow.
Yeah.
Our judgment. So if you can do it, you can do it. Communicate.
Your lordship, I'll hand over 2 copies or one.
One copy. একটা লাইন অ্যাড করে দেবেন ওখানে the copy of the cross objection filed today be kept on record. This is the cross objection?
Yes.
Yes.
Because to get out of the limitation, I have to come with the cross up.
Yes.
একটা ডকুমেন্ট
কিন্তু জাজমেন্ট ফরম্যাটে করবেন হ্যাঁ হ্যাপি
লুজ কপি but I'll take back, Lord, the copy of the deed.
Yes, deed ফেরত দিন ওনাদের দিন নীলাঞ্জন ভট্টাচার্য দিকে দিন
নিলে তো দেখে না কোনটা আছে
না কিছু বলিনি উপরে on consent of parties. Mr. Mukherjee, we are adding a line at the top on consent of parties, appeal and the cross objection taken up for hearing along with the application.
Smile.
You're adding that.
এটা নিয়ে নিলাম।
Thank you. ঠিক আছে, গিফট ডিড দেখুন দিয়েছেন ফার্স্টে কত
Lordship,
20 oh, you're happy.
Lordship, plaintiff is an appellant before your Lordship.
Right.
The suit was allowed in favor of the plaintiff. First appeal,
Reverse.
no demand, set aside the degree,
We said reversed.
reversed,
Yes.
but not remanded back.
Not remand. No.
My lord,
So the suit was for declaration of title.
title, interest, right title and interest of 1/3 share of the plot.
Only that without praying for partition.
No, there is no prayer for partition. Two plots are
Very well.
scheduled plot.
And you sought for injunction also.
Yes.
So why did the appeal court reverse it? Set aside?
They barred by provision of Land Reforms Act. It is a case of correction of record of right.
Where is the plaint? Have you annexed the plaint?
Plaint, my lord, it is only memo.
No, in the stay application have you annexed the plaint?
No, I have not filed any stay application. No execution has been filed, that's why.
You have filed an application for stay of operation. Can one is that? We need to look at the plaint to understand what is the prayer.
My prayer was, I am entitled
Unless we look at the relief sought in the plaint, how do we know whether the court was correct in saying that it is barred by section 51?
Appeal court held.
Appeal court held that the suit is barred. Barred by section 51 must be of the West Bengal Land Reforms Act. 51C. If that is the finding of the trial court, if you expect us to admit the appeal court, if you expect us to admit the appeal, we have to look at the reliefs, whether your suit is actually barred by section 51. Where are the reliefs? Where do you find the reliefs in the plaint? You don't even carry a copy of the plaint when you move the matter. How did you draft the memo? At least the plaint we are entitled to see.
The plaintiff's prayer was considered by the trial court.
The appeal court found your suit is barred by a particular provision of law.
Since
whether it is barred, how can we decide? We have to look at the reliefs sought in the plaint.
Yes, sir.
Only from the reliefs can we ascertain whether that relief is barred by any law. You have not got a copy of the plaint.
With a copy of
Search properly. Must be somewhere.
Not.
ডিগ্রিটা দেখে ট্রায়াল করে ডিগ্রিটা দেখে ডিগ্রি ট্রায়াল করতে ডিগ্রি করেছিল এই ডিগ্রিটাই চেয়েছিল তেমন এই রিলেটিভ চেয়েছিল show us that finding of the appeal court.
Yes. Page, inner page 13, Lordship. The last paragraph. This suit is specifically barred under section 51C of West Bengal Land Reforms Act, which provides that no civil court shall entertain any suit or application concerning any land if it relates to alteration of any entity. A record of right, my lord, my share should be 1/3. That was not. On this ground, and counterclaim was partition.
Their counterclaim?
My lord, that was rejected by the trial court.
Why rejected?
Since all plots are not joined in that,
partition suit is maintainable in respect of joint plot.
In counterclaim, only 2 plots of land they have.
All the plots were not. So you are not. Acha, what is this section 5 application is allowed?
That is your lordship query was on the last occasion.
You filed the appeal along with the section 5 application.
That is not. In first appeal, within time appeal was filed. No section.
So what is this observation at page 17? Hence petition under section 5 of limit.
I inquired. No section 5 has been filed.
Why does the court say hence the petition under section 5 limitation act
on
is allowed?
I inquired. My lord, no section 5 application has been filed. Appeal was filed within time by the respondent.
চেনেন নাকি আপনি জজকে? এখন তো চেনেন না বলবেন এসব জায়গা তাহলে ওই পয়েন্টটা অ্যাডমিট করতে কেন না যদি ডিক্লারেশন অফ রাইট প্রিন্সিপাল রিলিফ হয় তাহলে তো সুট বার্ড বাই সেকশন ফ্রিকোয়েন্সি হচ্ছে The present second appeal will be heard on the following substantial question of law. Whether the learned first appellate court committed a patent legal error, committed a substantial legal error in holding that the suit filed by the plaintiff stroke appellants is barred by section 51 within bracket C of the West Bengal Land Reforms Act 1955, comma, in view of the principal relief in the suit being declaration of the plaintiff's title and share in the suit property and the relief regarding correction of records of right being only an ancillary relief, and because the appropriate authority under the 1955 Act does not have the jurisdiction or the authority or the power to grant the principal relief sought in the suit. You have asked for stay of operation of the judgment and decree.
My lord, execution has not been filed, that's why I have not sought the copy of that stay.
Execution, how could it be filed?
2 plots of land are involved there.
Your suit was decreed. Appeal court set it aside.
Right.
So what is the question of execution?
Well,
What will you execute? You can execute the judgment date.
well,
But
there is
not
no
the
scope,
decree.
there is no scope.
No scope. We will pass the usual directions. I mean.
My lord.
Allowed on contest. রিভাইভ করে যাবে আর যদি স্টেটা স্টে অফ অপারেশন ডিক্রিটা রিভাইভ করে যাবে তাহলে আনডিউ অ্যাডভান্টেজ পেয়ে যাবে করা যাবে Can 1 of 2022 is an application for stay of operation of the impugned judgment of the first appellate court, which of however, comma, in the event stay of operation of the said judgment, comma, whereby the trial court's decree was set aside, comma, is granted, comma, it would tantamount to allowing the appeal before hearing the same on merits, comma, since in such event, comma, the trial court apostrophe's decree in favor of the appellants would revive. Full stop. Next para. Accordingly, we dispose of Can 1 of 2022 without granting any stay, but directing the appellants to put in due requisites for service of notice of the appeal on the respondents. Full stop. Next para. On the respondents within a week from date. Full stop. The trial court records shall be brought by special messenger at the cost of the appellants, comma, also to be deposited within a week. Can I deposit with me?
Right.
So next para. The appellants shall prepare and file the requisite number of informal paper books without comparing with the records within 6 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants, whose of liberty to the appellants to mention the appeal as and when the same is ready, comma, for inclusion in the list before the appropriate learned single judge having determination. Acha, can one of such and such is disposed of bollam? Is disposed of, if you dispose it of, then we have to direct you to serve notice. You are dismissing it. Is dismissed without any order as to cost. তারপরে কি কন্টিনিউ করেছিলাম thereby directing is disposed of by বলে কি বলেছিলাম no can such and such is disposed of বললাম যেখানে can 1 of 2020
dispose of Can 1 of 2022 without granting any stay, but directing the
আচ্ছা এই একটু চেঞ্জ করে দাও এটা accordingly we dismiss Can 1 of 2022 full stop. তারপর we direct the appellants to put in special messenger.
Give you already.
Thank you. Next.
My lord, before my lord takes up the next matter, my lord, we mentioned item 47. My lord had asked me
Yes,
to
yes.
come back at
47. What is the other? You're for the other?
47.
47.
Lord, I'm led by
47 টা
Mr.
call
Bachchan.
করুন ওটা।
This should be very short, my lord. Before your lordship is troubled with the order, I'll just
It
take
was
1 minute.
not mentioned that you are leading Mr. Mukhot.
No, my lord, he's competent enough to do it himself.
Yes, he is competent.
More than competent, my lord.
Yes.
Look, this is being action. It's being taken by your lordship now, or it will be taken up
Lord,
tomorrow?
affidavit of service.
Now.
Oh.
Photo.
But very short matter, ex parte order obtained against a auction by someone who did not participate and had no intention to
Let the
participate.
file just come.
I'm sorry.
47 চারটের সময় মেনশন করে লিবার্টি দিয়েছিল না সাইড করে রেখে
But may I just pray for one thing? We were somehow mistakenly, for sure, under the impression that we mentioned at 4 o'clock. I'm being led by Mr. S.N. Mukherjee. He's on legs. Could we do this? Could we come back tomorrow, my lord?
Couldn't have been under that impression. It was mentioned in presence of your.
Ami Jain. That's what I was under the mistaken impression. That's what I was told.
No, it was to be taken out of turn, Mr. Shah.
I perhaps did not understand, my lord. I thought, my lord, sir, if it's not taken in the usual course, to mention it at 4 o'clock.
What is the use of mentioning if then it would be mentioned tomorrow itself? It would be a futile exercise to mention it at 4 p.m. We mention and I say yes. It would in any event be in the list tomorrow. Mentioning means mentioning for being taken out of turn. That was the mentioning of Mr. Mukhopadhyay actually, to take it out of turn. We said if we can't reach it today, then mention at 4. Obviously, if you can't reach it means.
My prayer for not today because we have a leader in this matter.
It depends on Mr. Bachchan.
Monday,
But tomorrow we can keep it above the hearing matter.
Monday, my lord. That
Monday is very good, going to be very difficult.
the orders of 23rd of April.
Maybe.
No, that's true. Here, what can I?
Some extreme urgency was pleaded by.
I am also equally. Mr. Mukherjee is there. He's requested if it could be taken up on Monday. Otherwise, I'll do it now. From 23rd April, this order has been passed.
You have to tell me. Yes.
We are on the 14th of May.
Yes.
October
there's a little difficulty, in waiting till Monday, I wouldn't have come anyway.
Yes.
But very short matter, your lordship gives me 30 seconds on the facts and then comes to the order. I am a NBFC. I have given a loan to someone who is not a party to these proceedings. There's a default by him. He's declared a NPA. Now I intend to transfer the deposit. So, I advertise. I seek expressions of interest. EOI not publicly published, and in this case, your lordship will find we refer to the fact that this will be under a Swiss challenge method, which the Supreme Court recognizes as a very fair and transparent method. So, Swiss challenge method, it says please put in your expression of interest by 22nd of April. If you do, you will have access to all the documents. This advertisement comes out on 16th of April. My learned friend waits for the date to expire, does not participate. He claims he's an interested participant, does not participate, does not put in his expression of interest. On the 23rd, he files a suit. On the 24th, he obtains the ex parte injunction. Now,
who is he? The borrower?
No, borrower is not concerned. He says, I intended to participate in the auction.
What has he challenged in the suit? What is the prayer in the suit?
He's got an injunction, restraining me
from. What is the relief sought in the suit?
Yes, please take the plaint, it's incredible. Please come to. There is no cause of action in contract or tort. Please see the prayers at page 27. Notice that the tender that I've called for is bad.
So, sought for a mandatory injunction restraining the defendants.
Yes, from ever selling, and please see para 2 rather. He is an interested bidder. Interested bidder who did not participate. And one shocking thing I want to show your lordship. Please come to page 94. On the day when this expression of interest was floated by me, he takes a resolution on that date to challenge it. It shows he had no interest in participating. Please turn to page 94. He has annexed his resolution. certified true copy of the resolution passed by the board of directors of the plaintiff company. And please see, resolved the second resolution. Or first one, resolved that the company has been enlightened about the advertisement published. And then para 2, resolved that the company intends to appeal.
16th April was the deadline.
No, 16th was the day when the advertisement came out. On the same day, he passes the resolution. 22nd was the deadline.
Oh.
He had no intention to bid at all. 16th, my advertisement comes out. 16th, he takes a resolution.
Where is his best cause of action paragraph, Mr. Bachchan?
But he has none, according to me. There is no cause of action in contract. No.
Banerjee is also appearing with you, or on the other?
No, if this is
This Mr. Banerjee.
Yes. If this is straight,
I have no idea.
We have also put in a bid, in the and we are also agreed, we have filed an intervention application, so far as this matter is concerned. I am agreed, by the process, which it has been conducted.
Now, I tell you, Lordship, why there is no cause of
That's beyond the scope of this suit.
If the order either the order is confirmed or varied, I'll have a right.
Will prejudice the trial court regarding the intervention application.
He gets a fee regardless.
Fee, perhaps, is not the that I get regardless.
Prejudice the trial would pass such observations, Mr. Banerjee, that the trial court will be prejudiced when you take out that order 1 Rule 10 application. Because your claim is entirely beyond the scope of this suit. You have to file an independent suit. File it, but till then there will be no injunction.
May I just make one submission? Then, after that, it's him. On threat, I have to go away.
No, don't go away. Remain here. See what happens.
No, earn your fee by sitting.
I've made
He has.
Some people are lucky.
I'm told,
Some people are lucky.
Nowadays there are standing fees and sitting fees. Different.
It's the same.
He gets standing fees even if he sits. There's another matter. Well, a little while ago, I stood, I fought, no fee. He did nothing, and Melody gets a fee.
Already forgot.
No, now. But I've also argued.
What?
Just two submissions rather. Just two submissions. In this auction, I've also participated in this auction. I also put in a bid. I am agreed by the process also. I don't know if that's the agreement.
Let him file his suit. Let him file his
Let me just make my submission because I am told I found out.
Yes,
you are a participant in the bid.
Yes. Participant.
You are one of the bidders.
I'm one of the bidders. I am agreed with the question of the anchor bid. There's a process which has been followed there. Which I am agreed by.
Process of auction.
Process of auction. And just one thing, so far as this order is concerned, I'm told that's what I found out. There's a stay so far as the auction is concerned. So either way, I would be affected. I have an application which I have also filed. That's my submission for the present moment. Then if it comes up tomorrow, can decide on the fate of my application as well. If this appeal, that's my
yes, Mr. Bachchan, yes.
Correct. Now,
show
yes,
their best.
If your Lordship takes the plaint once,
yes, we are there.
May I just show your Lordship what is probably the apparent reason? Now, para 4 at page 19, I'll show your Lordship. Para 2 is he's an interested bidder. Para 2.
Swiss challenge method, I've forgotten. The reverse process. I mean, the
highest challenge is I select the seller. I select someone who puts in a bid.
Yes.
That is like the minimum bid.
Right.
Now, everyone puts in a bid. I inform that he has to go, and whoever goes beyond, he may match it.
Right.
And there also, I'm not obliged to accept the best bid.
All right.
Then, if your Lordship sees page 19, para 2, he says an interested bidder. I've showed your Lordship from his resolution, he wasn't. On the very same day, he said no. Para 4 is he says that the defendants are acting illegally, arbitrarily on extraneous considerations to assign the loan account. Now, he is not the borrower. Why should he be bothered? So, para 4 is not interesting. It shows who he may have been set up by. Then para 6, he says that the assignment is sought to be conferred or made is arbitrary, onerous, and in a manner devoid of transparency. Again, he can't be bothered by that. So these seem to indicate maybe it's someone behind it. Then para 7 onwards, he keeps on saying why it is wrong. He did not get sufficient time to decide. He didn't get sufficient time to look at the papers. But the point is, my lord, he was not entitled to it. He has to first put in his expression of interest, then only is he entitled to not get reached to any documents. That's the advertisement. If your lordship only sees that, not that's at page 33. This was my advertisement. Not very clear, but not if your lordship sees, not from the third para or not fourth para. Upon submission of the EOI, including annexures, the shortlisted eligible bidders would be allowed access to the bid process department and virtual data room containing further information for commencing. Oh, better copy. Oh, I see. Containing further information for commencing due diligence, etc. So he wasn't even entitled to the papers. Not this is the situation. So how can he not decide that everything I've done is wrong?
What is the reasoning of the impugned order?
None. Not please come to the impugned order. None. It says the petitioner's submissions are attractive.
2 pages.
Not, it says petitioner's submissions are attractive. That's what I'll show your lordship. Not page. Please come to the order, not which is right at the end, and or take the memorandum of appeal, my lord. And my lord, please see. But there is nothing. Not the closest to that. Not facts are set out. Those are all there, not copied from the plain petition.
Page, the second paragraph.
Second paragraph, not halfway down. Halfway down, not till then is submission. Petitioner states there is no disclosure, etc. The lordship comes to about 10 lines from the bottom, starting with mentioning several other irregularities and referring to the documents in support thereof. Petitioner has been able to make out a prima facie case in support of its claim. And
then we also have to see what are the irregularities.
Yes,
there.
so I'll take your lordship there. But is not stopped from giving effect thereto when the plaintiff as well as several other intending bidders may suffer irreparable loss and injury, especially when vide notice insufficient and unworkable deadline has been given to complete all the procedure. Now, he has not even attempted to get the papers. Maybe my procedure would have asked for nothing.
The date of your advertisement was 16th April.
Yes,
on which date
yes,
they took the
that's his
resolution to
case.
challenge it.
Yes. I'll show that to your lordship. ওর প্যারাটা দেখো 16 বলেছে না ও যেখানে বলেছে it was published on 16 সেটাই দেখছি কোথায় yes but para 2 and para 6 say that the notice was not 16th April. But it's incredible that on the same day he decides to challenge it. It shows he had no intention of participating at all. That itself is good enough not to knock it out. But in addition, 2 points. But obviously, he has no contract with me, so he has no cause of action in contract, and none in tort has been pleaded. But 2 other points: someone, Lord, who does not participate in a tender is not entitled to challenge it. Now that's the legal point. Lord, I'm fortified by judgment, but in a matter like this, it's pointless doing it. But he may say anything else about the manner of Lord, in which I floated tenders, but Lord, he has no right to challenge it. He has no locus at all, not having participated.
Pursuant to this notice, what has happened after this?
But after that, offers have come in. Lord, your lordship has seen it's been restrained. I can't go ahead with it. The injunction is preventing me. I've received several offers. 7 bids have come in.
You could have waited till tomorrow, Mr. Bachavat.
Not, I'm a creature of instruction. That's why I asked a few times. They've been apparently not trying to have it heard for a few days.
Let us hear Mr. Banerjee. Yes, sir.
But the way Mr. Bachavat argues, for a second, I thought I have no case at all. And I had nothing here. 2 aspects,
What seems Can I just take 1 minute and not just show your lordship one judgment on this?
Yeah.
Just that. Because obviously they intend to take it.
Yes.
Judgment Gulan. But number 1, but the Swiss challenge method, which is advertised, it has been held by the Supreme Court to be a transparent method. So his challenge on the ground of transparency, goes.
Arbitrary selection of anchor bidder.
The Swiss challenge is based on anchor bidder. There has to be one. There can't be Swiss challenge. 2009-7 to the. But 2009-7 SCC.
So for a Swiss
462.
challenge, for adopting this method,
Yes.
there has to be an arbitrary selection of a
Yes,
of an anchor.
yes, because he gives a price.
Obviously.
Now, my lord, please come to para 54. There's two other paras I'll show your lordship from there, but not the lordship comes to that first. Yes. My lord, if your lordship first comes to
54, yes.
54. Change. At the moment I'm trying to make it big, it's vanishing. Sorry. No, ठीक है, I've got it. But para 54. The Swiss challenge method is transparent transparent in as much as all parties were well aware of the right of first refusal accorded to the originator of the proposal. As per the method which was known to all the parties, the originator of the proposal must, in consideration of his vision and his initiative, be given to the benefit of matching the highest bid submitted. As pointed out earlier, the said method is beneficial to the government in as much as the government does not lose any revenue, as still getting the highest possible value. Now, there are two paras which indicate that this is adopted all over the place universally. Please take para 20 and 21. It was highlighted by the appellants that the Swiss challenge method is adopted in Chile, Costa Rica, Guam, US territory, Indonesia, Korea, Philippines, South Africa, not number of states, etc. set out. And then para 21, the application of the Swiss challenge method by MHADA is accused of being not fair and transparent. But the said contention raised by the respondent as well concluded in the impugned judgment cannot be relied upon, as the public notice clearly dated so-and-so clearly mentioned that said method and the scheme to be followed under it. We also mentioned the Swiss challenge. Moreover, in the said notice, the rule of right of first refusal to the originator of the proposal has also been discussed accordingly. Though the name of the originator may not have been mentioned, it was contended in the said public notice that it has received a suo motu proposal from a developer. This is a well-known, well-accepted method, but no one can accuse this method of being an unfair method. Yes, and we are private, we are private NBFCs. We are not even government NBFCs, government concerns. And then a judgment that a party who has not participated has no right to challenge the tender. 22 24 Swiss challenge method দরকার এটা দাও or you want to give the SEC anyone that
So Mukherjee is following the Russian roulette method. He's trying all the
2018 টাকা That's the one.
Yes.
But if your lordship sees this slightly longish judgment, but not if your lordship comes straight away to paragraph page para 20 at page 261. But 7 lines from the bottom. But if your lordship comes to para 20, last 7 lines from the bottom. Having failed to participate in the tender process, and more so, despite the express terms of its tender documents, validity whereof has not been challenged, a respondent can't be heard to contend it has acquired any right whatsoever. Only entities who participate in the tender process pursuant to a tender notice can be allowed to make grievances about non-fulfillment or breach of any of the terms and conditions of the tender documents. The respondent who chose to stay away from the tender process can't be heard to whittle down in any manner the rights of eligible bidders who participate in the tender process on the basis of written and express tender conditions. At the culmination of the tender process, the respondent had not participated in law after the offer submitted by eligible bidders is required to be considered on the basis of the stated terms. Thus, if the claim of the respondent was to be strictly adjudged on the basis of terms and conditions, specified in the subject tender condition, the respondent had no case whatsoever. But there are other judgments on it. But that's sufficient. But I think that it's good enough. There are no reasons at all. Not, and that too to justify. I'm not ex parte interim order. I'm not on that one line saying that the material shows sufficient. But let me not take it at worst. Let us say, Lord, everything is wrong. He still has no right to challenge. There's no locus standi at all.
My instructions are to just again renew my prayer if I could come back on Friday with Mr. Mukherjee here.
Friday we sit singly.
Oh, Your Lordship, that's right.
That is a difficult.
Tomorrow
Tomorrow is the only day you have. We take up appeal matters, hearing matters, but we can give precedence to this. But Friday we sit singly.
That's right. That's right.
And we have fixed matters on
Tomorrow, if Your Lordship could accommodate us sometime, Mr. Mukherjee is there. It will be slightly impertinent on my part too. If that otherwise does not disturb the.
Yes, Mr. Bachat will keep it up.
Anyway, this for 25
Tomorrow,
minutes, Your Lordship will give.
Lordship keeps it tomorrow, I'm sure.
Such a matter that we have to sit through for the evening for.
If it was to have been taken up longer, later I would have, my submissions would have probably been longer with 5 more judgments. Not necessary, not necessary.
On the same point, you need not multiply judgments.
Not doing so, not doing so.
Lordship would take that first.
That will be first. We'll fix it at as the first matter in the list, top matter in the list, but
shouldn't be done.
We'll fix it at 10:30, but will
shouldn't be done. Go to court for it.
I wish.
Hard learned senior counsel appearing for the appellants. Pushed up for further hearing, let the matter be listed tomorrow at the top of the list before the appeal hearing matters. এটা একদম উপরে দিয়ে দেবেন, টু বি মেনশনড গুলো থাকে তারপরেই দিয়ে দেবেন।
ওটা আমার
অর্ডার 41 রয়েছে না, আন্ডার দ্য হেডিং স্পেশালি ফিক্সড করে, স্পেশালি ফিক্সড করলে আন্ডার দ্য হেডিং স্পেশালি ফিক্সড ম্যাটার্স, টু বি মেনশনড এটা স্পেশালি ফিক্সড তারপর।
Very good. So far as my application is concerned, if I can get it on board, then we'll come and also.
You probably won't be able to. If you can give the number today, I mean.
It's not been, it's being filed, that's the difficulty.
যদি নাম্বারটা দেয়, যদি
we'll serve on them, and
যদি আনিয়ে দিতে পারে, তাহলে নাম্বার দিলে দিয়ে দেবেন কালকে। থ্যাংক ইউ। ডেকে নিন, আর তো 2 মিনিটে খেতে।
Leave to shots. If I can take leave, I'm told that's what my instruction. If I can take leave to file the
application,
because we are not parties to the appeal.
একটা লিভ দিয়ে দিন, টু ফাইল। লিভের জন্য যেন না আটকে যায়। Leave is granted to
subject to objection.
Of course. No, leave to file দিয়ে।
Leave to have an order. Create some complications.
Not leave to have any order.
Grateful.
Yes, have you got it? Item 70. Both of you have agreed.
Both of us agreed. We have given up.
Remuneration, you have got a.
That idea after the consulting the records. What I have to do. So that part, he said, Lordship can keep that.
We'll say that remuneration will be fixed later.
Name and details, everything.
এটা যে নিয়েছি মনে আছে তো? Thank you.